So let's start with our good friend Professor D.K. Ellumulai sir. He worked in the IGNOU. He was the director, founder director of the Distance Education and Law Center in IGNOU. He invited all of us many times, and sometimes he did not. But we have no grievances against him. We still are good friend. We consider. And sir would like to speak on human rights protection, promotion, and entitlements. Indian response to UN and UDHR initiatives. So thank you very much, sir, and over to you for 15 minutes is yours.
Thank you, sir. Good morning to all of you. With your chair's permission, I would like to present the paper by say here only from my
It's
laptop.
up to you, sir. Whatever.
Let me give a very brief background based on which I prepared this paper. In fact, as chairperson was telling that I was at IGNOU and heading the School of Law, and the Haryana Police Academy, Madhuban, they used to invite me. I was a visiting professor at Haryana Police Academy for a decade. So they used to invite me to interact with the newly recruited judges and police officers, sometimes middle-level officers, to discuss various aspects and dimensions of human rights. In the process, I had to read a lot on human rights issues, nationally as well as globally and all. Over a period of time, and while observing the subject, watching the subject very closely, one of the issues was disturbing me. Very often when the newspaper, the international institutions, into some countries making allegations against India about the violation of the human rights. Whereas I was reading a subject team following this very subject, I felt that such allegations are wrong, false, incorrect, vis-a-vis of ground real taking place in India. But simply saying this will not help us. So I thought, no, why can't we make a study? What the international instruments are saying on human rights on the one side, and what the action needs with the government of India on the other side, and comparing these two, where do we stand India? That was the idea came in mind. Incidentally, during the last 19 or 20 also, the Rajya Sabha invited some research application projects under the Rajya Sabha research scheme. So I submitted the proposal to the Rajya Sabha on this. Fortunately, several applications, Rajya Sabha approved my proposal on the comparative study. That is the background, and the project report has been submitted to the Rajya Sabha on December 2023. Now I thought the international seminar is coming, why can't we share this also with among the such a distinct auditions? This is the background with which I created this paper. Just a minute, please. So I will just wanted to share with you this what I did, and so just a minute. This is the background. Now let me get into the this what I'm going to what I'm going to present and all. Any study on human rights, if it has to be completed, one has to refer to the Magna Carta, 1215, signed by John King. That is the starting point for even the all legal ideologies, philosophies, even rules and rule of law, all those things. It emanates from the Magna Carta. That is rooted into this. That's a Magna. I'm not, because time is very. In my paper, discuss detailed about the Magna Carta, what are the object, purpose, and all those things. However, there are two classes are very important related to the human rights. That is class 39, class 40 of the Magna Carta deals exclude the human rights. Class 39 places the operation of the rule of law above all, including the king, as it prohibited interior seizure, imprisonment, dispossession, etc. of human being except by lawful judgment and law of the land. That is what the class related to the human rights. And the class 40 prohibited sale of human beings or delay of cost in the enjoyment of rights and denial of justice. So these are the Magna Carta, class 39, class 40 related to the human rights. The rest of the details are given in my paper. You may kindly go through this. Next one is the conceptual framework, very brief. We all know about the human rights. It's a common subject, but therefore I will not spend much time on those. And this, as you all know, human rights are applicable to the enjoyable to human beings, applicable to human beings only, regardless of caste, color, nationality, etc., as we find it and all. Then, what is the very briefly the human rights definition meaning also? Human rights are legal guarantees towards promotion and protection in rights of the individuals or groups also concerned. That is a basically entitlements conferred through the say legal framework only. If you come to the our this human rights 1993, there is a definition of human rights. I would like to refer there. That it talks about that human rights are the individual liberties, right to life, liberty, etc., and also international rights conferred the international conventions and enforceable by the court of law in India. That is what the definition. Three requirements are there in the human rights definition. Section 2D deals with the refers about the human rights definition. Then another thing I would like to know, we all know human rights is applicable to all human beings. I would like to extend it. Not only the human being, before birth and after death, it extends. That's the only point I would like to share with you. Before death refers to that, we have the sex law prohibiting sex determination. In fact, here I would like to two cases, this very briefly. In USA, a mother, pregnant mother, she used to consume a lot of liquor and cigarettes. Very common these days in India also. You'll find everybody saying this thing and all. So with the result, the child in the womb got infected with a serious disease and infirmities and all. Ultimately, when matter went to the court, the mother's justification was, I have a right to on myself, my own body, everything. So I don't find any violation of any law of the land or otherwise also. But with the court said that with respect to when we talk about the rights of the human rights from the date of conception till physical birth also, that is the extended. So therefore, if the right of the child in the womb is affected directly by the consumption of alcohol, cigarette, definitely this human right will prevail over all other rights of the mother's concern. That is the one judgment from US is concerned. And coming back to India and Bombay, one case where the parents, they want, in all in India, everybody prefers the male child. So they had a female child, that they wanted to go for a male child. So they go for it, then they gone to the doctor, they wanted that the sex determination. Actually, it is prohibited under the law and all. But they themselves wanted to terminate this pregnancy and all, this and all. Then again, their argument before the court was, we have a right to liberty under Article 21. Therefore, we have the right to determine whether we want the female child or a male child. That was so. Therefore, we have not committed any wrong or mistake. That was the argument they placed before the court. But the court said no. When again the same argument, if there is a conflict between the rights of the child in the womb vis-a-vis the rights of the parents, the rights of the child will prevail over the rights of the parents in relation to the human, as per the human right is concerned. So therefore, in this context, the human rights starts before the physical birth of the child is concerned. Similarly, just a minute, after the death, when the Punjab was boiling and all those things and all, there was a mass burials are taking place. The parents of the deceased, not the deceased, killed person, they approached the government that at least they wanted that the body should be given to them for doing the last rites. But that was not done. Why to talk of the Punjab the rights and all? Even during the COVID period, we know those who have died and all. Many of the bodies are not even shown to the family members. It was a huge encourage and all, because we are religious. We have the religious sentiments and all. So in this case, also when the matter went to the Punjab High Court, there the court declared that even the human rights extended beyond the death also. Therefore, they issued the direction to the concerned government that you should hand over the body to the concerned family members for the performance of the last rites. So this is what one aspect. It extends before birth and goes beyond the death also. That's the only point I wanted to add this. Just 1 minute, please. Then rest of the things I will not use. coming to the children, we have lost number of child-related loss. Child labor is there. Then child soldiers internationally is we know that even in our Jharkhand, our tribal areas, and where there is a Maoist and all there, the childs are, they say that's a big story. I don't want to go behind it, but child soldiers are prevalent in India as well as the international countries also. It's a violation of the human rights, child labor. Example only I'm giving, but the detailed discussion what type of child-related human rights are taking place. That's one, and also adult-related. Then after that, I said then falls up. If you take this different segment, child, women, senior citizens, disabled person, like with different sections of groups also, the human rights violations are taking place at large scale in India as well across the country. And similarly, there is an instrument when we come to the UN instruments and vis-a-vis the things are there. So what the point I would like to identify, no, just human rights violations take place at all levels. And the instruments are, UN instruments are there, very many. Indian instruments are all there, where we have discussed it very briefly. But it's practically speaking, violations are, but to what extent? That is the issue. Even with 130 crores of population, if you compare with the other countries' population and all, so you're very bound to, when the population is very high, large like our country, then so certain aberrations are likely to take place. But quoting single incident and telling that in India this is the violation, simply quoting one incident, Srinagar, and putting it for across the country, that was not good in my opinion, proper and all. Then that's about that. Then what I did in my paper was, I made a comparison between the Universal Declaration of Human Rights, provision 32 articles are there, UDHR, and our Constitution. What I found, almost all the human rights articles and the UDHR 32 are reflected in our Constitution, with the right from preamble to the fundamental duties. I'll just make it elaborately clear. Another thing to be kept in mind, there is a close relation between the United Nations, there's a drafting of the United Nations Charter with UDSR Charter and the Indian Constitution, the same period only. And India was one of the signatories to the United Nations Charter, first 26 countries. India was one among the 26 countries. So our development, constitutional development, and if you read the United Nations development, you will find a close proximity. Even one of the United Nations, in my paper, I have given the quoted how one of the members of our own country, they participated in the drafting of the United Nations Charter as well as the UDHR. They appreciated it also. What I am saying, close proximity between the drafting of the Indian Constitution, of course, Constitution has been and all, but if you read the provisions, I'll tell, we will find it close proximity. I'll just conclude by saying that all the 32 articles are reflected in our part 3, part 4, part 4A. Let me come to fundamental rights. Except Article 18, abolition of titles, and Article 27, all other fundamental rights are covered in the Universal Declaration of Human Rights, number 1. Number 2, with regard to the directments of state policy, except Article 4, that is this Uniform Civil Code, all other articles are reflected in the human rights, vis-a-vis also we can say. And the fundamental duties, Article 51A, G and K, related to the human rights. So what I would like to bring to your knowledge is, so our Constitution covered all the provisions of the Universal Declaration of Human Rights. That's what just I would like to share with you. Now, kindly, just my laptop is giving just give me a minute, please. Now, let me come to the United Nations Charter. Now, this is what the portion related to the India. Then I'll come to the United Nations Charter. United Nations Charter, again, we played a very dominant role. Then UDHR. Then coming, but if you study the international instruments, there are 18 international instruments related to the human rights. I cannot go read it and all, it's a very length and all. So therefore, that is one, find 18 instruments. This includes conventions, protocols, and treaties, all these 18 core instruments, core human rights instruments. Then, and against the core instruments, the United Nations there are 20 other minor instruments also human rights. That is one aspect. Then they have also identified the worked out, the mechanism is created under the each instruments. That is given in my tabular form, that if you get your paper, you can consider. That is one as findings. Then I just came to the found out. Then what are the human rights issue entitlements? That is also discussed in my paper. Entitlements, what is the rights available to the person but under a legal framework. It's what that is what the entitlement. There are 7 entitlements, and you will, if you read the Universal Declaration of Human Rights, there are 7 kinds of entitlement provided in the Universal Declaration of Human Rights. I just listed. Just kindly give a minute, please. Just a minute, please. I would like to read that one. 7 entitlements. It's getting off on and on. Just also one, the preamble versus preamble also. Just one while going back. Universal Human Rights preamble says human beings are born free and equal in dignity and rights. That is Article 1. In our preamble, that's Article 14. Just I wanted to give. That's how the comparison is made. Then coming back to the preamble versus preamble. That is also I would like to. Just a minute. Just please, just a minute, please. No, it is there. Entitlements, have we seen it? This is what human rights entitlements, and this is what the instruments identified. There are another issues. Just I'll come to the issues identified under the United Nations. There are over 50 human rights issues are identified under the UN Charter, UN instruments. But out of that, I have taken only 17 issues for comparison purpose. These are the human rights issues taken for the studies. 17 issues I have taken for our study comparison purpose. I just simply human rights to indigenous people and minorities, prevention of discrimination, rights of women, rights of the child, human rights to older persons, human rights to persons with disabilities, right to food, water, sanitation, environment, right to health, administrative justice. This is what the issues. And based on that, the human rights instruments are UN identified major instruments are human rights to indigenous people. I don't want to. There is a table is given in my paper giving all the human rights instruments international level. For all the 17 issues, the UN instruments are given in a tabular form. Then coming to the mechanism, yes, sir.
Just like
I'll take 2 minutes.
Time
only.
Is already
just 2 minutes. I'll just take 2 minutes only. Just allow me 2 minutes.
बोलो 2 मिनट 2 मिनट आप ऐड कर दीजिए.
No, I'll conclude. Now coming back to India, Indian Parliament has enacted over 40 legislations related to the human rights issues. Like we have the child laws. We all famous the Indian laws. We have so many child related laws enacted with the Parliament. Women related laws. We have the laws for the disabled persons, senior citizens. Apart from that, right to food. We have the right to food in 2013. Likewise, India has enacted over 40 legislation related to protection and promotion of human rights compared to that 18 instruments by the United Nations and all. And I concluded by saying that based on this comparison made the United Nations instruments of 18 versus the 40 legislation, India has done exceedingly well with regard to the protection, promotion of human rights is concerned. With this, let me thank you all of you, and I feel sorry for taking 2 minutes extra. This is not my percentage is concerned. Thank you very much, please. Thank you.
Thank you very much, Professor Elumalai, for a detailed, exhaustive journey of the human rights you have elaborated in your presentation. So let me request, I'm also very happy to share dice with my young colleague, Professor Anupam Jha, the professor in charge, LC2 Center, and also Treasurer, Indian Society of International Law. I welcome you, sir, on behalf of everyone here. And sir is going to co-chair the session. I request, sir, if you want to say some words, then I can summarize.
Should I go?
So back? What I'll do, if panelists agree, I'll just summarize also whatever has been said by each speaker. So we'll save time in that process. मुझे लगता है कि वाईफाई का यूजर नेम मिल गया, नहीं मिला? कोई बात. So all right. So I think it's very detailed. Your journey began with the Magna Carta. You ended with the United Nations. In your presentation, you have emphasized how parallelly, like United Nations drafting of UN Charter and in UDHR. So little bit like my colleague will agree that there was a gap between when drafting of the United Nations Charter took place. So it started actually from 1942, the first time
No, you
the
League of
term United in James
Mm,
Fort meeting where 22, 23 members they coined the word United Nation, and subsequently journey started. Finally culminated in the San Francisco Conference in April 1945. However, as you correctly pointed out, sir, that drafting of UDHR and and the meeting of the Constituent Assembly was parallel, were parallel. Uh, uh, Although we, I also tried to find out, and maybe Anupam Jha and other colleagues will correct, we did not notice anywhere we we have reached on the assumption, or that is correct also some way, because some of the members participated as a member of the Commission on Human Rights in drafting of the UDHR, and also she participated in the drafting. So some way the
yeah,
idea which shared there might have incorporated, but the Constituent Assembly draft nowhere mentioned ki the fundamental rights and directive principles of state policy have impact of the drafting of UDHR, but individuals impact as
yeah,
a
yeah.
human being might have been there. But we appreciate that you have mentioned about both the things the 30 articles of UDHR, which contains civil and political rights, economic, social and cultural rights, and most interestingly this is also an important where we start tracing the relationship between IPR and human rights under Article 27 of UDHR. So somebody says, is there any relationship? So we see from the Article 27 of the Universal Declaration of Human Rights, which talks about. In a sense, Universal Declaration of Human Rights is unique because it also talks about right to seek asylum, that is Article 14, which is not mentioned in any other human rights instrument, and right to property. Right to
Yeah,
property in not in any other human rights, but this is the UDHR under
yeah.
Article 17. We have a right to property as well reflected under the UDHR. When I come back to the Constitution, you have nicely elaborated. You said ki abolition of the title. So, if I see abolition of the title, which Professor Illumina you can elaborate, it's some kind of practice of discrimination.
Yeah, yeah.
And human rights, all human rights instrument based on the fundamental principles of non-discrimination.
Non-discrimination. Yes.
So whether the word abolition is there in the Constitution, it could have been easily addressed under the Article 15, paragraph 1,
Yeah.
but we have title and other things are so all discriminatory practices
Have been
addresses under the non-discrimination principle. But in the Constitution, it's clear cut mention, and that is the unique. I believe Article 27, I remember, that is more on the religious right, 25
Yes, yes,
to
yes.
27,
Yeah, 27.
and something on the related with the tax of the there. You have also spoke about the Article 23 and 24, that was like you hinted the provision against exploitation,
Yeah,
the two
that's-
article you have mentioned. And we have number of important judgments. You have also highlighted about the United Nations optional
Optional protocol.
no, not optional protocol, to the protocol 2 of the Convention on the Rights of the Child. There are two protocols which were adopted in the, which
No,
talks about the child
it is
soldiers.
mentioned.
That
It is
you have
covered in the
mentioned.
all the instruments are covered
So
in the
it's a
paper.
very good presentation, and I'm sure that we have limited number. Kanika is seriously heard you and other young scholars, limited participant, but it was very interesting to learn many things. And you also already circulated or promised to circulate
I'll
your
circulate,
paper
circulate it.
to the all the participants, and it will go. Kanika, you take note of when sir
Definitely.
gives it, you wider we can put with the permission of sir in the website also to for all the the very interesting. And I hope that when you submitted uh, your report to Rajya Sabha, Rajya Sabha
under
never
recess scheme.
dissolved. So Rajya Sabha never dissolved. It like members change. So I thought
No.
assembly was dissolved, but parliament was dissolved.
No,
So
no,
I
no,
can't say
no.
Rajya Sabha was dissolved, but the committee might have ended its function in the specific committee whom you. So we look forward for your report and other things, and we
Definitely.
wish you all the best for
Thank
the wonderful work after retirement you are doing, and that is the source of inspiration for person who are going to retire in 5 years, 10 years time, like all of us. So we take note of your dedication
No, thank you, sir.
and serious engagement with the academic activities, even if you are not associated, but you remain as an active academic scholar. Thank you
Okay,
very
thank
much,
you, sir.
Professor
Thank you.
Elumilai. Thank you.
Okay.
Big round of applause. थोड़ा जोर से तालियां बजाएं. तो मूविंग ऑन, हमारे पास नेपाल से आए हमारे परम मित्र श्री दिनेश त्रिपाठी जी, काठमांडू नेपाल से. और त्रिपाठी जी, आपका बहुत बहुत स्वागत है. हम और हमारे को चेयर करते हैं. आप क्या वुड लाइक इट टू पीपीटी और एक्सटेम्पो? सो अच्छा, पीपीटी नहीं है ना, दर कोई बात नहीं. एंड सर इज दी सर, यू प्रैक्टिस देयर, नो?
No, I am a senior advocate at
Senior
Supreme Court of
advocate.
Nepal.
Supreme Court of Nepal.
Yeah. So
And international human rights law in changing global context. And if I remember one thing in the unique in the constitution of the Nepal, which says in case of the conflict between the domestic law and international human rights law, international human rights law will prevail. And
Yeah.
that is the some way I heard, or like, you may correct me if I
Yeah.
wrong. But with this note, I would request sir to speak on the international human rights law in changing global context. And your time starts, sir. In front of you, you have timer. यहाँ 15 मिनट का वो है सर, आप देखते रहेंगे.
okay,
सामने
thank you
वो
so
घटता
much.
जाएगा. और
Thank you so much for inviting me. And we also listen the previous speaker. So you are living in a very difficult and interesting time in human history. As Charles Dickens says in his novel, Tale of Two Cities, this is the worst of the time and this is the best of the time. So this is also the best of the time and worst of the time for democracy, for human rights. Because on the one hand, there is a tremendous growth of international human rights law. There is a very robust provision in constitution about the human right. Even a large number of state constitution, it has been largely benefited by UDHR and international human right law provision. But there is a huge gulf between idealism of the constitution or idealism of the UDHR or idealism of international instrument of human right and the ground reality. So it's not functioning. And you are having a phenomena of only a formal democracy. So in the constitution is in paper and constitution is in operation is two different things. So there is a huge gulp. So like UDHR was drafted, and at that time, now there is a sea change in a global reality. When UDHR was written, the state was the major actors. So it was try to make accountable only to the state. We have to assert our right against the state actor. But look at, there is a tremendous growth of transnational companies, and transnational companies are more powerful even the state. They are the most powerful. There are other kind of non-state actor as well. So there is no such mechanism to control them, to assert our right against the transnational company, or to even for the state also it is very difficult to control and regulate transnational company. And there is a non-state actor like a terrorist, and there is all kind of illegal groups. So now look, the global reality has been changed. And when the UDHR was drafted, at that time there was no issue of climate change. Now the climate change has become it's like an existential threat for us. There is a huge crisis, and million people, they are losing their job, their livelihood, because of climate change, and there is a huge displacement of people, and there is a also called phenomena of development refugee. So look, the whole ground reality has been changed when the UN Charter was drafted. Under the UN Charter, there was Article 55 and 56, under which member states they have taken a pledge that they will protect and promote fundamental rights and fundamental freedoms, and they will take collective as well as individual action to protect and promote the human right. And the human right, the UN Charter is now the landmark document of international human right law. So all the after the UN Charter, the growth of international human right law was taking place. UDHR was drafted, and then international community recognized that it is a mere declaration. This is just a soft law. It is just only a source of inspiration, but there is no binding thing. So then there was two instruments simultaneously. It was drafted. The International Law Commission has entrusted to draft a binding document, but there was because there is a ideological differences. There was a Soviet camp and there is a American camp. So American, they think that human right means only civil and political right, and Soviet Union bloc, they think that human right means only economic and social right. But now there are 3-4 generations of human right. Now when we are talking about human right, it's not only civil and political right, it's also economic, social and cultural right. It also not only economic, social, cultural right, but now there is a right to development as well, and there is a right to environment also, a right to live in a healthy environment. So these are also right to participation is a 4th generation right. Right to inclusion, because nothing about us without us. If you are not allowed to have a meaningful participation in the governance process or stay in decision making process, it means that you are left out. So now you are having a democracy. Only there is a phenomena called procedural democracy. So in order to have effective implementation of human rights, we need a functioning democracy, a genuine democracy. The leaders who are directly accountable to their population, their voters. But you are facing the phenomena of formal democracy. Formal democracy means you can also say it is a procedural democracy. After there is a periodic election, there is adult franchise, there is all the formal institutions are there of democracy, but it lacks credibility, it lacks genuinity. So what happened is that some demagogues, populist agenda is there, and they are able to elect. And what they do, they dismantle the democratic institution, they dismantle the court, they dismantle other constitutional mechanism. So so this formal democracy doesn't protect the human right. So in the large number of if you see all over, it's like since it has been universalized that large number of states, they adopted in their constitution, their legal system, human right, international instrument, they have been directly domesticated through the constitution, through the legislation. But thing is that only the formal guarantee doesn't work. You need real genuine institution. Like in case of Nepal, Professor rightly mentioned that we have in our constitution, we say that we'll abide by international human right treaties and UN Charter. And not only that, we have a treaty act. It would say that if there is any conflict between international instrument which Nepal has ratified and domestic provision, then the international instrument will get primacy. And at that time, pre-constitution era, actually, there was we have a treaty act which also say that the same provision, that if there is a conflict between the treaty duly signed or international instrument of human rights, it has been signed, and if there is a conflict, then of course the international instrument will get primacy. So there is a one court case regarding women equality, like that citizenship right of women. So then court says that, okay, that time Nepal has not a party of SIDA, but the court says that so hard, if you are, whether you are party or not, but these are the recognized principle of justice. So under the Nepali constitution, there is one provision that the court will dispense justice not only according to the constitution, not only according to the law of the land, but also the recognized principle of justice. So things are there, but the things are looks fine in the paper. But thing is that there is a huge gulf between the ground reality and provision of the constitution and provision of the law. So how you can bridge the gap? So that's the huge problem. And look, the poverty is the biggest violation of human right. Since there is a poverty, the human right guarantee cannot, because human right does not mean only civil and political right, just right to vote. If there is a huge poverty and huge inequality and huge inequity, so the people, they are forced to sell their vote. So right to vote does not mean, if there is a huge poverty, which is very cruel. So how you can humanize the system? So at the global level also, you look at, there is a growing inequality at the global level. Look at the large number of states has been marginalized. So there are some richer states, they have a primacy over all the institutions. Even the event system, it is a long overdue agenda that events should be democratized. But there is little progress, no progress at all. So look at, there are 5 permanent members, they have a primacy over all the decisions, they can veto. So you are talking about equality, but there is no equality within the event system. All are equal, but some are more equal. So they have and there is a growing militarization. So growing militarization is also a biggest threat for human right. If there is a militarization and there is a military budget is increasing, we are talking about only border security, but there is no discussion about human security. People are suffering from poverty, unemployment, people are uneducated, disempowered, they are discriminated, women are discriminated, Adivasis are discriminated. There are Dalit population in South Asia. So even state is not reach out to them. They have no meaningful equality. So equality does not mean only the formal equality given by the constitution. Okay, all are equal. Doesn't work. We need a substantial equality. We need a substantive equality, meaningful. So people are allowed to participate in a meaningful way in a governance process, in a decision making process. So democracy does not mean only just vote, but also engagement in a decision making process. The state, the actor need to be accountable toward the people. So since only legal guarantee of human right doesn't work. What you need is we need human right culture. So there is a lacking of culture. It's the issue of way of life. It starts from home, in society. When you are talking about democracy, you are talking about only political democracy. But what about the social democracy? There is a huge inequity is there, discrimination is there. So the discrimination and democracy cannot go together. And if there is no effective and functioning democracy, human right cannot be guaranteed. So this is very clear. And look at the South Asian nation. If you go to the Europe, if you go to even the African state, even the inter-American state, they have regional court of human rights, regional mechanism they have. But look at South Asia or even Asia region. We don't have any regional mechanism. So look, it is a success story. European Court of Human Rights is a success story. They giving a landmark judgment. They enhance the jurisprudence, deepen the jurisprudence of human rights. Even the Inter-American Court has given a landmark judgment. Even the African state have also a regional mechanism, regional court of human rights. But in South Asia or in Asia region, we don't have such mechanism. Even there is no such debate. And since violation of human rights is taking place all over the South Asia and Asia, but I'm talking particularly about South Asia. We have a lot of commonality, and you can connect. This is also a big issue. How you can cooperate in terms of human right? That is also issue. How can we learn from each other's experience? Because we are suffering from the same kind of problem. Poverty is there, discrimination is there, women disempowerment is there, Dalit population is there, Janjatis, indigenous people are there. So a lot of commonality is there. But how we can come up with some kind of regional mechanism, so you can address the issue of human right, not only at the domestic level but regional level also. Because the primary responsibility to protect human right is with the is a particular state. It's a domestic issue. But the internet.
Only 2 more minutes. So like.
Oh, okay, sir. Okay. Let me conclude. Okay. So how to the thing is that how you can provide genuinity of our institutions. Like we have a human rights institution. I don't know case of India, but in Nepal, what happened is that human right commission was appointed by the unconstitutional means. Actually, in the constitution, there is a constitutional council to appoint the constitutional body. So what Prime Minister is a chief of constitutional council, and he called a meeting, but there was a rift. And what he had done, in violation of the constitution, he promulgated the ordinance, and that very same day he appointed the commissioner. I filed a case in the Supreme Court as PIL to quash those appointments. So look at not only that Human Rights Commission, even the Election Commissioner, Public Service Commission, all those people, even Women Commission, they all appointed by ordinance. So I say that you cannot run the country by the ordinance Raj. Like in Indian Supreme Court given a case judgment on Rakesh Vadhav. I also, so still that case is going on, but no verdict. So things is that if the Human Rights Commission itself is appointed by unconstitutional means, what you can expect? So these are issues. So the institutions are lacking the credibility, genuinity. So only thing is that we are talking about democracy, but there is a shrinking space for civil society. There is a shrinking space for democracy, and people they are losing their voice. Civil society is losing their voice in all South Asian nations. So in this context, how you can create culture of human rights is a huge task, and it is our existential issue. No human right, no democracy, no human dignity. Thank you so much.
Thank you very much, sir. दिनेश जी, जोरदार तालियों से दिनेश जी के स्वागत कीजिए. So कुछ बोलो, मैं बोलता हूँ उसके बाद.
उनको बुलाइए, अनुपम जी को.
नहीं हाँ, अनुपम जी थोड़ी बोलिए, उसके बाद मैं बोलूँ.
ये तो हमारे
अनुपम शांत नहीं बैठने.
Thank you, Dinesh ji. It was food for thought in the morning. आप नेपाल से आके और हमारे देश में, इंडिया में, but it's all about, he was talking about South Asia and what are the problems which are being faced by the countries of South Asia. Or he had raised and exactly pinpointed the gap between the law and the actual, what is the reality. So law and reality, these are the things that he was trying to highlight. Law, he was saying that law is an ideal and the reality is completely different. So that is important. I can say that the same situation prevails in South Asian countries, I agree with him that we have also right to equality, and we have also uh, right to live, right to life. But I remember the case of Hussain Ara Khatun, when a lot of prisoners, they were in the jail, and the punishment, whatever was the punishment for the commission of the crime, she had exceeded the punishment, but still she was in jail because she was so poor. So, and then a lady advocate who was sitting in Delhi, she filed a public interest litigation in the Supreme Court. So Dinesh ji is also an activist. He files public interest litigation in Nepal to highlight the problems of the people and how the law which are there enshrined in the constitution and the international instruments to which Nepal is a party. He wants to rake up the issue in the Supreme Court of Nepal and tries to fight out for the people. That is very important. He can understand because lawyers have a great role in protection of the human rights. And perhaps Dinesh Tripathi ji, being an advocate, senior advocate of the Supreme Court, I can say that whatever he is doing by protecting the human rights on the ground, because that's what he was highlighting, that on the ground it is very difficult. I also say that human rights are important. We have the constitutional writ petition we can file, but who can file the writ petition? So PIL will be one help. PIL can be filed, but who will file the PIL? Advocates. Can any individual file a PIL? That becomes a technical issue. So unless and until a PIL will not be filed, and nowadays the courts are also not taking very lenient view to accept the public interest litigations. So I think that Dinesh ji has highlighted correctly the point. Thank you.
So thank you very much, Professor Anupam ji. Dinesh ji, you started with a note: best of time, worst of time. You have also challenged democracy, political democracy to social democracy, and also you mentioned about the sinking democracy. If I say in space, it's democracy. So you have put a great challenge before everyone that what the model of the democracy should be, which should be generally we believe in democracy, rule of law, independence of judiciary, people's participation, transparency, and all other necessary elements attached to the democracy. And I believe when it comes to the India, we have the Nepal is also progressing from monarchy to constitutionalism, which has come into in your state. You also expressed very deep concern about the human rights are always against the state. So that is the public officials, enforcement officials are there. As my young friend mentioned about the Hussain Ara Khatun versus that important case, and Rudulsa versus state of Bihar, all these cases where due to the poverty, people were not in a position to pay the money for the get out from the jail, and they languished the jail, in fact, and subsequently through the, and that helped also to develop the right to seek compensation jurisprudence in the Indian scenario, and constitutional thought has evolved. I totally agree with you. I think all of us agree with you that that poverty is a major threat to the human rights, and that has also realized at the global level, and that is why to end the poverty, elimination of poverty, extreme form of poverty becomes a global concern. And it is started with the adoption of Millennium Declaration and then Millennium Development Goals, and 2015 onwards we are running Sustainable Development Goals. As you mentioned in your discussion about the ideological differences, how the priority shifted when it comes to the civil and political rights and economic, social and cultural rights. Largely the communist country or the blocs which were supported by the USSR, including India, were in favor of giving importance to the economic, social and cultural rights along with the civil and political rights. The debate related to the bifurcation of human rights has come to an end after the Vienna Declaration, where it says clearly that human rights are independent, indivisible,
Yes.
interdependent, integrated. So more or
Indivisible.
less, we are moving on a very right direction. There are a lot of you pointed out very correctly how the European Court of Human Rights, and of course, if any institution in human rights at the some level, global level or regional level or international level, we say it's actually functioning European Court of Human Rights, and which has given a large number of judgments related to right to life, provision against torture, even the deportation order has been stayed by the European Court of Human Rights. And the most important case, Chahal versus Binay ji ko शायद याद होगा, Chahal versus UK in 1987-88. Chahal was the Indian national living in England. So there are, but how we'll build the regional mechanism when we have so much differences in the Asian continent, and that is the only continent which doesn't have regional human rights instrument, and that remain a big issue because of lot of factors. We are there. I you also said this like house, that is the more in a perspective which very concerned that gradually poverty, caste based discrimination, religion based discrimination, these are also some way you have highlighted. You the increased role of the transnational companies are also very serious concern for the state, and particularly the states in the Africa and Asia, where transnational companies have huge investment in that country, and their income is much higher than the country itself. So there are a lot of challenges are there, and there is a development has taken place, but there. Let me just conclude, because there are many things to say, many things you have given us to think over, and I'm sure the colleagues sitting here, they are noting, and they will also try to take note whenever they write something in future, an academic journal and other things. You also mentioned about the obligation of the state under Article 55 and 56 of the United Nations Charter. So, and then just to conclude, you made a very nice distinction between the formal equality and substantive equality. In the Supreme Court also in India, and when commission of the women, commissioning of the women in the armed services, permanent service, that become a big Binita Punia case, where Honorable Justice talked about the formal equality and substantive equality. So what we have to, I feel that leave the equality or something, it's better to pulling off. So we have to pull up the person with extending our hand. Don't go in the, there is not, every solution is not in the constitution. There are solutions which is more human based solution. So we devote much time on the constitution, and our own obligation we forget. So we can keep it aside, let the constitution interpret it, but as a human being, we can always extend our hand and help the people. We can we can have, if surplus money, we can share somebody. So instead of focusing too much on constitution, we must realize the human duties what we have, and how we can also help in the betterment of life of some of the citizens. With this, I come to end, and I think this time to move for the another speaker, and that is very is very proud for all of us, the person who gave the shape to the Indian Society of International Law for the 2 decades, more or less 2 decades, he served in the Indian Society of International Law, and the lot Binay was known, society was known because of the Binay वहाँ नहीं जाएगा, यहीं से हो जाएगा, was बोलेंगे, society was known because of Binay was always so anything, and I see how effectively he managed the functioning of the Indian Society of International Law for the almost 2 decades, and we are very proud and happy that Binay has joined Jawaharlal Nehru University a place, a dream for every academician to go there. So I did not get a chance, and I don't think this life I'll get a chance. But of course, Binay will invite me for some function, so that may give a chance to speak there. But the people are inviting me, so I'm going there, JNU, in a different capacity. But as a teacher, it's like wonderful, like a place where one can explore, one can think independently, and autonomy is these days autonomy is cutting down. What I gather from newspaper, but I think the autonomy exists, and all these autonomy provided Vinay an opportunity to think about the draft covenant on the right to development. So sir is going to discuss about a step ahead from the 1986 UN Declaration on Right to Development towards a legal binding instrument on the draft on right to development. Floor is yours. You have 15 minutes. We'll give you 2 minutes from our co-chairperson, 1 minute from my side, and one. So you have total 19 minutes to speak. You take your time. Thank you, Vinay.
Why this discrimination for us you did not give me?
Thank you, sir. And this is really a privilege for me to speak before Professor Manoj Sinha. And this topic, credit goes to him. My work, which I begins during 2000 when I begins this topic, and credit goes to his writing published in 2003, IJIL, where I was exploring some materials pertaining that someone who could, from Indian scholars who could have written on this one. And I went to the library. I could not get that article to understand some points. I approached to his rooms, and one distinct, what you can say in his article, which only few would have underlined the importance in their writings, particularly on right to development. And he wrote one line: right to development unifies civil political rights with economic, social, cultural rights. This is a debate which has been taking place at that time, and he took this stand on that one and wrote a beautiful piece on it. And it gives insights to me to understand what sir is trying to mean by this one. And thereafter I discussed with sir, and I'm quite sure, sir, you remember this aspect as well. And this is really presenting before him, who's authority on this subject. I'm quite sure if I do mistakes, he will add to that whatever I left into. So it's a right movement, and as he said that really that's I used to introduce him whenever he used to come to the society, and this verbatim I used to do that. We see him and then we see the society from that. So his what you can say, his style of functioning, and also we learned a lot from him. And I worked during his time when he was director, when he was assistant professor over there. We worked with him, and I learned a lot from him. He was so encouraging that even if you do mistakes, you don't find yourself somewhere to be somehow to be in that any negligence cannot be taken to the somewhere, what you can say, in mind and in his mind. So he is always forthcoming, supporting, doing all of work of the society. We learned from him, so all credit goes to him, and he really encouraged a lot to do that. So, thank you. Let's come to the topic, and this topic is, as I said, as sir has said, that that's beginning is with the 1986 UN Declaration on Right to Development, and as rightly begins with that, this right is important in the context that it says that civil and political right unifies with the economic, social, cultural rights. Since that early experiences, what you can say, implementation process so far has neglected a lot to the economic, social, cultural rights, or somehow the preferences has been given to civil and political rights to extend debating and discussing, and also streamlining the procedures related to that one. And this is the set a tone for all of us to take forward that what could be what could be the discussion as ideological debate, which has been within the human rights. Since long it has been there, and we all know that UDHR consists both rights to civil and political rights, economic, social, cultural rights. Whereas while enforcing these rights, we got two separate covenants. That one is covenant, international covenant on civil and political rights. Other is international covenant on economic, social, cultural rights, which has basically what you could see that uh, often been, as I mentioned, that preferences of civil and political right in discourse implementation been the one of the reason to see that how that others' right had could be given more space to be debated. Now, having said all this beginning task, and this could as I said that it has ideological dimensions, which has led this division of the civil and political, economic, social, cultural rights, and this also somehow that could be seen that the next debate somehow to influenced by this ideological debate, and this carries forward again, and there is a writings at that time in 1987, huge debate on this aspect by Donley, Jack Donley. He has written a beautiful piece in American Journal of International Law, which he questioned that by by unifying both rights, civil and political right, economic, social, cultural right, somehow to be given preferences to the economic, social, cultural right, and it will violate what you can say basic rights. It could infringe the basic rights. In this context, this is giving this all of us a sense that that all words are not together on giving equal footing to civil and political rights, economic, social, cultural rights. This has basically set a tone for all of us to understand the present ongoing crisis with the UN Declaration on right to development. 38 years has passed. Today, in 2024, still we are exploring the legally binding instrument pertaining to the right to development. And there are a series of what you can say committees has been working on this one. Let me to give little bit detailed about this aspect, that in 1998 open-ended working group was established, which is being supposed to explore the possible method to operationalize the right to development. Then there is in 2004 high level panel was constituted. It is known HLTF, High Level Task Force. Thereafter, a 5-member expert committee, which is recently in 2020 has been established to give the SAFE as a legal binding instrument. In these scenario, in these committees, a huge debate took place about what the concerns about the right to development as a legally binding instrument, and the major contest has been to the nature and that scope and function of the concept of the right to development. And this has been, as you know very well, that declaration when it was adopted, United States was one who was given negative vote. Rest overwhelming support from all countries were being there. And US has a stand on this issue that right to development cannot be found any human rights documents or any human rights instrument, and could not be potentially to be considered as a human rights in this context. So this his stand was it's a stand of United States continues to till today, when this what you can say discussion when the legally binding instrument is proposed before the UN General Assembly to be adopted. Now, this is the besides that, what you could see that in last 30 years, around more than around 20 reports has appeared, and in which you will find that there was independent experts Arjun Sen Gupta from India, who has also given a boost to this subject in the pertaining to that, linking this subject with the economic dimensions, which could give a thrust to understand that the widening ambit of the right to development has been at that time we see. And unfortunately, today is the task before the any what you can say our committee would be that from this instrument it is expected that it will achieve everything, and this is the unfortunate what you can say incident. Now you see that this instrument is being connected with the trade. This instrument has been connected with the environment, and recently the task has been given to look about artificial intelligence and cultural rights. So from this instrument it is expected that it could resolve all issues of the human rights. Now this is unfortunate situations we could see with this with this right to development, and that's why this today lingering issues been that whenever the report come publish it immediately thereafter new agenda has been added to make delayed this process of the adoption of the legally binding instrument. Now having said all this, 3-4 issues which I would like to float before you. What is the important what you can say concept has been during the evolution of the process of the what you can say the legally binding. So what are the concept enforcement concept has been developed over there, and this has not only strengthened the subject of human rights law as well as it has influenced the evolution into the international law as well as. So like several concepts which has been available in various international laws branches has been brought into the within the human rights, and those concepts has been given a concrete shapes to ensure that could be useful for the implementation of the right to development. Like we begins with the human rights based approach, which has been one of the initial what you can say enforcement concept has come into being, and this human rights based approach which has been said that could be the way to achieve the right to development, and it is expected that this language has to right based approach could be articulated in all international institutions, their governance and functioning of it. And thereafter what we find that there was conditionality has been imposed while implementing the human right based approach, which led that to think about to go beyond this concept of enforcement concept of human right based approach. And this movement has brought linking this human right based approach with the human right impact assessment, which has been also you could see that this impact assessment being in international law become the one of the tools to achieve or implement the rights which has been under debate. So linking with human rights based approach with the human rights impact assessment has been brought into it, which given a very useful insights into it. And thereafter what you could see that there is another additions to it to operationalize the concept of duty to cooperate. Duty to cooperate has been since long been debate while after establishing what you can after adoption of the UN Charter, and this is being considered a principles of international cooperation is the means to achieve what you can say the UN objective. And considering this is what we can say basis of the human rights, in the sense it has to be implemented through the right to development instrument. And this duty to cooperate has been again linked with the what you can say the no harms obligation, due diligence obligation, which is a new current what you can say doctrine which appeared into it. It becomes mammoth task for the committees to articulate linking with these two concepts together, duty to cooperate with the no harms obligation. Gradually I will explain to it. Then another new concept which has been brought into this instrument is known as the common concern of humankind, which you could see like these are terminology phrase has been often been adopted in various other international instruments like common concerns of mankind in space law, also common heritage of mankind in law of the sea. Many other instruments you would find similar understanding. Then the important task which has been before that in this subject is being that which is known as most agenda of the developing countries that address the structural obstacles. Structural obstacles means that what you can say the whole developing countries, while engaging with the discussion with the economic law, look to the two instruments, new international economic order and right to and charter of economic rights and duties, to be given a proper shape into the international arena, where that could be seen that this context has to be linked with the concept of the right to development. So new model, which is being considered to be one of the major tasks in the economic law, has also been brought into the right to development concept to be actualized, operationalized, the whole process of debate. So this new model has been often been opposed by the, what you can say, developed countries. I will take 2-3 minutes or more. And this has been also become difficult for this instrument to carry forward among the what you can say, the industrial countries, to get support of it. So the new model remains one of the challenge for it, and which has been addressed by 1998 committees, which has linked with the, as I said, that linked with the human right based approach with the human rights impact assessment. Now, having said to this understanding, now let me to summarize that what are the concepts which is being become the focal point for a whole legally binding instrument to be taken care: right based approach, duty to cooperate, due diligence, development compact, human rights impact assessment, and then Millennium Development Goal and SDG, which brought the global partnership for development, and then common concern of humankind. This all new concept has been brought into the human rights added ambit to the whole debate on it. So today what we see that we have reached to the stage where a draft convention was been proposed in 2020. It has been proposed. It has been asked to revise this convention, and it has come as a draft covenant on right to development. The title has been changed to ensure that the importance to the right to development will be given in similar manner what the other two covenant are being there: international covenant on civil and political rights and international covenant on economic, social, cultural rights. So the title has been changed to ensure that importance to the concept of importance to the right to development has to be placed into the whole human rights instrument framework which is emerging into it. Then coming to that, basically one important innovative aspect into it, which could be also challenge for it, for this instrument to be go through to get passed from the all with the consensus of the one, that is basically provision pertaining to settlement of disputes, referring the matters to the ICJ. We all know that Convention on Elimination of Racial Discrimination is the one treaty which is often invoked before the ICJ, and considering that one, we don't have provision pertaining to the settlement of dispute before ICJ in ICCPR and ICESCR, economic, social, cultural right. Keeping this one, this is a progressive version which has been come into the right in the convention on the right to covenant on right to development. It will be definitely a huge task to understand by the stage to how they to go ahead with. So I will end here, and thanks for giving me an opportunity to share my thoughts on this topic. Thank you.
Thank you, Vinay.
Vinayji presented this paper on right to development, and he was saying that a draft treaty is going to be signed. So the story is very interesting. You see that right to development, every country became politically free in the late 20th century, and after mid 20th century decolonization happened, but economic sovereignty could not be given. Political sovereignty was given, or somehow after a lot of struggle, political freedom was taken by the people, natives, in many countries of Asia and Africa. But economic sovereignty could not be given. Now that is the point where the third world countries like India, they have been trying to assert, when they became one of the members of the United Nations, they wanted to assert that economic sovereignty is very important. And without economic sovereignty, we will not be able to develop. And there should be a right to development. And then the movement began that whether we can have control over the natural resources, and then a whole declaration on permanent sovereignty on over the natural resources of a country. So even natural resources which were there in the country, like oil, like gas, and like Dinesh was saying, that transnational corporations, they came and they started exploring the natural resources and then taking the benefit out of it. So here comes the point that right to development is it a charity? Is it just a declaration, or this is the right of at least those countries which have not developed yet, and they aspire to develop because of the poverty. Poverty has to be eliminated. Poverty, how can it be dealt with? Because unless there will be no right to development, this will be very difficult. So developing country, developed country, this is a kind of, here comes the point of tussle, because developed country, perhaps that is the reason why this treaty is not going to be, so many countries are not willing to support it. But this is the aspiration of all the Asian and African countries, that they must be having this right to development. And perhaps the settlement of disputes relating to right to development, that has not come yet, but that is a very important issue. That suppose someone wants to go before international court relating to this, because I remember Anglo-Iranian oil case. I remember the case which was Texaco Overseas Petroleum Company case, where you see all these questions, that whether the Charter of Economic Rights and Duties, these instruments are important, how much they are legally binding. So Vinayji's paper today, it has tried to connect all these things. I am so thankful to Vinayji that he has taken up this issue today. Thank you.
Thank you, Jajit. I request Aarti, why don't you come here? I think Sarma ji, Ashok Kumar Sarma ji है नहीं है? आप आओ यहाँ पर, your speaker. So you can, नहीं, you leave, you stay, sir. Ashok Sharma is not there, so Shiv Aarti. उनका नेम प्लेट ले आइए से वहाँ से. वो नेम प्लेट बना हुआ आरती जी का. So this is an equality, no? We substantially, I said you can't wait for the constitution. So women are like, a panel is sitting there and we are like, so I just noticed, I'm sorry that I could not notice. No, opportunity, you are like in your rights, and but unfortunately I have not seen when I saw that Aarti Lamba. So आपको यहाँ बैठना है, इसी को कहते हैं पुलिंग. So हमें क्या सोचना है, हम कॉन्स्टिट्यूशन पे ज़्यादा ना पड़े. So moving on, like what Binay had said, and very nicely summarized by our young colleague. आप कलर तो नहीं किए हैं घर में, बार बार ही अंकल ही कह रहे हैं. So I think so, but he's still very young, and so Binay ji is like it's a very important topic on the right to development, and some way it was like you might have also noted the idea of the whether right to development is a human rights. It first time figured in the 1972 when the Chief Justice of the Supreme Court of Senegal, while addressing the student, and then he said, right to development is a human rights for the African people. We want to develop, and that is he pushed. And then subsequently Carol Basak and others, they worked very hard, and then finally much opposition. So it has always an opposition. When the concept of right to development evolved, pushed by the African nations to recognize as a right to development. And most important, the very first article of the UN Declaration on Right to Development, in the Article 1, which says clearly the article right to development is inalienable human rights. So very fundamental. The article, the 10 article, the first itself talks about the inalienable human rights. Means most important core human rights is the right to development, and that the idea, the way Supreme Court has interpreted Article 221, the same way we need to look into that. And then since the journey, and USA was opposed, USA opposed the declaration very strongly, did not join, and still it continued as opposition of United States for various reasons there. You also travel time zone. Their journey started with the 1988, then 2004, 2022, and then also you mentioned about the independent expert. And I believe, if I remember correctly, our Professor Surya is the special rapporteur on right to development. Even Kishore Singh served one term right to development. So even one UN special rapporteur study was there. He served as a special rapporteur on right to development. Currently, the person who is sitting is an Indian professor in the University of Deccan in the Australia on the special rapporteur. Binay also highlighted, which I was not also aware, and of course many things we can't follow always, and that is correctly human rights based approach. Then he mentioned about impact assessment, Millennium Development Goals, Millennium Sustainable Development Goals, and most important, two important point which you have, no harm obligation and due diligence obligation when it comes to the right to, means like distributive justice, and some way high resources has to be distributed among the people or something on that is the due diligence application. And also not to development should not cause damage to the poor policy should not
violate the human right. Any policy
violate a human. That is the dialogue. That's very good. And you emphasized heavily on the inclusion of a provision or article which allows member states to refer the disputes to the International Court of Justice regarding that will be interpretation and application of the convention before the International Court of Justice. I believe that will also allow a state to opt out also. A state like Genocide Convention, 1949 Genocide Convention has similar provision, and India has opted out, I believe. So opt-out clause will be there. But anyway, that is the good development. No other human rights instrument talks about there except the Genocide Convention, which has interpretation and application. And then 1951 genocide case is there, no?
So racial discrimination.
And racial discrimination. Okay, racial discrimination also. And this is very important. And the major challenge which because अगर हिंदी में हम बात करें इसकी, तो development has become a very important aspect of the political discourse. जहाँ बात होती है राजनीति में, तो विकास की बात होती है. So there are two models which I keep on saying. There are two parallel models have evolved. One is the right to development, human rights based approach. What we have been talking, we are discussing about, and there is a right to development which state is. So state is also promoting development. State always, all states investment is the development. Economic investment makes growth of the country. So we see a development model followed by the state is more an economic model. So economic model has all the harms. No harm is important. No harm policy, due diligence and others is there. So somehow the development is a core issue which government has taken very seriously, but it has taken more on the interest of the transnational companies and also overall economic model, which needs to be integrated with the human rights approach. Things will be there. With this, I come to the end. And also, we thoroughly enjoyed your wonderful presentation and learned many things to take it further from our own point of view, and other young scholars are there. We moved from Delhi to now Banaras Hindu University. And we have a very great colleague, Dr. Raju Maji, GC, and then he is a professor of law in the Banaras Hindu University, and
No,
he.
sir. Again, you'll have to come one time.
Acha, again, I have to come on time. So I think my best wishes. So recently, Raju, associate professor, is there, and so we consider in Jindal model all all are professors. So the day you join, so Jindal model, you are professor. For the UGC model, I'll come again. So Dr. Rajiv Maju, and Raju is we deeply appreciate your engagement with the Indian Society of International Law. It goes to the student days. I remember you and Deepak always used to come to the society, and maybe for many all national conference, international conferences, Raju participated and ensured he becomes the integral part. And this is the way you people young students should become. So we were like you. Many times we never thought कि will come here. We thought कि will sit there और माइक ही पास करेंगे. तो लगा लेकिन किस्मत में तो लेकिन एक दिन आप बैठोगे इधर. So you have to Raju and we all sit the other side, and then I'm sure कि how time changes. When you sit, we may not be, maybe in photo or somewhere, but we'll be just, you remember these things. So all the young student must realize कि I'm going to take this position. I'm going to sit there. They are there for the time being. So it's a time is important. So आपका भी समय आएगा, आप भी पेप्सी पियो, खुद रहो, लेकिन आपके भी टाइम आएंगे. So I see that you think about on that way and you work hard, and I'm sure your time will come. People will move and new people will come, and you have a future. And that is the reason I inspire all of your students to take it there. I'm going to be there, and that is why the Raju is there, Vinay is there. और हम लोग तो जबरदस्ती बस गए. Thank you very much. Over to you.
Sir, thank you very much for your nice words, sir. But one thing which I like to express for you, sir, that you are right. That I remember when I was a student in the year 2000. At that time, the BHU has started the new course in PG level, that is LLM in Human Rights Education Duties. So sir was the visiting professor at the time, and I was doing at the time my LLM. I was in general, not in HRDA. But when we met sir, then it's inspired that we'll have to read this subject also. Then I begin to read this subject, and as sir remember that from that day he always inspired us that why you are not attending any seminar, why you are not attending, you come here and you are because we had the one group at the time. Now we don't have that. At the time sir, international law group was there, so I chose that, and that might be the reason that I was associated with. And Vinay sir, he always inspired me that you come, and whenever any seminar organized, as Manoj sir rightly pointed out, that the Vinay means the IHL. So we remember that those days, that I'm talking about the 23 years ago, when Manoj sir was very young and we were student at the time. Okay sir, thank you. Thank you sir, for your nice word. The co-chairperson Anupam sir, and co-panelist, and all the learned delegates. We are very fortunate that when we started at the time, they are only the few, but now the number has increased. So thank you very much for it. Sir, in today's discussions, I have chosen that very burning topic as the two reasons why I'm calling it the burning topic, because when we will talk about this particular rights, that is the protections of human rights of indigenous and tribal peoples. So if we'll go through the provisions, or you can say the India's commitment toward the protections of human rights, no doubt India is a pioneer to protect the human rights. But even that I have raised this question. So very good morning to one and all, and Johar. So Johar is greetings in the Jharkhand. Mostly the tribal people, they express their greetings by using the word Johar. So Johar to all of you. Now the topic is the discussions which I have taken, that I will discuss in the five part. That the one, there are some of the definitions which I'll read out before you. I'll not discuss on this. Then the second thing, the protections of human rights under international instruments. The third things which I like to share with you, that is the protections of human rights under Indian constitutions. And then the my theme core is, that is the identity of the tribals, and finally the recommendation. Now see, as I don't want to read out this the definitions of human rights, as you all know about it, but that the definitions which are given under the section 2 clause D, that is very important. As yesterday the Manoj sir pointed out, that human rights means the rights which are incorporated under the either in the part 4 or the part 3 of the Indian Constitution as a directive principle of state policy, or the fundamental rights. And at the same time, that the India's the mandatory that to respect the international covenant and other international instruments. At the same time, it is talking about the human rights means the rights which are protected under the Indian courts. So in that way, when we are looking towards that our rights, the human rights, then we find that the India, as I have already mentioned, that is a pioneer of the protections of human rights. And there are the many provisions which will have, and the India is a party of the international covenant, either when we are talking about the international covenant on civil and political rights, or when we are talking about the international covenant on civil, economic and cultural. So my focus is that we are having such kind of the international obligations, and we have incorporated the many things as in under our constitution. And besides that, the sometime what we are experiencing in the reality, that we find that the majority the rights are neglected. So in this regard, that I have chosen the vulnerable groups. Although there are the many constitutional provisions, when we'll see, then we'll find that apart from these instruments, there are the many constitutional provisions which is talking about are there the rights, the human rights which are protected. Now, the two things which I like to say before you, that when we are talking about the indigenous people, the terms which I have used, and the tribals peoples. So sometimes it is used in a synonyms. If you'll read even the conventions, ILO conventions of 1989, and the convention number 169, if you read, then you will find the same kind of, you can say, the word has been used. But when we are looking towards the definitions which is given under the Indian Constitution, then it's defined in a different way, which might have created some sort of problems as far as my understanding. Maybe the Manoj sir will correct me in this regard, but what I understand, that might be the one problem. The indigenous people, when we are talking about, then it's belong to, no doubt, that the particular community, and the scholars, the social scientists, they have defined they in a different way. But as far as constitutions, when it defined, then it says the scheduled tribes means the president may, with respect to any estate or union territory, and where it is a state, after consultation with the governor thereof, by public notification, specify the tribes or tribal communities or parts of or groups within tribes or tribal communities which shall, for the purpose of this constitution, be deemed to be scheduled tribes in relation to that state or union territory, as the case may be. And further it says, the parliament may by law include or exclude from the list of scheduled tribes specified in a notification issued under clause 1 any tribe or tribal community or part or group within any tribe or tribal community, but save as aforesaid, a notification issued under the said clause shall not be varied any subsequent notification. So in this definitions, if you'll see, then we find that if you are saying that by the parameters which has been said, that is sometime it totally depends on the government. The government, whether the government will consider you, then only you become a scheduled tribes of this country. Otherwise, you are not. Now, the one example which I like to mention before you, sir, that there are maybe that the internally displaced or whatever may be the region, that the tribals, they have migrated to the Assam state. Unfortunately, these tribal people we met personally, we went there and we met and we discussed with them. They are residing in the Assam from at least the fourth, fifth generation. But yet the Assam government has not recognized them as scheduled tribes. And the reason, whatever may be the reason, but due to that, they are not entitled the protections which are granted under the Indian constitutions as far as concern the upliftment of the tribal people. At the same time, what happened that we have experienced in the Manipur, the Kukis and Methis, that might be due to this problem, because that from time to time, it's with the consultations with the governor, that the estates may include any the other the inhabitants of that particular place, that they will get the tribal status. Now that when the list increase, and at the same time, it is also talking about that sometimes you might have got that rights, but that the government has that power that he may exclude from you that list. That's what the constitution says. In this way, that we find that merely saying that I'm a scheduled tribes, it is not sufficient. It is only happen that when government will notify under its notification. Now, with this, there are many constitutional provisions which I don't want to read out before you, because which talks about the protections of the interest or the protections of the rights of the scheduled tribes in this country. The two very important provisions which I like to mention here, that the fifth schedule and the sixth schedule, that is very important. And why this particular things is very important, because it's talking about the protections of the administration system which you have. The tribals, they have their own customary administration system. And my main focus is on this issue. When we are talking about the indigenous and tribal peoples conventions of 1989, when you will go through that, or the United Nations declarations on the rights of the indigenous peoples 2007, then you'll find that all the rights which are incorporated, that is basically for their identity, for the preservations of our identity, to preserve or to protect their cultural rights and the other administration of justice which they have. It is talking about that. When you go through these two documents, then you find that we have also incorporated in our constitutions. As I'm talking about that the fifth schedule or the sixth schedule, then you'll find that these two documents is talking about the protections of their administration of justice which is existing. The fifth schedule, as we know, that it deals about the administration and control of the scheduled areas, the scheduled tribes in state, except Assam, Tripura, Meghalaya and Mizoram. And these, the four estates, they are regulated by the sixth schedule. Now, the extension of this, when we are talking about that these two schedule, which is talking about that every kind of the rights that is available to the tribal, even that they can have their own rights, the mineral resources which is available in the scheduled areas. In this extension, what we are looking at for the protections of their self-governance when we are talking about, so especially an act was enacted, that is the Panchayat Extension to Scheduled Areas Act 1996, which talks about the self-governance through the Gram Sabha for the people living in fifth schedule. As you might have read, the one cases, that is the Samanta cases, which very importantly that the Supreme Court observed, and the Supreme Court expressed that unless and until that the consent is given by the Gram Sabha, the no land, or you can say the resources which is exist there, it cannot be exploited. That's the provisions which will have. At the same time, that when I'm going towards the many estates, they have their own tenure laws. And particularly when we're talking about, because I belongs to the Jharkhand, so in the Jharkhand there are the two very specific laws which also prohibits that for the transfer of the tenure rights, that is land, not it prohibits to transfer the non-tribals. And the reason behind it that the land property must remains with them, what I understand. And that's why the many times the attempt has been made that no, because if you don't give such kind of rights, then how, as rightly sir was talking about the right to development, so how they can develop, because the property what they have, because it belongs to the community, it not belongs to an individual. So individual with the certain, by taking the permission from the deputy commissioner, that you can sell out, and that can be sold out to whom? That only the tribals people. So in this regard, we find that that there are the enough laws we have to protect the interest of the tribal side. Now then, where is the problems? The problems what I find that the indigenous declarations of indigenous people rights, the conventions what says, that is not properly implemented. That's the big issue before us. I'm not saying that we don't have, as I have mentioned, that we have the sufficient tenure laws. Every state they have their the land laws which protect the interest of the tribal people. Apart from that, if we'll see, then we have many other kind of the legislations which is talking about the protections of the tribals' rights. The scheduled tribes and other traditionals and the forest dwellers, that is regulations of Forest Rights Act 2006. We have the scheduled caste and scheduled tribes, that is the preventions of the Atrocities Act of 1989. We have the Tribal Advisory Council who will take care of it, that from time to time they will send their report, the status, what kind of the things is going on, in what conditions they are living. And the problem which I found that besides all these provisions, that the tribals are neglected, and that might be there are lack of implementation machinery, or whatever may be, we'll have to find out that what are the solution, because at least the India have the sufficient number of legislations, the sufficient number of the constitutional provisions. If it will be implemented with the spirit of words, and there will be no problem. The tribals, they have their own customary rule. They have their own, you can say, the administration of justice system. And if you go through this slide, then you'll find that it is working in the three level. The one is called the village council, that is in the lower level, which we are calling the Maji system, and the upper level, that is high court, what we are calling, that is the Pir Pargana system, and the last one is the highest level which is talking about, which we call is the Supreme Court, that is the Desh Pargana. And there is one, if any kind of, you can say, the things which were existed earlier, but now it is not existed, that is the law bir. Now, the recommendations which I prefer, because due to the paucity of time, I don't want to go in details that the customs which will have. These are the systems which are prevailing, and these systems, if it will not be protected, then we cannot, you can say that, that the time will come that when we'll find that we lost these kind of, you can say, the spaces which we had or what we can say that we have, because their total, the entire life cycle that is based on the identity, and that is, you might have read that is again and again they are crying, you can say, for Jal Jangat Jamin. That is very important. And so their language, the other customary, they are very rich. One example, with the permission of the chair, just I would like to cite before you. See, when we are talking with the Santhali language, इसमें अगर आप जब देखेंगे तो आपको पता चलेगा कि कितना रीच है. मैंने इसको कई जगह देखा, नहीं मिला किसी भी. जैसे हम अगर बैठे हुए हैं तो हम डिस्टिंग्विश नहीं कर सकते हैं कि हम लोग हिंदी में भी जब बोलते हैं तो आदमी बैठा हुआ है, अगर कोई 4 पाँव वाला जानवर बैठता है तब भी हम बोलते हैं कि बैठा हुआ है, कुत्ता बैठा हुआ है. अब पक्षी अगर है वो भी बैठा है तो तब भी हम बोलते हैं कि बैठा हुआ है. लेकिन जब हम संथाली में इसको आप देखेंगे तो फिर आपको सिर्फ एक वर्ड से समझ में आ जाएगा कि ये आदमी है, आदमी बैठा है, या 4 पाँव वाला जानवर बैठा हुआ है, या पक्षी बैठा हुआ है. फॉर एग्जाम्पल, अगर हम कहते हैं कि आदमी बैठा है तो हम लोग दुड़ुप शब्द इस्तेमाल करते हैं, दुड़ुप. अगर पक्षी बैठा हुआ है तो उसको हम लोग कहते हैं आप जैसे बोलेंगे तो समझ में आ जाएगा, कोई भी आदमी समझ लेगा कि पक्षी बैठा हुआ है. और बुरुम शब्द अगर इस्तेमाल करेंगे तो हमको समझ में आएगा कि 4 पाँव वाला जानवर कोई बैठा हुआ है. तो बुरुम, आप, दुड़ुप, ये 3 शब्द ऐसे अलग अलग इस्तेमाल किए जाते हैं जो मैंने दूसरे कई भाषा को समझने का प्रयास किया, वहाँ हमको नहीं मिला. एंड द रिकमेंडेशंस व्हिच आई मेड दैट द लॉ मस्ट बी मेड by incorporating the international obligations, and it must be, you can say, to protect in words. And the one thing which I like to mention before also you, that there is a debate is going on whether the tribal peoples are Hindu or whatever. So we believe, because I also belong to that community, so we believe that we are not Hindu, we are Sarna. So the recommendations has been passed by the Jharkhand Assembly, and it is pending before the central government. Yet it is not. But it will be better that it will be immediately. It will be given the legal status, or you can say recognize the Sarna religion, so that they can also enjoy their religion. Thank you very much, sir, giving me this opportunity. At the outset, let me congratulate to the organizing committee of ISL for organizing such a wonderful seminar and giving me this opportunity to share my thought. Thank you very much.
Thank you very much for a very interesting presentation and comprehensive presentation. I think we have running short of time. We have 2 speakers, so I'll quickly sum up. But you have said, so Hindu, or it's like, I believe Hindu is a way of life. So we all are Hindu, even if Muslims are Hindus. So it's not the question of like, and we consider, and I also belong to Jharkhand. So Santhal Pargana, so my childhood almost like in Santhal Pargana in Devghar, so we are more on Santhali in a sense. But and then culture, lot of things we find is a common in both, like worshipping tree, worshipping well, water, a lot of things which in both culture practices are there. But on the top, we all are human being, and we have to live like a human being. So my best wishes for Sarna also to be recognized on that. What he has mentioned, and quickly to sum up, there are direct provision on the constitution which relate to the scheduled tribes, which we don't use the term indigenous people. So that is article 244, 342, and then 371 also A to K takes care of, and 2 schedules like schedule 5 and schedule 6 is there. He has mentioned about there is a very important case on the tribal Samta case that is very developed a lot of things. I'm not quite sure, but ILO convention is the main 169. ILO convention 169. India became party or still not party? Nahinder Singh sir can elaborate. So I have a doubt India is not party of the ILO Convention 169, and for many times we have been looking forward that India should become you have also definition part, you have looked into the Human Rights Act and UDHR, another aspect. I am sure one the issue which you have identified, which bothered me to think, Adivasi, he moved to the in Tea Bagan in Assam, lost his scheduled tribes status. So status of the scheduled tribe, scheduled caste, OBC is more an state determines, and of course the union government has a role to play. But what I think, once they are recognized as the scheduled caste or scheduled tribes in a state, that should be recognized by the entire country. Yeah. So that is the problem. Even if you move from the ST and then you live in the Andhra Pradesh, you may not get the benefit, and that has to come to an end. So it should, at least in the scheduled tribes, because it will encourage migration, people will move, and same time they will constitutional guarantee. So it should not end with migration. Migration become estate. So some need to change, at least for the scheduled tribes, because if you want SCP, they can move from one place and they retain their. That is the important point is there. There are a lot of things to discuss, but I'm not in a position. We'll always discuss over a phone or whenever we'll meet leisurely. And moving on to the next speaker, Aarti Lamba.
Now I request Ambassador Narendra Singh, Sir, Secretary General of ISIL, to felicitate the chairpersons of the session, Dr. Manoj Kumar Sinha and Dr. Anupam Jas.
अच्छा सर, ये आ गए सर, आइए सर, आइए. So Aarti, so now we have been already felicitated. So felicitation has been done, and so now we move to the, we will be confused, meditation or facilitate. Aarti teaches in K.R. Mangalam University, and Aarti is going to speak on a very empirical study on human rights of the police officer in India, a comparative study, more on the data or observation or other thing. Yes. Please go ahead. And you have, take 15 minutes. Sure. If Illumination, I have not given 1 minute, I'll transfer 1 minute to Illumination to you also. So go ahead.
One juvenile inquisitiveness, if just 1 minute or two, you can say.
Question answer, what?
That was about the use of word indigenous versus tribal.
We'll do that, sir.
Let's we are in the international law regime state discussing in that realm. So I think it is a post-colonization effect, and indigenous word is used more in America, and tribal is where our natural population subsists. That's the only thing.
Thank you, sir. Thank you. Please go ahead. Thank you, sir.
Good morning, everyone. My name is Aarti Lamba. The topic is a empirical study on the human rights of the police officer, a comparative study. Start with the introduction. The human rights, fundamental freedom inherent to every person, uphold the dignity and equality of all, as enshrined in global and international framework like the UDHR and the Indian Constitution. It is the heartening to note that awareness about human rights has gained worldwide attention. Even the government and the non-government agencies have come forward to propagate and protect them. However, the human rights of the police officer are often undervalued and neglected. Most people consider that there is always the police officer who violate the human rights of the other persons. But the question is raised, what about their human rights? It is also important to protect their human rights as well. To preserve the efficiency, integrity, dignity, pride, and professionalism of police officers, they must be acknowledged also. The objective of the study is to assess police officers' understanding and adherence to human rights, focusing on preserving life within a socio-economic and legal administrative framework. An empirical study approach will provide evidence on the state of human rights of the police personnel. The hypothesis of the study is that the legal framework and the implementation are inadequate in protecting the human rights of the police officer. My universe of the study was New Delhi district in Delhi. These are the samples which I have collected with the help of the questionnaires. I asked very basic question to the police officer. I have two questionnaires. The one is for the police officer and the second one is for the academicians, experts and lawyers. The sample which I have collected from the police officer, that SI are 53% of the police officers who responded of my questions. Some inspector, ASP, DSP and IPS officers are also involved who responded my questionnaires. And from the experts and from the advocates, academicians, advocates from the Supreme Court, I have collected this data from the Supreme Court, where 101 and 25 academicians and 17 advocates on record and experts. The empirical result, the result of my empirical study which I have collected, which says that the 94.90 police personnel's workload stretches beyond their duty hours. 88.40 police officers are under stress due to workload. 93.50 are unable to enjoy their holidays. 49.50 are suffering from disease. They even are not allowing me to disclose their disease, what kind of disease they are suffering from. And the majority of 89.90 respondent that they are unable to avail their lunch break on time. There is no fixed time for their lunch even. And they lack proper clean toilets. 59.40 responses. The police station which I have seen is the Tilak Marg police station, which is near to the Supreme Court. The data which I have collected from the academicians, experts and advocates was, I have asked some few questions related to the Police Act 1861, where they propose the amending the act should be amended. 93.9 responses I have collected. They also recommended that the government needs to pay attention to the human rights of the police officer as well. Even they also think that there is always some interference in their work through which they are unable to resolve some cases, or they are unable to handle the cases as well. The comparative analysis, human rights of the police officer in India and the United Kingdom. We are facing the workload in India. We are facing so much workload in our police officers. In India, they face extended working hours, minimal and high pressure environment due to a large population and socio-political challenges. Whereas in the United Kingdom, the police officer generally operated in structured environment with a defined working hours and sufficient resources. The next point is training and accountability. Indian police training programs are often criticized for being outdated and lacking a focus on human rights, and receive inadequate training for handling complex situations. Where the UK has comprehensive training programs that emphasizes human rights, community policing and ethical use of force. The next point is health and safety. The mental health support in India is insufficient, inadequate protective measures, where UK well-defined health and security standards for the police officer, including regular assessment and superior equipments. The last point is legal safeguards and rights. In UK police, they benefited from clear legal safeguards under framework like the Human Rights Act 1998, ensuring the rights related to working conditions, safety and treatment. In India, constitutional protection and legislation exists for public employers, but the enforcement is often inadequate. There is a case. This case is belong to the UK. In this case, I have identified that the applicant, Mrs. Halford, an assistant chief constable, she alleged violation of her rights under the European Convention Human Rights. The issue was the case centered around the interception of Miss Halford's private telephone communication made from her office during a period when she was engaged in legal proceedings against her employer over allegation of sex discrimination. The claim, Miss Halford claimed her calls were intercepted to gather information for the discrimination case, violating her right to privacy and correspondence. The second, she alleged breaches of Article 8, right to respect for private and family life, home and correspondence, and Article 13, right to an effective remedy. The court findings were that the interception of her private cell phone calls by her employers constitute a violation of Article 8. The United Kingdom government argued that the Halford did not exhaust domestic remedies, but the court held that she had no effective remedy available, thus the finding a violation of Article 13 as well. The outcome of the case was concluded that the interception was unjustified and that Miss Halford's right to privacy had been breached, leading to the finding that the UK was in violation of the European Convention Act on Human Rights. The next case which I have studied, Prakash Singh versus Union of India 2006. As we are well aware of this case, in this case, the former Director General of Police and other filed a public interest litigation to reform the public police force in India. The objective of the case was the petition sought police reforms to ensure the independence of the police from political interference and to improve the accountability, efficiency, and professionalism of the force. The key issues was that political interference, police accountability, and police functioning. The Supreme Court directed that all the states, the Supreme Court also directed the 7 directive key reforms where they directed all the states and the union territories to implement these reforms and to ensure accountable and efficient police force. Many states have yet to fully implement directives, but this judgment remains a landmark in the Indian police reforms. The finding of the cases was that the right to life is about more than just a right to survive. It also entails living a complete life of dignity and meaning. Police officers are overburdened due to heavy workload and department's lack of workforce. Even the former CJI, Honorable C.V. Ramana, who also highlighted that investigative agencies are overburdened. It is also revealed that there is no awareness, provisions, rules, circular, procedure, or system for the filing case violating police officers' human rights. Even through the RTI, I have found that there is only one particular case regarding the violation of the human right of police officer. Through RTI, I have found this. The conclusion of my study is to protect the human rights of the police officer as well, because they are also human beings. I'm not talking about at least they should get the basic human rights or the basic facilities, because they are also human being first. Every citizen, legal rights are safeguarded by the law. The people are granted the legal right by the virtue of being a citizen of the nation. The suggestion of my study is conclusion of human rights of police officer, incorporation of human rights education in police officer training program, recognition and realization of police officers' human rights, independent review of disciplinary measures against police officer, and legal protection for police officers in India. Thank you.
Thank you very much, Aarti. So you not only summed up your presentation nicely, but also saved 3 minutes for all of us, 4 men. So quickly we'll just sum up that there are a lot of things you have said based on your study and finding. I believe that some way we have to give a good working environment to the police, and also they are entitled for some of the rights. Even the constitution limits their right. Fundamental Article 33 gives some limitations on the police officer, armed members of armed forces. It's not all fundamental rights, so their rights can be curtailed, their rights can be there. But it's still workplace environment, how to mental health issues, number of things are there which needs to be taken. As I'm sure that you might have found in the UK comparative study how police are better placed. So I hope, and then you have also mentioned the judgment of the European Court of Human Rights and the Halford versus the UK. I think we are at the end of our program, but we have a special request from the Avin Tiwari and Subbar Rao Chaudhary. Are they here? Yeah. So you have 5 minutes, and you come here balancing liminal space investigation, state dispute of state sovereignty in third world. You can please go ahead with that.
Good morning, one and all. My topic is balancing liminal spaces, investor-state disputes, and state sovereignty in the third world.
Universe.
So our paper is a paper which is formulated in a doctrinal manner, and it deals with three fundamental questions, which is whether or not in a world of decreasing BITs, a new trend is emerging where the number of BITs are decreasing, however ISDS are drastically increasing. Whether or not the global south, except for countries like India and China, who are the home for TCCs, is specifically vulnerable for it, and what could be the way forward regarding this. The whole premise for this argument is that in the past decades, the number of BITs ranging from around 200s have come down to around 30s or 40s. However, ISDS is busier than ever, and it is dealing with a huge case loss. What it could possibly mean today is that a lot of the international capitalist investors are currently working out of bounds, in which states have limited structural integrity to impose upon their domestic policies upon these international investors, and they also found themselves out of bound practicing and getting the best out of their investments. The peculiar problem of global south in this regard is that countries like India and China, which are home to the transnational capital class, have used this above mentioned vacuum into their own interest. A prime example of which could be the Tata's acquisition of Sri Lanka Airlines. Moving forward, the paper has been formulated in a doctrinal manner, and even though there are not very direct cases regarding to this, but this has been an emerging trend, and looking beyond the past 3-4 decades, it could have been predicted from the three cases: Philip Morris versus Uruguay, Philip Morris versus Australia, and Bywater Gulf Limited versus Tanzania. In both the Philip Morris cases against Uruguay and Australia, there had been a termination of an initial BIT, which led to Uruguay, Philip Morris suing both the countries for their policy changes. In case of Uruguay, what it tried to do is impose upon stricter tobacco regulations so that its people stop smoking less. Philip Morris sued them, and the ISDS found Uruguay in contempt in multiple issues, but even at the end of the day ruled in favor of Uruguay. The same trend had continued for Australia as well. However, with the passing time, the ISDS have become more critical of the state than of the investor, and a change could be incoming, which has been in the case of Bywater Gulf versus Tanzania. The same case when Tanzania, beyond the protection of a BIT, tried to terminate the contract of Bywater Gulf. It had a very adventurous interpretation of FET and sued Tanzania, and the ISDS ruled against Tanzania. However, it changed in the appeal. Moving forward, the way forward regarding this could be that a stricter imposition of carve-out policies. Carve-out policies are basically such policies which, even in BIT, specify that certain areas of policy making would always remain with the state and will be a subject of state sovereignty and will be beyond the protection of the BITs. Hence, ISDS will not be able to impose those upon the states. Other than that is promoting sustainable developments, aligning investment policies with sustainable development goals, which would encourage responsible business practices by foreign investors and strengthen international cooperation to address the global challenges. And at the end, harmonization and standardization of model BITs in the global south could effectively resolve this issue, as then the need for terminating BITs for the countries of the global south will not be a need. In conclusion, in our paper, we found that the interplay between state sovereignty and investor rights under international investment law has always been a very controversial subject. But in the recent times, prior to this, there were at least the BITs providing some kind of a structural integrity to the subject. But with the demise of them and decrease, this is becoming more and more problematic. With this, I would like to conclude. Thank you.
Thank you very much, Rai Chaudhary, and I think you have brought a very important topic, and the interesting part which you noticed how bilateral investment treaties are coming down, decline in there. But you have also suggested that there is a need to have a model BIT because exploitation is taking place, as you gave an example of Tata acquiring the rights of the Sri Lankan Airlines, and China and India play very important role. So you did not hesitate even bringing India along with China. So I appreciate that your courage to. So that these are the problems which you have highlighted, and I'm sure that some development already taking place in that context. You have mentioned where bilateral investment treaties, ISDS, something you have mentioned, I have looked into. So thank you very much for coming and sharing your views, and wish you all the best. You write a paper on this.
Yes, sir.
And
Thank you, sir.
thank you very much. So this we come, कनिका हम सर आपका क्वेश्चन ले लेते हैं, आप हमारे सबसे खास हैं, आप जरूर लेंगे सर, बताएं सर.
I am Commodore P.K. Goel, retired Judge Advocate General of the Navy. My question is to all the panelists, and that is. Yes. And the question is, are the terrorists have human rights? And this issue came in the Operation Blue Star, where on a PIL, the Supreme Court had passed a judgment that all the people who are inside the Gurdwara terrorists, they were to be provided with water and food. Now, the three chiefs were asked to implement the judgment, and they called all the three Judge Advocate Generals, including me, how to implement this judgment. Fortunately, the Supreme Court did not say how much water, how much food. So we only said, give them half bottle of water and 2 slices of bread every day. The question that came to us was, the terrorists encroach upon our human rights, and they claim their human rights. Now, this issue I leave to the panelists to discuss whether the terrorists have human rights or not.
I just to add 1 or 2 points there. So human rights is available to all, and then our law is basic presumption of innocence. So till they prove guilty, they were so they have all the guarantees what are available. So you can deprive, you can take away whatever rights have, that has to be lawfully. Arbitrariness, if it comes, you deny something that violates the human rights of individual. So human rights of the individual, then categorization takes place, whether terrorist, whether dacoit, whether, so everyone has rights, and of course their rights are curtailed, their liberty is curtailed, and they're punished according to the law. Then another point which you highlighted, the Supreme Court has not said how much water we have to supply. This can also be a dangerous trend. If somebody dies in that particular situation, so this is a very serious issue. A condition is created for the which affect deprivation of food, deprivation of water, deprivation of medicine, and then that can go in a next level, which I don't want to discuss here, but I'll discuss. But anyway, you have taken sure that this person survive, but that is the only important. But this is the big issue, this is debate everywhere, and I hope that some amicable suggestion come where the things can be more looked into the
Sir, 1 minute. I am giving the suggestion.
सर अभी एक और भी यहाँ पर होने वाला है, तो आपका ले लेते हैं अभी.
Ordinary standard. It is the ordinary standard a human being could survive. It could be given by the nutritional or the doctor.
है ना सर, भी यही बात करें. तो हम इसके साथ ही आप सबका बहुत बहुत धन्यवाद देते हैं कि आप आए, और वी हैड वंडरफुल टाइम. वी ऑल डिस्कस टू ऑल द पैनलिस्ट. प्रोफेसर एल्लू मिलाई सर को स्पेशल थैंक्स. आरती फॉर द फॉर शेयरिंग योर आइडियाज थ्रू द एम्पेरिकल स्टडी. प्रोफेसर विनय रिप्रेजेंटिंग द जवाहरलाल नेहरू यूनिवर्सिटी राइट टू डेवलपमेंट, एंड ऑल्सो राजू माजी फॉर द indigenous people. Of course, Dinesh ji has brought a lot of issues in human rights, and we learned a lot of things today. Particularly myself, I have noted, and I'll go back. I'll try to write something, read, and come and meet soon next time. Thank you very much. Thank you.
We all convey thanks to chair for you can say giving this time and sharing the session.
So shall I begin?
Yes, please.
Okay.
Please.
Welcome and good morning to the 10th International Conference on International Law, Issues and Challenges, organized by Indian Society on International Law. This session is on Seas of Change, International Law and the Future of Maritime Dispute. Our first chairperson is Professor M. Gandhi, who is currently Professor and Dean at VIT School of Law, VIT Chennai. He has also served as Professor and Executive Director, Center for International Legal Studies in OP Jindal Global University. He is an accomplished teacher of international law. He has been a practitioner of international law and member of the legal team in the Ariel incident case 1999, decided by ICJ. He has participated in number of international conferences, working group on international law representing Government of India. He will be accompanied by Dr. G.V. Rao, who is a designated senior advocate by the Supreme Court of India, specializing in various branches of domestic and international law, constitutional law, corporate tax, and civil and criminal matters. He started his career at the Attorney General of India's office in 1986, and thereafter he continued as the government counsel for about 20 years and has been practicing in all courts of India as an independent counsel for about 31 years. He has been a recipient of number of national, international award and has published numerous articles, papers and edited books. This session will have about 4 to 5 speakers. Now I would request the chairperson to begin with the session.
All right. Good morning, all of you. Apart from my introduction there, I'm also Vice President of the Indian Society of International Law, which I've been, and I've been a life member for more than 2.5 decades. And I've done, there has been a lot of participation in international law, which is not reflected in my profile, which is about my professional, professional work. Now we can begin. I'm also a Rhodes Ocean Scholar in the law of the sea, which is held by the Rhodes Academy of Oceans Law and Policy in Greece, which is in the city of Rhodes, right? We'll talk more about that, but first let me see who all are going to be there with us. There's Bhavya Jain, Charvi Kohli, and Aditi, and your Prashishti Sarya. Why didn't you shift one place? I think Siali Chandrekar is not coming. Is she coming? Then my co-chair, Dr. Gandhi, is also not going to be here. So let's look at our program and begin with the first presenter in this session. And that is Siali is not there. Then Aditi. All right, we'll start with you, Aditi. Please take your time and please.
A very good morning to everyone. I hope I am audible. I feel gratitude to be here.
Put the mic a little up.
Yes.
Put the mic a little up. I think it is not completely.
Am I audible? Yes. So my name is Aditi and I'm a fourth year law student at Rajiv Gandhi National University of Law. And the topic of my presentation is envirolegal underpinnings of artificial islands and analysis. This paper majorly deals with this particular question, which is the exclusivity and the ability to construct any structure in the exclusive economic zone compatible with the progressions being made in the field of science and technology, or does it need rethinking? And in simple words, my argument is no, it's in negative, that currently the UNCLOS system is not in tandem with the science and technology developments. In simple words, the gist of my paper is that artificial islands are being constructed in the seas. They are being constructed by dredging the seas. Machines are going inside the sea and the subsoil is being extracted, and then more and more soil, more and more concrete is put forward, and it completely destroys the marine environment. However, the UNCLOS or the international regime does not take that into consideration. Moving forward, I would like to show you some pictures of the artificial islands of the world. The first picture, which is like zigzags, it's of Maldives. It's a floating island. Next to it is the picture of a Kansai airport, which is a Japanese airport giving air services to major cities like Osaka and Kyoto. And under it is the oil field of Kashagan. It's in the Caspian Sea. And the palm-like structure is the Palm Jumeirah of UAE, which is a luxury island that was constructed by the UAE with a view to boost tourism so that they can fund their oil extraction activities. Now, what are artificial islands? As the name suggests, these are the man-made island. They don't exist naturally. UNCLOS does not define it, neither does it confer any legal title to these kinds of islands, which is given to other naturally existing islands. These artificial islands have been there since the Egyptian civilization, though through cutting-edge technical processes such as advanced dredging, concreting, and land reclamation. Now the process has become even larger. More sophisticated islands are being constructed in various kinds of environments, no matter the depth of the sea there. Now, there might be multiple reasons for why artificial islands are being constructed. I have given example of Flevoland, which is in the Flevoland province of Netherlands. This whole province is constructed on an artificial island. The reason why this particular artificial island was constructed in 1968, it was a part of land reclamation project, which basically intended to give residence and recreation to the growing population, and at the same time to prevent flooding from a very prominent river therein. In 1994, Japan built Kansai International Airport, which is referred to as engineering marvel. And it is linked to the mainland Japan by a bridge providing air services to nearby cities of Osaka, Kyoto, and Kobe. The other reason for which the artificial island may be constructed is for bolstering geostrategical influence. For example, China. China is constructing land masses in the South China Sea for only reason that it wants to demonstrate its military will, and it wants to put it forward in the world that this particular South China Sea belongs to China through their theories. And then there are economic reasons for the construction of artificial islands. Like I've mentioned the Palm Jumeirah, and I've also mentioned the Kashagan oil fields, which are constructed in the Kazakhstan in the Caspian Sea. Then there's one good reason for construction of artificial island, that is sustainable energy infrastructure. Denmark has recently proposed construction of artificial islands for staging their windmills, because windmills require a lot of area, and artificial islands provide an alternative to using the land that can be used for the residential purposes of the country. Today's world is described as the age of artificial islands, according to a social geographer, Alistair Bonnet of Newcastle University. Basically, the prominence of the artificial islands, the construction has been there for quite a long time, but with cutting-edge technology, the process has even fastened. Now, what are the problems? There's this one beautiful quote from Small is Beautiful. It says, "The system of nature of which man is a part tends to be self-balancing, self-adjusting, self-cleansing, but not so with technology." With that line in the mind, I would like to point out to the marine ecosystem. It's a highly sensitive ecosystem. It's sensitive to the natural changes as well as man-made changes. Whenever land reclamation processes take place, they usually take place along the coastline, primarily affecting coastal and marine habitats. The coral reefs, which are regarded as the rainforests of the sea, are normally situated in warmer waters which are nearby the coastal regions and within the EEZ of the countries.
Take out one chair.
Dredging and subsequent sedimentation due to unplanned land reclamation has affected the Singapore most by destroying 60% of the coral reefs because of the land reclamation process. This terminology, land reclamation, basically means claiming the land back from the sea, marshlands, or other alike regions. The growing population along the coastal regions, which is supposed to double by 2050, basically translates into construction of more such kind of islands to accommodate the rising population. I have mentioned the example of Palm Jebel Ali, which is also a luxury island constructed in UAE. Due to its construction, 8 kilometers square of natural coral reef were lost. And this construction has further worsened the condition of already endangered sea turtles. I've also mentioned a 2021 oil spill in the USA, where an offshore facility was from where the oil was transported to the ports of the USA was spilled, and it affected the 2-mile necklace of eco-sensitive coastal marshlands. It should be noted that these marshlands serve as a rare feeding and rearing ground for nearly 90 species of bird. Throughout this conversation on environmental hazards, I just want to point out the impact these kind of activities have on environment by citing examples from in and around the world. Moving forward, I would like to point out on the lack of international regime on artificial islands. I have specifically mentioned 1972 Stockholm Conference's report, wherein in one of the annexures, general principles for assessment and control of marine pollution have been mentioned. And this particular principle, which I'll read out, is the development and implementation of control should be sufficiently flexible to reflect the increasing knowledge of the marine ecosystem, pollution effects, and improvements in technological means for pollution control, and to take into account the fact that a number of new and hitherto unsuspected pollutants are bound to be brought to light, which basically translates that our international regime has to be in tandem with the growing awareness about the environment, about the possible pollutants. Herein I have mentioned UNCLOS, wherein although Article 60 gives an exclusive right to the states to construct any artificial structure in their exclusive economic zone, which basically extends 200 nautical miles from the baseline, there has been one general obligation put on all the states to protect the marine environment. Article 193 recognizes states' sovereign right to exploit their natural resources pursuant to their environment policy. Now, specifically pointing out Article 208, it specifically obligates the coastal states to adopt laws and regulations to prevent, reduce, and control pollution from artificial islands. I have underlined it. From artificial islands, there's a general obligation. There's an obligation on states to harmonize the policies. There's an obligation on state to establish global and regional rules, standards, recommended practices, and procedures to prevent, reduce, and control pollution of the marine environment, referred to in paragraph 1, which talks about artificial islands as well. However, it's sad to see that there has been no such convention, even if artificial islands date back to Egyptian civilization. While there are multiple conventions on specific type of pollution in the marine environment, like the pollution from ships, pollution from dumping waste, there's nothing that specifically deals with the artificial islands. I have also mentioned the Equator Principles, which provide a risk management framework adopted by financial institutions. Basically, under this regime of Equator Principles, which is a non-binding regime, 38 countries have formally implemented the Equator Principles, which basically translates that banks and the financial institutions of these 38 countries will not fund the activities which are not conducted sustainably. They call for an independent review of environmental and social assessment of a project's impact by the financial institution. However, these principles, as I've already dealt, are mere guidelines and they do not see uniformity. Only 38 countries are part of it in a world where there are almost 200 countries. I have also mentioned one example from the Palm Jumeirah once again, wherein Nakheel Properties, which is a state-owned corporate, had constructed these islands. They followed the Equator Principles, but to an extent where the local laws lacked sufficient force to ensure compliance with the highest standards. Let's say Equator Principles state that you have to have a environmental impact assessment of this level, while the local laws say the environmental impact assessment should be of level which is lower than that. Obviously, there is a lack of implementation because local laws give a sort of leeway. Therefore, while the Equator Principles serve as an important overarching framework, their subordination to local laws acts as a major deterrent for sustainable practices. Moving forward, I have at the end called for an international cooperation and collaboration referring to Article 208 of UNCLOS. I have recommended call for an international direction having the following elements. Herein I have given that the purpose of the construction of artificial islands should be taken into consideration. Why I say so? Let's take the example of China, which is trying to construct an artificial island to stage a nuclear power plant, and compare it with the Denmark's example, which is constructing the artificial island for stationing the windmills. There's a difference. While the nuclear reactors are not only security risks, they are environmental catastrophe. Therefore, the purpose of the construction of artificial islands should be given due consideration. Luxury of the few should not be a reason for destroying the marine environment in and around. Then further, I have given the recommendation of a tailored environmental impact assessment, which basically means that since the marine environment is quite unique, there's a need of specialized knowledge, and there's a requirement that a special organization should be there that should basically uniformize the information. It acts as a interoperable institution. It provides a database of licensed firms which are capable of doing environmental impact assessment specifically for the marine environment. Further, I have given a recommendation for a need of an overarching organization like International Seabed Authority. Under the UNCLOS, International Seabed Authority basically oversees the deep sea mining, and that too beyond the EEZ. But taking cue from that seabed activities are being regulated, being supervised, there's a need of international body that acts as a supervisory body. Further, I have recommended for research on sustainable construction materials and practices. Like I've showed in my first slide that there are floating islands in Maldives which are not as harmful as the ones that are being constructed by completely destroying the marine environment, putting concrete in and completely destroying the marine environment. I have also cited an example of a specific island resort off the Ivory Coast, wherein a person has created an artificial island from the plastic waste. With this, I end my presentation on a note that there's need of a collaborative approach towards the artificial islands. Thank you.
Thank you, Aditi. Excellent presentation, and you have, concluded 1 minute before your time. It was up, and but you did a great job. We will discuss more of that. Thank you for the presentation. It's really insightful. It's an excellent thought about dealing with the environmental issues that are caused by artificial islands. So we'll discuss more of that, and there'll be a Q&A after this. So the next presenter is Prashasti Saharia on India International University. She's from India International University of Legal Education, Goa. So her paper is on From Surface to Sea Floor, Legal Frameworks for Marine Environmental Pollution. So over to you, Prashasti.
Yes, sir. Good afternoon to everyone present here. I'm Prashasti Saharia from India International University of Legal Education and Research, Goa. And my topic of research today is From Surface to Seafloor, Legal Frameworks for Marine Environmental Protection. So I'm just going to give an introduction as to why we're here, why we're discussing this in just 1-2 minutes. So maritime activities, as we all know and as the co-panelist already highlighted, are inherently global, with ships and marine vessels crossing international waters, whether it's for exploring the ocean's depth, as seen as in the infamous case of the Titan submarine, or enhancing international trade through ships like the Evergreens, or promoting tourism and entertainment with cruises. These advancements are notable. However, with these positive advancements, we get some negatives as well. And here I have added a quote which says, in an increasingly globalized world, the environmental impact of one event can ripple across ecosystems and communities far removed from the source. So here I have tried to show that according to these statistics, the global marine vessel market, we can see that there was an increase in the marine vessel market, except for in 2020, which went down because of COVID. But this basically just highlights that on what rapid speed we have been advancing towards this field. Next, value of marine environment. So marine ecosystems like coral reefs, mangroves, and seagrass beds are essential to ocean health. They support diverse marine life, act as natural barriers against erosion, and capture carbon, playing a key role in climate regulation. Beyond biodiversity, oceans provide livelihoods for millions, particularly in islands and coastal communities. So here I have listed marine pollution sources. Firstly, land-based sources, as we all know, agricultural waste and all of land mills and all of that would come under this. Next is industrial waste, which would include chemical waste and things like that. Next is plastic and microplastic pollution. Next is shipping and maritime traffic. Then we have offshore drilling and oil extraction. And then last, climate change and ocean acidification because of global warming. So marine plastic pollution is flagged as a major threat by the 2019 IPBES assessment, which warns us that it has increased tenfold since 1980, affecting at least 267 species, including 86% of marine turtles, 44% of seabirds, and 43% of marine animals. According to the same assessment, there has been an estimated 3 million sunken and advanced vessels in the ocean, and over 8,500 are classified as potential polluting wrecks, and the majority of these contain chemical pollutants in them, along with 6 billion gallons of heavy fuel oil, which we can imagine to what extent it will affect the marine environment. So here I have highlighted the international conventions. I have divided them in two parts. First, the core ones, which first I have mentioned UNCLOS, which is United Nations Convention on the Law of the Sea, which provides us the primary legal framework for marine conservation, focuses on pollution prevention in exclusive economic zones, EEZS, and on the high seas. Next, we have the MARPOL, which is the International Convention for the Prevention of Pollution from Ships, which covers pollution by oil, chemicals, garbage, sewage, and air pollution from ships, with 6 annexes addressing specific pollutants. Next is the London Convention and Protocol, which prevents dumping of hazardous materials at sea, focusing on controlling industrial and radioactive waste disposal. Next are the additional marine protocol protection treaties that I have added here. First is the International Convention on Oil Pollution Preparedness, Response and Cooperation, OPRC. This basically enhances global coordination and preparedness for major oil pollution incidents, providing protocols for hazardous materials. Second is the Ballast Water Management Convention (BWM), which prevents the spread of invasive species via ballast water from ships, protecting marine biodiversity. And last is the Regional Seas Conventions, which include conventions like OSPAR, HELCOM, and all of those. And these include regional treaties. And these are marine protection they target localized marine protection issues, supporting international frameworks like UNCLOS. So from my analysis, from what I could tell, that all of these conventions were lacking. So these I have listed here. Firstly is the inadequate coverage of pollution sources. In all of these frameworks that I have discussed, like UNCLOS, these focus primarily on marine pollution from ships, but they lack strict provisions on land-based pollution sources such as land mills or maybe agricultural resources, which contribute about 80% of the ocean pollution. The Global Program of Action, which is GPA, addresses land-based sources but remains a non-legally binding agreement which limits its enforcement. Next is the complex jurisdictional overlaps. Multiple regulatory bodies such as the International Maritime Organization and the United Nations Environmental Programme (UNEP) manage different aspects of marine protection, causing jurisdictional overlaps and sometimes inconsistent enforcement across regions. This weakens the overall cohesion needs for global marine regulation. And next is plastic and microplastic pollution. Despite high-profile agreements like the UNEP resolutions on plastic waste, international binding agreements specifically targeting microplastic pollution remain limited. Plastic litter continues to accumulate due to inadequate waste management infrastructure, especially in regions with growing economies. So here I have mentioned some solutions that I'll be elaborating on. First is a legally binding global agreement on land-based pollution is required, which is adopting a legally enforceable framework that targets land-based pollution. As I highlighted before, there is not enough emphasis which is placed on land-based pollution. So land-based pollution would address a significant gap in existing protections, building on the GPA's initiatives. But with enforceable commitments, it could ensure stricter regulations and encourage national action against pollutants like plastic and agricultural runoff. And how to go about it is that establishing a binding agreement similar to the Marpol Convention, targeting land-based sources like agricultural runoff and plastic waste would be nice. Nations would commit to national regulations and standards that align with the treaty, supported by periodic reviews and progress reports. So this is for the first one. Secondly, streamline jurisdiction through a unified ocean management body, which would include consolidating oversight roles of organizations like the IMO, UNEP, and the Regional Seas Program under a unified global body, and that would improve enforcement consistency. This approach would also enable coordinated action on global and regional scales for various pollution sources. And the approach towards this would be the IMO or UNEP could be expanded, or a new body could be created to unify ocean management tasks. This organization would coordinate regional and global enforcement with clearly defined roles for managing marine pollution, fisheries, and marine biodiversity. So the steps to go about would be that first, a feasibility study would outline responsibilities and the resources needed by the particular countries. Next, member of the nations would agree on funding and they would decide on the jurisdiction. And the new or expanded body would take over the integrated enforcement of existing treaties like the UNCLOS or the Marpol. Now, next is the Global Treaty on Plastic and Microplastic Management. So, a globally binding treaty on plastic and microplastic pollution could address the entire life cycle of plastic from production to disposal, and this would include provisions for improved waste management infrastructure and extended producer responsibility, which requires manufacturers to manage their products' environmental impact. And the approach towards this would be to by implementing a treaty that sets plastic production limits, mandates biodegradable alternatives, and holds producers responsible for the entire life cycle of plastic products, similar to the extended producer responsibility, that is the EPR approach. And for this, the countries would collaborate with the UNEP to draft a treaty setting clear targets for waste reduction and recycling. Support programs would also provide infrastructure funding and technical assistance to developing countries. Additionally, the treaty incentivizes companies that innovate in sustainable alternatives. I would also like to highlight some more key points on the implementation support for all of these solutions that I've given. Firstly, would be financial aid and technology transfer, which would include providing financial and technical assistance to countries that may struggle with infrastructure or enforcement capabilities. Second would be global reporting and accountability mechanisms. So for this, like the Paris Agreement, solutions can include mandatory progress reporting with transparent assessments to ensure compliance and to allow for necessary adjustments. And thirdly, there can be collaboration with private sectors and maybe NGOs. So partnering with industries and environmental organizations to implement technology, raise awareness, and help with monitoring, this will help as well. And this approach will combine a clear regulatory steps with international cooperation, targeting funding, supporting infrastructure, and making it feasible and adaptable across different countries and economic contexts. So here, for a conclusion, I have added a quote: "Just as a ship leaves behind a wake on the surface of the ocean, so too do incidents that affect the marine life, leaving invisible wakes that ripple across the globe, affecting the ecosystems and lives far beyond the immediate site of the damage." Thank you.
Excellent presentation, Prashasti. Really impressive for all your recommendations that you have provided for marine pollution. We'll talk more about her presentation after. Well, then we go to the next presenters, Charvi Kohli and Bhavya Jain. If you would like to come this side, and do you have a chair? Maybe you should, just move over to this side. Can you just shift her placard as well, so that you don't have to. You're not blocking the. From or even Shruti can, that's right, so that we have enough space. And I think we should shift our chairs because it's too close to the podium. The last chair is too close to the podium, so just shift a bit. Right. Okay. You can start. Please. So the next presenters, Charvi Kohli and Bhavya Jain. Over to you. Navigating the depths, regulatory challenges and implications of maritime autonomous vehicles under the law of the sea. And some of you, you can always call it UNCLOS. We are always used to calling it UNCLOS. You don't have to say UNCLOS and all of that. So over to you. Your time starts now, right?
Good afternoon to everyone present here, the audience, my co-panelist and chairperson, Sir G.V. Rao. It's an honor to present our paper amongst you all. Now, just to introduce the topic, now these ships that are maritime autonomous vehicles, which our paper is currently based on, these emerged just as a mere concept to what were known as ghost ships. It was just a mere idea of how would ships look like without any humans in them. Then this gained popularity in 2003 and 2004 when US for the first time used its unnamed underwater vehicle during its Operation Iraqi Freedom 2003. Since then, there has been evolving and the focus has been shifted from commercial and transportation use to now military and intelligence gathering. Now, how do these maritime autonomous vehicles operate? So they are operated remotely, and the function is to navigate, monitor, and assist maritime autonomous vehicles remotely, locate them. They can be located on another ship or even in another flag state, which again is a issue which needs to be addressed, because then a jurisdictional issue comes into play. Then, as we know that there are various pros and cons attached to it. Yes, there is a remote operation. It's easy to manage, and it also saves human lives, because in case of emergency and collisions, the human lives are not at stake here. However, there are a lot of cons that are in play here. There is a legal ambiguity. There is no uniform definition of maritime autonomous vehicles, whether they are ships, vessels, or warships. We don't know. There is no clarity among that. Then there is a surveillance risk, terrorism potential, and trafficking issues that needs to be catered. So there are three main issues which I will be highlighting upon. First is, how do we categorize maritime autonomous vehicles under maritime law? Second, what is their legal status? Third, their liability. Who will be responsible during the time of collision? Whether it's the person who made these vehicles, whether it's the state, or whether who are operating these systems. Now, I would just discuss the legal frameworks that are into the play here. First is the UNCLOS. It came in 1972, a time when ships generally had humans in them. So, at present, there is a debate as to its extended applicability, whether it's applicable to the MAVs or not. So it does not explicitly define ships, it's used interchangeably with vessels. Also, moreover, Article 94 of the UNCLOS requires the presence of a physical crew, which conflicts with fully automated or remotely controlled MAVs. This discrepancy highlights the need for updated regulations to address modern maritime technologies. Secondly is our IMO regulations. The IMO, however, makes no distinction between the traditional ships and MAV and says that both can be governed by UNCLOS and IMO treaties, which are SOLAS, SAR, COLREG, GAPS, etc. Thirdly, IMO has currently a regulatory scoping exercise which aims to tackle this problem. They are evaluating the existing laws that are there, and they are identifying the loopholes that are existing here. They have drafted a non-mandatory code, and this transition from a non-mandatory code to a mandatory code is supposing to be happen in 2030. So by 2030, we can expect to have a separate code to govern and regulate maritime autonomous vehicles. Now, what is the legal status of maritime autonomous vehicles? Whether they're ships, warships, what exactly is their status here? Now, the absence of a uniform definition of ships and varying domestic interpretations complicate matters. Since every state has their own definition of ships and vehicles, that further complicates the matter here. For example, I've cited the definition of India and Korea. India's definition does not mention wing and ground craft. However, Korea's definition mentions that. So here, in case of a dispute that arises, then there is a potential jurisdictional conflict that challenges the admirability law. Now, MAVs as warships. Some researchers argue that MAV could potentially fit the conventional definition of a warship under Article 29 of UNCLOS when applied in armed conflicts. This classification would grant these vehicles sovereign immunities, potentially enabling illegal surveillance and espionage. Further, their submarine tourism is another emerging problem, as my co-panelist highlighted the Titan incident. So there is a regulatory gap because there is a lack of binding international regulation for submersible operations. Secondly, there is a safety concern because potential emergency situations can emerge. Then certification issues. There needs to be a proper certification check that needs to be done to manage and prevent such collisions and emergency situations. Then classification.
So, just to conclude my part here, there should be a uniform definition so as to ascertain the legal status of MAVs here. There should be safety standards, there should be a proper certification criteria that should be mentioned to manage their control. Then accountability, who should be at the end of the day liable in case of collisions or accidents. Then, of course, there is an international collaboration and cooperation that is the key here to regulate them. Now, over to my co-researcher Bhavya.
I'll be dealing with the use of MAVs in peacetime, that is intelligence gathering and surveillance. MAVs have served efficiently in collecting intelligence and doing surveillance that it has become easier than ever before to monitor maritime activities and improve situational awareness about them. The MAVs cover a large area since assisting in detection of illegal activities like smuggling, piracy, and unauthorized fishing. As they can operate without human beings on board, their inherent capacity for real-time data collection and analysis minimize risk to the people involved. MAVs have advanced sensors and communication technologies that enable them to collect vital intelligence. They help understand the sea environment by collecting data on it, monitoring shipping traffic, and analyzing maritime conditions. The importance of maritime situational awareness are comprehensive monitoring, rapid response, and informed decision making. The advantages of MAVs for peacetime surveillance are persistence, versatility, and cost effectiveness. Since no humans are involved on board, and there's least risk of cost because no human can die even if they want to go below the sea level also. The application of MAVs in law enforcement are border patrolling, search and rescue operations, illicit activity monitoring, and environmental protection. In the cooperation of MAVs in peacetime missions serves numerous purposes like search and rescue operations, environmental monitoring, as well as maritime law enforcement. Adding MAVs in non-warfare activities endorse different activities such as looking for lost people and analyzing the environmental conditions or ensuring that our oceans are safe by shrinking down into little pieces, thereby making it very easy for them to look up for anything in these usually vast areas. The legal framework governing the use of MAVs for intelligence gathering is primarily regulated by the United Nations Conventions on the Law of Seas. Article 17 of the convention states that ships from all the countries have the right of innocent passage through territorial seas, while Article 19 of the same convention explains the innocent passage means navigation which does not pose a threat to the coastal state's peace, good order, and security. Notably, Article 19, Clause 2 enumerates activities that would render passage non-innocent, including any act aimed at collecting information detrimental to the defense or security of the coastal state. The persistence monitoring of the maritime activities as there is continuous surveillance, autonomous coordination, and adaptive response. Even if if we use these MAVs, we could identify that smugglers. We could also identify smuggler. In particular, there are countries who are signatories to migrant smuggling protocols that can greatly benefit from the employment of maritime autonomous vehicles for surveillance of complete their commitment to provide information regarding smuggling routes and transportation techniques. In particular, exchange of scientific and technological information that has benefit from prevention as well as detention, investigation, and prosecution of criminal acts is demanded, which enhances each party's ability to prevent, detect, investigate, and prosecute people involved in smuggling. This obligation faces domestic legal restrictions, especially with regard to sensitive commercial and military aspects regarding MAVs. If smugglers utilize MAVs in transport irregular migrants, these vehicles would be likely be classified as vessels or ships due to their size and functionality, according to Article 8, Clause 7 of the Migrant Smuggling Protocol. An MAV suspected of being involved in a migrant smuggling could be treated as a vessel without nationality, allowing state authorities to board and search it in accordance with legal existing framework. The future of the MAVs in peacetime operations are expanding the capabilities, increase collaboration, and integrated system. The next thing I'm going to deal with are the flag nations. Flag states are fundamental components in legitimacy before international standards and regulations of vessels that fly their flags. Autonomous MAVs make a significant transformation in maritime operations, presenting both opportunities and challenges for flag states. The evolving of the maritime landscape, that is the automation, connectivity, and sustainability, poses certain legal challenges for flag states. There are opportunities as well. There are risks as well. The emergence of maritime autonomous vehicles prevents significant regulatory challenges for flag states as they navigate the responsibility within existing legal framework. The jurisdictional issue complicates enforcement efforts while raising questions about liability and compliance. Enforcement efforts while raising questions about liability and compliance with international standards. As nations continue to invest in autonomous technologies, there is an urgent need for comprehensive legal framework that addresses these complexities while promoting safe and responsible use of MAVs. There are gaps in the regulatory framework, that is the unclear jurisdiction, safety and liability, and environmental concerns. The recent developments in these UMVs are that Singapore has begun testing its surface MUV, specially meant for patrolling the vital maritime corridor, that is the Singapore Strait. And the US Navy is planning to deploy it into its fleet exercises starting in 2021, a medium-sized MUV called the Sea Hunter, which specializes in submarine tracking. The Israeli aerospace industry (IAI) has unveiled its latest innovation in maritime technology, the Blue Whale. Blue Whale, a large autonomous vehicle that is set to revolutionize the underwater operations. Blue Whale can conduct illicit intelligence gathering above the sea surface, detect submarines and other undersea targets, gather acoustic intelligence, and search for and identify naval explosives on the seabed, just like human submarines can. The legal challenges that arises since the underwater vehicles remain unregulated in the international law. These days, unmanned ocean-going machines have become a significant aspect of contemporary naval operations and maritime security, especially underwater vehicles. The autonomous marine vehicles stand at the forefront of revolutionizing the marine industry. The lack of international regulations for autonomous underwater vehicles are like territorial disputes, safety and liability issues, the environmental risk, the dual use concerns. The the United Nations Convention on the Law of Seas serves as the foundation of the international law of seas. Yet it does not provide any clear definition of what actually constitutes a vessel or a ship. While large torpedo-shaped underwater vehicles may meet the common perception of a ship, their autonomous nature and the lack of human crew creates uncertainty regarding the legal classification. For a vessel to be recognized under maritime law, it must be registered with the state and meet specific size and structural criteria. I would just like to conclude by saying that autonomous marine vehicles hold immense potential to transform various sectors. In maritime transportation, they stimulate streamline logistics, making shipping safer, faster, and cost-effective, ultimately boosting trade and supporting economic growth. Beyond transportation, these vehicles can assist in search and rescue missions, maritime surveillance, scientific research, and underwater exploration, providing valuable data for researchers and security agencies. Overall, the future of autonomous marine vehicles promise a safer, more efficient, eco-friendly marine industry with wide-ranging applications that significantly impact our world. Thank you.
Thank you. Thank you. Bhavya, both of you, what an excellent presentation. Of course, we can talk about all of this a little later. Let's finish our business for today. We have, in addition to our, what was there, all those who have... thank you. In addition to the presentations that were made and listed in our program, we have two others who would like to make presentations, and we do have a little bit of time for that. And that is, one is Shruti. Shruti, please introduce yourself, because we don't have an introduction in the program. And of course, she will speak on environmental impact assessment of deep seabed mining. And her presentation is called An International Legal Analysis.
Thank you so much, sir. So good afternoon to the chairperson, my co-panelist, and dignitaries on and off the dais. So my topic that I'll be presenting on is EIA of Environment Impact Assessment of Deep Seabed Mining and International Legal Analysis. So
you haven't introduced yourself. Where are you from? Yes, please.
I'm a PhD scholar from VIT AP University, VIT AP School of Law, currently researching on law of the sea and biodiversity beyond national jurisdiction. So with your permission, I would like to continue. Yes. Deep seabed mining has been promising to all the countries in the world. However, the issue of environmental protection needs to be really traced in this scramble for minerals in the deep seabed resources. So, if you look at the political struggle that has happened with respect to deep seabed mining, and which reflects into the legal frameworks as well. During the 1960s, the international communities witnessed independence of a lot of nations, third world nations, because of which they could find a voice in the international law. And in 1967, Arvid Pardo, the ambassador of Malta, he introduced this concept of common heritage of mankind with respect to the governance of jurisdiction beyond the commons beyond national jurisdiction, which is the seabed. So after that, in 1970, a declaration was adopted in the General Assembly, which on deep seabed mining, where this concept of common heritage of mankind was accepted. However, the politics becomes very important, and it impacts the legal frameworks as well. So US was not very it did not the establishment of an international seabed authority, which had been advocated a lot by developing countries, had not been acceptable for US, and because of that it did not sign UN clause. And then we saw an implementing agreement to be adopted later to cater to the demands of US, so that it could continue seabed mining in future. Now, how it reflects in the legal regime today, and how it has impacted the environmental protection today, that I'll be highlighting. So it reflects in the structure of the International Seabed Authority itself. So if we see, International Seabed Authority has assembly, council, secretariat, and tribunal. These bodies are there, and all the countries who are party to UN clause are part of the General Assembly of International Seabed Authority as well. However, if we look at the decision making, and UN clause says that it mandates that for any decision on substantive matters has to be decided via a consensus based mechanism under the council. Now, council has 36 members, and the decision making process with respect to rules, regulations, and procedure. Let's say if international community wants to come up with a framework on international environmental protection or marine protection or environment impact assessment, they have to come up with a consensus, and it is not formal voting system. So that means that, and if even one of the nations in the council does not agree to the rules, these proposals, or any kind of decision for environmental protection, then it will go to a conciliation process, and the whole negotiation process will go, and finally again to counterbalance all the interest, a framework would come. Now, my argument is that this is a dilution of environmental protection interest. So international law has been reflective of these conflicting interests throughout, and somehow it has been going forward accommodating all the interests. So this consensus based system has been something that has continued through the past, and it is a problem still. Now, in 2021, an interesting development had happened, that Nauru is a country, a small island country, which has given an application for a 2-year rule. 2-year rule simply says that if the ISA doesn't come up with a mining code, then it would have to accept its proposal for Nauru to continue deep seabed mining. Now, Nauru has been intending to conduct deep seabed mining with an international corporation, which is Canadian based company. Along with that company, it is expecting to conduct this mining. However, such a mining code has not been adopted till now, and this invocation of the 2-year rule in itself presents a lot of problem with respect to environmental protection, because it is rushing the ISA through adopting some kind of framework for environmental protection, which will be very harmful in future, because and I'll be explaining why it will be harmful in future, because we have a lot of developments have happened, and a lot of knowledge has been revealed with respect to how vulnerable the ocean ecosystem is and how vulnerable the marine ecosystem is. So currently, there is a legal vacuum with respect to environment impact assessment, if you talk about it. So the current rule is UN clause, which talks about environment impact assessment, and that will apply. And second one is the implementing agreement of the Part 11 of the UN clause. Now, as far as implementing agreement is concerned, I talked about ISA and its consensus mechanism, the Council's consensus mechanism, which is creating a problem and would create a problem for environmental protection. Secondly, now if you talk about UN clause, so UN clause Part 12 talks about protection from pollution of the marine environment. Now, a lot of development has happened since UN clause was adopted. We have UNFCCC. We have BBNJ now, Biodiversity Beyond National Jurisdiction, which has really expanded the principles and the consideration we need to give with respect when we interact with the oceans. Another development that has happened is the ITLOS judgment, which really represents, if we see, this is a group commission of small island states on climate change, which has because it is so vulnerable and they are so directly affected, they have filed this case not only before ITLOS, it is pending before ICJ as well. And ITLOS has given a very important judgment with respect to it. And since BBNJ has come, the issue of this aspect of synergies between BBNJ and all areas, other areas of law like climate change law and and other areas of law has come up with, and it needs to be addressed. Now, if we do a synergistic reading, the ITLOS has actually expanded the meaning of pollution and said that states do have a responsibility under UN clause itself to give a wider meaning to pollution and to think about environmental consideration, climate change consideration as well with respect to ocean acidification and protection of marine environment. So we when we think about EIA mechanism, it cannot be a simple mechanism, but we have to look at into a broader perspective as well. It cannot be narrow now only with respect to coming, it's not just going through a process, but we need to have a wider understanding, thinking through, really understanding the impact that will be in the environment and whether there is an opportunity to go back on it or to balance it out or not. If there is none, I don't think we are in a time where we can just be take preventive measures. We have to take precautionary measures because the IPCC data also clearly shows that the oceans have been badly affected by climate change, and the whole debate has shifted to how oceans have been impacted because they're sequestering a lot of carbon dioxide from the atmosphere. So we really need to, the debate cannot be simple with respect to environment impact assessment. So in my paper, I will be discussing about these things in detail. So thank you so much.
Thank you, Shruti. You've touched upon some really important issues that are arising. Now I'll invite Akhil Srivijay, who is going to speak on the convenience of arbitral mechanism in UNCLOS. Please introduce yourself, Akhil. Where are you? Where you're from? And you will get about 10 minutes to make your presentation. Yeah.
Good afternoon, everyone. Good afternoon, everyone. I'm Akhil Srivijay, a first-year student at School of Law, BML Munjal University. Today, I will be presenting Dr. Sudhir Verma and Ms. Sania Khanna's paper titled The Convenience of Arbitral Mechanisms in UNCLOS, a theoretical reflection on the fragmented regime in preserving the global commons. So moving forward, I will be voicing the work of Dr. Verma and Ms. Khanna. Historically, the capitalist tides have swayed the international lawmaking process, and gradually this has led to the practice of commodifying the common heritage of humankind. A possible explanation for this, we argue, might be the absence of international law of spaces or the overbearing influence of neocolonialism in liminal spaces. The effect is such that today there is no common heritage of mankind. Common heritage of humankind has become a medium of manipulation, maneuvering, and a style of argumentation that sugarcoats capitalist agendas in the name of either development or sustainable development. This paper briefly touches upon one such aspect of what we now call as a common heritage of, and that is the deep seabed. In particular to the law of the sea, the narrative of commodifying global common ocean is not new. For instance, the continental shelf. The conception and the determination of the rights and obligations of states vis-a-vis the continental shelf are a testament to the capitalist agendas that shaped, influenced, and formulated the continental shelf as we know and claim it today. A reference to this is the discussion regarding the continental shelf during UNCLOS meetings, especially the US position. In the 21st century, this becomes even clearer with the prevalent practice of investors vis-a-vis the area. Conceptualized in part 11 of the UNCLOS, the area refers to the seabed beyond national jurisdiction. It therefore belongs to no one and yet belongs to all. The UNCLOS systematically imposes several layers of safeguards to protect the area. To name a few, due diligence obligations, environment impact assessments, no harm principle, ecosystem approach, among others. However, as many scholars have highlighted in the past and continue to do so, all of these layers of safeguards stand defeated to market forces, bourgeoisie interests, and value for money. The International Seabed Authority, or more specifically, the defunct Enterprise, the primary authority responsible to protect, preserve, and manage the activities being undertaken in the deep sea bed, is no exception to this. To make matters worse, we contend the sustainability narrative, manifested in the form of blue economy, has marketed the area as a new age gold mine, a mine that can help transit towards a low carbon economy and helps in realizing the long-standing view of UNCLOS, that is, the stipulation that the area must be used for the greater good, that is, for all mankind. The sustainability narrative, as per some, such as Nauru, Maldives, and even the ISA, see this possible through deep seabed mining for blue economy. The development of blue and green economy has thus diverted investments in harnessing the so-called renewable sources of energy, which as per report suggests the need for rare earth minerals will increase 450 times by 2050. This has led to the proliferation of mining activities in the area. Consequently, investors have developed a habit of plundering the rare earth minerals, lithium, cobalt, and manganese nodules under the garb of unsustainable development and blue economy. The problem lies in the need to preserve the environment and mitigate climate change due to the disastrous effects of it, such as the sea level rise. This has given rise to many disputes regarding deep seabed mining. With the dysfunctional enterprise and limited role of the International Seabed Authority, we argue that the plethora of alternatives regarding resolution of disputes is through the default mode of resolution in UNCLOS, that is, arbitral mechanism. This is evident on reading Article 187(c)(1) with Article 188(2) of the UNCLOS, and this can either broaden or limit the scope of arbitrations. In the former case, an arbitral tribunal is empowered to interpret and enforce the contract, including the mining code, and Annex 9 and 10 of the 2018 draft regulations which impose standard contract terms. On the other hand, in the latter case of limited scope, arbitrations can only be undertaken to preserve the legitimate interests with respect to acts or omissions of the party vis-à-vis any activities in the area. Consequently, the International Seabed Chambers get the primary and exclusive jurisdiction. Under this legal framework, the current approach adopted in seeking compensation against expropriation and FET, as we will highlight, makes preservation of the global common a utopian notion. Cases like Nautilus Minerals Inc. versus Papua New Guinea and the ongoing disputes involving the Ocean Minerals LLC in the Cook Islands underscore this trend. In Nautilus versus PNG, the arbitration panel focused on enforcing the government's financial obligations to the investor, disregarding the project's ecological risks and local community protests vis-à-vis the activities being undertaken to extract rare earth minerals from the deep seabed. Similarly, Ocean Minerals LLC has challenged the Cook Islands' imposition of stricter environmental standards, arguing that these requirements breach their investment agreement. These cases reveal a clear investor-centric orientation where capital continuity is protected at the cost of ecological safeguards, particularly when regulatory changes are deemed to infringe on investors' expectations. This pro-investor bias is also evident in other scenarios, such as the metal company's joint venture with Tonga Offshore Mining Limited, which pressures local governments to limit restrictive environmental regulations. Arbitration decisions like the Chagos Marine Protected Area arbitration further emphasize sovereign and capital interests over ecological protection, aligning with the Marxist critiques that these legal mechanisms operate to safeguard investor profits and sovereign resource control, often sidelining sustainable governance. These few case studies we highlighted illustrate that merging an inherently capitalist regime, that is investment arbitration, with UNCLOS, a regime meant the global commons reduces perishable global commons to a mere market commodity. The nature of investor-state arbitrations to a favor investor and investor rights is well known and contended, and its presence as a default mechanism of resolution in UNCLOS does not do much in actually moving towards sustainability. Rather, it promotes a practice of neocolonialism in liminal spaces. And therefore, from a Marxist perspective, this emphasis on protecting money and money's value aligns with neocolonial practice. By using arbitration as a default mechanism for dispute resolution under the UNCLOS, corporate interests are being placed superior to environmental safeguards meant to preserve these global commons. The blue economy narrative becomes a convenient vehicle to justify this extraction, where multinational corporations, backed by favorable arbitration rulings, pressure small island nations or developing states to limit their environmental regulations to secure investment and reignite the cycle of exploitation of the periphery. Thus, arbitration facilitates a neo-colonial exploitation of seabed resources, transforming what is supposed to be the common heritage of mankind into a new frontier for capital accumulation at the expense of environmental sustainability and the sovereignty of nations with limited economic leverage. Thus, we conclude that the default arbitration mechanism circumvents the mandate of the UNCLOS, that is preserving and protecting the area, and succumbs to the pressure of the new age colonizers, the transnational corporate class. Thank you.
Thank you. Thank you. So now we've got some amazing presentations on the international law and future of maritime disputes, our session here. So just to give a quick wrap up of what all we've discussed in the evening, and then we will go into a Q&A and comments section of our... there is an announcement. Who wants to make an announcement? Whoever should make an announcement. Some announcement is to be made, yes. Please. So we are just wrapping up at 1 o'clock. Okay.
I would like to invite our Vice President, Sir, Professor Dr. Manoj Kumar Sinha, Sir, to felicitate our Chair, Dr. G.V. Rao, Vice President, ISIL.
Lovely. All right. Sorry. Well, I think this was at the beginning, so they just came right in before we all rise for lunch, and we will be on time for lunch. That should not be a problem, I think. So just to get get a quick review of the presentations of this afternoon. Aditi did a great job with her presentation on enviro-legal underpinnings of artificial islands, and she analyzed all the artificial islands starting from Palm Jumeirah and the islands in Singapore and other such things, and the kind of impact that it has, and these are not regulated, and the UNCLOS also perhaps did not deal with them because it was of 1972. So that's a very important issue, because a lot of countries, the EEZ, which is of 200 nautical miles, they think they are free to do everything, and it's also polluting the marine environment and the ecosystem, and it's creating ecological imbalances and such problems for not only the coastal state but all other states around that area. Then Prashasti, who presented her surface to seafloor legal frameworks for marine environmental protection. She spoke about the kind of drawbacks that come from like even land pollution, which are not addressed, and that we need to address that. And she's provided some solutions about how to have a global treaty mechanism by which we can deal with these issues, and even the shortcomings that IMO and UNEP are there, those have to be looked into, and some kind of global reporting must come. So as we all know, the UNCLOS is of 1972 and negotiated till 82. Of course, it came into finally sometime really in force somewhere in 1994. But technology has moved so fast, and if you for all of you who know that Avid Pardo, the Maltese diplomat, Malta is a small state. It's in the middle of nowhere, in this middle of Mediterranean, and he called it the common heritage of mankind. So I think that aspect of common heritage of mankind has to be kept in mind when we deal with all marine issues, whether they be disputes, whether they be ecological protection, environment, etc. And therefore, this aspect has to be really addressed properly, because since the UNCLOS may get reviewed, and you may start having a newer regime by 2030. But anyway, the solutions and the issues highlighted by all of those who spoke here have been so excellent and pointed. Then we had Charvi Kohli and Bhavya Jain, again an excellent presentation on the regulatory challenges and implications of maritime autonomous vehicles under the UNCLOS. Now this again was never addressed when the UNCLOS came into existence, and this requires absolutely adherence apart from the fact that submarines were there, but then the autonomous vehicles are just like your drones, and they create issues regarding not only pollution but disturbance of the marine environment and also security issues. Personally, if you see us that we narrowly missed Sayali, or we actually miss Dr. Sayali Chandrakar's thing about the diplomacy. Neighboring countries are very, very, they're vigilant about the protection of their high sea, not only their exclusive economic zone, but the areas of how the high seas work, and also fishing. Fishing is an issue which get disturbed by these marine autonomous vehicles. So that was also to be addressed, and which some of which has been highlighted by both Charvi Kohli and Bhavya Jain in their presentation. It's been a very, very revealing presentation. Then we had Shruti, I think Shruti, who spoke about the environmental assessment, impact assessment on deep sea mining. Now, as you know, the International Seabed Authority, which deals with all of these issues and is located in Jamaica, it has a whole, it has an whole architecture of how to deal with that. But I don't know how much headway we've made in recent times. Some of you can actually add that, but they should be looking at these issues, because when we even whether it is autonomous vehicles or artificial islands, and all of these have an impact on the seabed, and of course the commercialization regarding deep sea mining, the nodules, magnesium nodules, and all of these issues can be addressed by the International Seabed Authority, and we some of us are not aware of their proceedings, and we must look at the environmental impact assessment. And also there were some judgments by the ITLOS and the ICJ after the BBNJ, which has come into existence recently. And another interesting presentation by Akhil Srivijay about his those people from his institution who were representing about how to create the arbitral mechanism and how it's been functioning with respect to, again, corporate interests of the marine resources. And can we look at arbitration as a good solution, because private investors would like to use arbitration, mediation, and such like forums which are not formal, which like the ICJ and the ITLOS, etc., and how effective they are in bringing about some kind of solution between various competing interests. So this has been broadly the whole gamut of discussions which we've had regarding the future of maritime disputes, and these are the areas which are of concern, which require attention, and some of you have recommended a treaty or a debating a debate that ought to be initiated of the issues that have been highlighted, and the international legal framework ought to take into account these things which are rather serious, pressing, and rapidly growing, and rapidly being creating the several kinds of difficulties in the law of the sea regime. So I will open the floor to discussion and some Q&A and any comments, if you please. So anybody who wants to either ask a question, make a comment, Any one of you here? Madam Jambolkar, our senior most. I mean, of course, she's a private international law person. Banerjee, Chaka Banerjee is one of our pillars and real senior members of the Indian Society of International Law. Would you like to ask a question or make a comment, or the question, but an observation? Oh yes, please. Please, somebody hand over the mic to others who are here.
Yeah, thank you very much, sir. And it's only in small observations with regard to the papers presented by the our young panelists, and it's absolutely very happy to and delighted to see that youngsters are picking up the traditional areas of international law, that is law of the sea, and the topics are very wide and very nice, and they are taking different aspects of law of the sea. The first thing is that the interconnections which Shruti as well as I think Prahasti has done is a wonderful job, because the kind of interface between BBNJ, law of the sea and climate change is very, very topical today. And what we generally discuss, that law of the sea somehow it's missed the opportunity of discussing the protection of the ocean resources from the increasing climate change, and also ocean acidification and mining and all these activities, and we need to look at that. And these papers, our students have done a good job. And when it comes to the other papers, it's a very interesting papers. But the only thing which I could see that we want to bring that some anchor point, and we need to look at that the traditional approaches, and also without compromising on the fundamentals of law of the sea convention. And what we consider today is that the law of the sea and the newly adopted convention on BBNJ are considered as one of the important foundations after long work has done the international community. But now when the new approaches are coming, particularly the non-state and non-state entities, how we are going to expand these rules and govern those non-state entities are very important. So our presenters, if they can work on that one, that is a very, very good point. And this is only my observation, and I congratulate all of them, and I'm very happy. It's a learning experience for me as well. Thank you so much.
Thank you. Thank you, Chekka, Dr. Chekka Banerjee. Now, if there's anybody, even those who are present on the dais, if they want to comment or ask a question from their co-panelists, they are welcome to do that. Commander Saab, would you like to make any observation or ask a question? Can somebody give him the mic?
The presenter who presented the maritime autonomous vehicle must also highlight, although they had touched upon the security issue, but they have a tremendous security issues, and the navies are faced with this problem like the army is facing the drones. So the maritime autonomous vehicles is a big challenge for the navies to counter.
That's good. Yeah, that aspect I also pointed out, that it's a massive security problem, and probably the first presenter, Dr. Sayali, may have been able to touch it, because her paper was on geopolitical analysis with the neighboring countries, and the autonomous vehicles are a big threat to security in the current scenario. I'm happy that Dr. Chekka Banerjee pointed out about the non-state actors. Piracy in the waters, Middle Eastern areas and from Somalia, etc., have been a great threat. And they not only piracy in terms of capturing ship and taking the crew to ransom, but they also try to destroy ships and create oil spill and other kind of difficulties that we see in which affect marine pollution, etc. Now, those are issues again which we must look into. As all of you know, that international law basically started with the law of the sea. Hugo Grotius, the father of international law, was an expert or he was the founder of the law of the sea, and thereafter law of the sea took off, and in the Committee of Nations we propounded the laws and regulations, and the international community kept improving on it. So I think all of those who have shown great interest in the law of the sea and made some tremendous quality presentations must keep the fact at the back of their mind that it is only when we try to make our best efforts in bringing up to speed the law of the sea issues that we will be able to, because about 80% of the planet is nothing but water. Is and the 80% of the trade, international trade, maybe more, correct me, it goes through the seas. So therefore, if you saw that COVID disrupted the entire maritime trade in between the countries. You have a problem recently. We saw in the Panama Straits a ship which was which got stuck in that, and the trade was disrupted for weeks, and it cost billions of dollars. A bridge that a ship crashed into a bridge near, I think it was somewhere in San Francisco area, which brought down the ship. It disrupted the movement of the marine, all the other ship traffic, and therefore caused a huge impact in terms of disruption of trade. And similarly, pollution or archipelagic issues between various countries, the Malacca Straits, which is a very important area today, and you find that I don't mind naming one of our neighboring countries which is trying to take control of those areas, and which is creating a security issue in the Indian Ocean. So it is essentially that some of the scholars and international lawyers who focus on ensuring that the law of the sea is well treated in terms of the issues that are coming before it, both in terms of pollution, both in or autonomous vehicles. Some of you have pointed out the climate change issues that are taking place, because the seas are being used for creation of solar power, water energy. Now you have, and marine cables, internet cables are going through the seabed. In fact, I think we have marine cables from Mumbai, etc., which go all the way to Dubai and other places, which are cables for the movement of internet traffic. So all of these things, issues can, now just imagine if by any private entity which was mining, deep sea mining, and it damaged the marine cables which carry the internet traffic, how disruptive it could get. So therefore, although we have a relatively regulated aviation scenarios post 9/11, but there is lots of work to be done in the law of the sea, which is pointed out by a wonderful, extremely well presented papers and debates here. And the quality was extremely good for all of you, those who have participated. I urge you to keep doing that. And keep doing it for as long as you can, because you're going to make a difference. And the only thing I think personally, not only just lawyers or international lawyers, for everybody, is to make the world a better place to live in. And I wish you all success in doing that and make the seas a better place and safer place to be in and benefit mankind. Thank you very much. Right, we break for lunch. Lunch is on time, came and said my colleague. It's 1 o'clock. So all done on time. Thank you very much. One group photograph for all of these. Come closer so that we have.
Good afternoon, everyone, and welcome to the 10th International Conference on International Law, Issues and Challenges, organized by Indian Society of International Law. This session is on arbitration in a globalized world, international law, and cross-border disputes. The chairpersons for this session are Mr. A.K. Ganguly. Mr. A.K. Ganguly is a senior advocate at Supreme Court of India. He has served in various capacities, including national and international institutions. He is Vice President of Asian Society of International Law, Member Executive Committee and Governing Board, Union International Desk Advocates, UIA Paris. He is also has served in Indian Council of Arbitration, Member Advisory Committee, Delhi High Court, International Arbitration Center. Professor G.J. Hegde was previously assistant professor and course coordinator and for the postgraduate diploma in international trade and business law at the Indian Academy of International Law and Diplomacy, Indian Society of International Law, and was assistant editor for the Indian Journal of International Law before joining the National Law School of University as assistant professor in April 2002. Now I would request the chair to make the opening remark.
Good afternoon, ladies and gentlemen. A very warm welcome to the present session on a very important aspect of the interrelationship between the law of arbitration and the international law, particularly in a globalized world. We have with us co-chair, Professor Hegde is a renowned personality, everybody knows him. Those who are associated, not just the ISIL, but almost all the Indian law universities. He is a well-known personality. So we have Professor Hegde from the National Law University, Bangalore. Bangalore, yeah. Is popularly known as the Bangalore Law School. Then we have a number of speakers. I think Dr. Harishankar possibly would be joining us online. He is going to talk on the proposal on dispute settlement on international economic law. That will be his topic. Then Dr. Archana Sukej, she is going to speak on environmental dispute and international arbitration. So that's quite a challenging topic in these days because environment is a field which does not come to arbitration normally. It is a component of public law element and a much wider application in all subjects of law, but it includes how does it play its role in the realm of arbitration? Can it really play any role or not? Would be the question. I think she is going to address us on that. And then Madam Taruna Jakar, she is going to address on intellectual property law, international arbitration, proposing an universal model for resolving the arbitrability of IP dispute. It is quite a hot topic in the sense that many of the countries feel that intellectual property rights are in the public domain. They are not private rights, so to say, adjudication process. Because there is a public law element in it because it affects the rights of people at large. Though the property rights are individual, but the rights are not only affecting those who own it or who are affected by it, but it has a larger policy measure. Can you or can you not refer these matters to a private adjudicatory body like an arbitral tribunal, which is a creature of a contract? or should it be necessarily the adjudication process must be left to the statutory mechanism which the lawmakers have provided? But this is a highly debatable issue, but a very interesting topic. We were going to hear them. Then Mr. Anvik Sethi, he is going to speak on the enforceability of online dispute resolution, ODRs, settlement agreement in India, analysis and issues, challenges and solution. This is again a very challenging topic now, because as you know, ADR we have followed for a long time, alternative dispute resolution. Now the new question is whether ODRs also fall within the category of ADR. Can we resolve ODRs, online dispute resolutions, as arbitration proceedings, similar to that? And what are the challenges to those kinds of adjudications? So we will hear the author of this subject. And then Mr. Akshay Sagar, he's a lawyer. He's going to speak on interaction of war crimes, sanctions, and commercial arbitrations. This essentially involves a discussion as to how far the private adjudication by the arbitration tribunal can take into account components of criminal law, if at all they are involved, to what extent they can adjudicate. Or this is a no-flying zone altogether for a private adjudicating body that don't touch upon the question. Moment there's a mention of a crime, okay, your jurisdiction is out. You go to the national court wherever the crime has been committed and seek enforcement of that law. But this is not so simple, so easy to answer. There are gray areas, so we will hear there from the authors. So these are the broad topics on which today we are going to discuss. Very briefly, that I would like to comment on these topics. I must commend the Indian Society of International Law, and particularly my friend Mr. Narendra Singh, who has been the prime mover in organizing this event and has chosen all these topics and has collected all the people. That's a great thing. Even my presence here, I owe to him only. But for his insistence, I would not have been here. It's a great opportunity for me to be present in this great gathering and meeting all my old friends, including Dr. Nachappan, who is a rare feature. You don't get to see him at all. And he has graced the occasion and he tells me that he has come only to see me. I don't believe him that, but it is my great fortune to have him and meet him here. So I thank all of you for what you have done. Let me just say a few things, because people think that I am associated mostly on the law of arbitration. That's why everybody thinks that I am. I don't know how I got that branding. I can tell you that I have no such branding at all. In fact, my favorite subject, and Narendra Singh knows very well from all my life, since the beginning, had been the constitutional law. That was my prime subject. But be that as it may, as lawyer, we perform what our clients want us to perform. Like, for example, to give you a great example, Mr. Palkiwala is known to be a very great constitutional lawyer because he has argued all important constitutional cases, including Keshavananda Bharati. But it should not be very surprising to you that his grounding was primarily on direct tax law, that to income tax. And his practice was confined primarily to the ITAT, Income Tax Appellate Tribunal, and rarely on a reference to the High Court. But he came to Supreme Court to argue big matters, including Golaknath, followed by so many other cases, bank laceration, etc., etc. And he is today known to be one of the leading lawyers in the exponent of constitutional law. I have had great privilege, hearing him, associated with him, and opposing him. I had great privilege of opposing him in a very big matter, which way back in 1986, I was just then designated for the first time. It's a great opportunity when Mr. Palkiwala came to argue a matter which involved 800 crores alleged excise evasion. And I was representing the government, opposing him. Whatever be the result. But so I had a great introduction. So we all perform or do as lawyers whatever is assigned to us. And we try to do our best in the subject in which we have been assigned. The clients decide what is your subject. In which subject would you specialize? Not me. My choice is something else, but I have no choice. I get a case I have to handle, and I have to do it the very best that I can. So there was a time, like a decade of from 80s to 90s, that decade, I was known to be a tax lawyer, mostly indirect taxes, because I was handling all big customs and excise cases, both for the private sector as well as the government. Subsequent years are many other years. I did many cases on constitutional law and many other subjects. So a lawyer is has no choice. So that way, don't please think that I'm an expert in particular subject or anything. I'm not an expert in anything. A lawyer has to know everything. So you can call me a generalist. Yes, I'll accept that. But I specialize in none. So it's up to you how you like to visualize. But of course, I have done so many arbitrations, particularly international arbitrations, conflicting jurisdiction, etc., both in a country, outside country. So some exposure I have, some experience I have. So from that point of view, I may say something which, if you at all I'm called upon to say, I'll do it at an appropriate time. I don't want to take more time. I'll ask Professor Hegde to say something if you wish to, or else he would do, I think, a summing up after the speakers have spoken. Whichever way you like, it's up to you.
Thank you, Dr. Ganguly sir. I don't want to take much time because as chairpersons, we need to observe the principle of natural justice. It's a New York Convention mandate that if the principle of natural justice is denied, then there is a good ground not to recognize and enforce the foreign arbitral award. One simple comment, rather it's not simple. There are 4 presenters from National Law School of India University. If I look at the topography of the subject matters covered, the 4 presentations from the panel proposal made by National Law School of India University, it's on a single theme called challenges and problems in the settlement of international economic disputes. And these 4 presenters, Dr. Harishankar, and then Ms. Ranjini Ray, and then Arnav Sharma, and there is one more, Dr. Saravanan. Yeah, Dr. Saravanan. So these 4 topics are on a single theme. Otherwise, other topics, they do fall under the discipline of a settlement of international trade and investment disputes. So there is coherence. I mean, with these words, I request Dr. Ganguly to open the discussion.
Thank you, Professor Hegde.
One time element. So 10 minutes.
So I'm instructed by Professor Hegde. He is very good in this, and I always follow his advice.
It's just a suggestion, not
No. I choose to follow him. So all the speakers will get 10 minutes on the outer line. So I'm sure you don't need a bell or a reminder. You'll do it on your own. It's a self-response. So I call upon the first 4 speakers on this subject. It's a panel proposal, on dispute settlement in international economic law.
Yes.
So you
challenges and problems
in
the settlement of international economic disputes.
Right. So let's hear the challenges and the solutions to those challenges. Thank you.
I think Dr. Satyakalan will be joining online.
That's all right. I've already announced that, no problem. Is he going to begin? So then we have to please call it. Then we can start. You can start, any one of you.
The first speaker is supposed to start.
Hello, Dr. Ganguly. Am I audible to you, Dr. Ganguly?
Don't give me a doctorate. I am not. So give me just simply say Mr. Ganguly, if you like.
Thank you, sir. Mr. Ganguly, Professor Hegde, and other distinguished speakers on the panel. My name is Dr. Harishankar. I'm part of the panel proposed by the National Law School of India University. I hope my presentation deck is visible to you all. So the title of my presentation, or rather my paper, is Commercial Reservation and Investment Arbitration, the Indian Scenario. This comes the trigger for the topic comes from two recent decisions from the Delhi High Court, not very recent, but a few years back, 2018 and 19, where the Delhi High Court basically made a distinction between commercial arbitration and investment treaty arbitration in an application related to anti-arbitral injunctions. In the first case was the Vodafone case, and the second case was the Khaitan Holding case. In both these arbitrations, the government of India made a representation to the High Court requesting the Delhi High Court to issue an anti-arbitration injunctions. Although the decision was observed as a pro-arbitration decision, but the decision has some problems which has created a lot of controversy and confusion among arbitration community, particularly investment treaty arbitration community. So the larger theme of my paper is on the relationship between commercial and investment treaty arbitration, and particularly the relationship between the nature of commercial and investment disputes.
Dr. Harishankar, just sorry to interrupt. I believe you have some slides. So as you speak on, you can change them.
Yeah. This is my first slide.
Very well. I was told that you were not changing, so I made this request. Thank you.
Thank you. I start with this question: Is the New Convention for the recognition and enforcement of foreign arbitral awards, is it confined to just commercial disputes? So, if you look at the convention, there are fundamentally two reservations available to the contracting states, and like many states, India has also made these two reservations. The first reservation is called the reciprocity reservation, which is not relevant for the purposes of my presentation or my paper. Reciprocity reservation is when the government notifies certain countries as notified territories having made reciprocal arrangements, and only awards originating from those countries will be considered as foreign awards for the purpose of enforcement in India. The reservation that I am going to focus on is the reservation called the commercial relationship reservation. So according to this reservation, the enforcement country or the enforcement forum has the ability to restrict the enforcement to certain awards which emanate from commercial relationship. So largely, if you look at the New York Convention and even its predecessor, the Geneva Convention and the protocol, had this commercial reservations in place. Commercial reservation basically because there are different categories of disputes which are arbitrable, and in commercial disputes, arbitration is possible, and in other disputes, it is up to the national legal systems to make a decision on that. And the test of defining what is commercial is also left to the individual states. So to take an example from the Indian legislation, if you look at section 44 of the Arbitration and Conciliation Act, where the foreign award is defined, it is defined as an award on differences between persons arising out of legal relationship, whether contractual or not, but considered as commercial under the law in force in India. And this particular part of the provision has been confusing because there is again no strict definition given under the Arbitration and Conciliation Act as to what is meant by commerciality or commercial. The term commercial means. And so these were the two decisions that I was referring to. So in that background, in the absence of a commercial definition in India, it simply says that Arbitration and Conciliation Act will be applicable only to arbitrations which are of commercial in nature, and enforcement of arbitral awards are possible only when they fulfill the commercial relationship reservation under the New York Conventions. And we have these two cases from the Delhi High Court. In both these cases, the Delhi High Court refused anti-arbitration injunctions to the government fundamentally distinguishing the nature or the nature of disputes in commercial and investment treaty arbitrations. And the main concern the court observed was in investment treaty arbitration, because the disputes are relating to regulatory disputes, disputes involving public international, disputes involving administrative law and fundamentally sovereign states, and therefore Arbitration and Conciliation Act, which is meant for regulation of commercial arbitration, cannot be extended to disputes involving states, meaning disputes of investment treaty arbitration. Now, the obvious question in this context is, what is commercial? Do we have a definition of commercial under any Indian legislation? There is no strict definition of the word commercial under Indian law, but we have some assistance from the Commercial Courts Act of 2015, where Section 21C defines what is a commercial dispute. And it is interesting to note that in that provision, it says it shall not cease to be commercial dispute merely because one of the parties, one of the contracting parties is a state or any of its agencies or instrumentalities. That means this dichotomy between public parties or public and private is clearly resolved through the Commercial Courts Act, this particular provision, which means that merely because of the fact that a state is involved in a dispute, you cannot say that that dispute is not commercial. So, as we have seen how the idea of sovereign immunity is now regarded as not as an absolute immunity concept. So in the same logic, we have seen how internationally and nationally, how the idea of states being a major player in the commerce, in the market, has given rise to such legislations. So basically, the idea behind the Commercial Courts Act, or the idea of commerciality, has expanded so as to include even disputes involving public functionaries, including sovereign states. And we also have some jurisprudence from other fields, from Indian courts, on the question of commercial relationship, not from other fields, but particularly on arbitration. If you look at the interpretation of the word commercial from the previous legislations like the Foreign Awards Recognition Enforcement Act of 1961. So we have this decision called the RM Investment and Trading Company Limited versus Boeing. The question for the Supreme Court in 1994 was whether RM Investment's consultancy agreement with Boeing, under which the company promised to help Boeing to sell aircrafts in India, could be considered as commercial. And the court held that it could be considered as commercial in nature. Also, in the same case, the Supreme Court made this interesting observation. While construing the expression commercial relationship, it can also be taken from the ancestral model law. Now, if you look at the ancestral model law, even though there is no, there is no strict definition of the term commercial under the ancestral model law on international commercial arbitration, but we have a very important footnote given under Article 1 of the ancestral model law. If you see that particular footnote, it says it has a non-exhaustive but inclusive definition of commercial. It starts with the statement saying the term commercial should be given a wide interpretation so as to include matters arising from all relationships of a commercial nature, whether contractual or not. Now, relationships of a commercial nature include, but are not limited to, the following transaction, and you can see a number of commercial activities included under that particular footnote, including the term investment. So the point is, under the ancestral model law on international commercial arbitration, which is again inspired from the New York Convention on foreign enforcement of foreign arbitral awards, has this wide meaning given to the term commercial. And now that we know, if you look at the investment treaty arbitration jurisprudence, most of the investment treaty arbitration jurisprudence has this commercial element involved in it, and many of the international bilateral investment treaties also includes the term commercial under the definition of protected investment. So if you look at both commercial arbitration legislations and international investment agreements, there is this crossover between commercial and investment. Both terms are treated in close association. But still, when it comes to Indian jurisprudence, we have these two decisions from the Delhi High Court. On the other hand, there is another decision from the Calcutta High Court, which is a much earlier decision, where the Calcutta High Court has held that it is possible to extend the application of Arbitration and Conciliation Act even to investment treaty arbitrations. Now, there is enough academic literature on this. There are blog pieces written on this. So my point is, this confusion has created, this controversy has created a lot of confusion among the international investment community. And this is perhaps one of the key reasons why Indian investors are securing awards against the state, not Indian investors, foreign investors securing awards against Indian states are reluctant to come to India for the awards because of this. Indian legal position, it is possible for a future Indian court to reject the enforcement of an arbitral investment treaty arbitral award, saying that because ultimately to approach an Indian court, you need to, since India is not a party to the exit convention, the only way to try and seek enforcement of any international award is through the application of Arbitration and Conciliation Act before an Indian court, and this is all a good reason for Indian courts to reject, saying that since Arbitration and Conciliation Act is not applicable to international investment arbitration, we cannot enforce investment treaty awards. On the other hand, if you look at some solution, for example, the Indian model investment treaty and some of the bilateral investment treaties concluded post this model BIT, based on the model provision that you have. Article 27.5 of the Indian model BIT has a solution to this problem, saying that a claim that is submitted to arbitration under this article is considered to arise out of a commercial relationship or transaction for purpose of Article 1 of the New York Convention. That means New York Convention commercial relationship reservation may not be a problem for future arbitrations. But again, as far as Indian jurisprudence is concerned, the only position that we can rely on for the time being is the decision from the Delhi High Court. Two decisions from the Delhi High Court rejecting the argument that the New York Convention and the Arbitration and Conciliation Act, Part 2 of the Arbitration and Conciliation Act, can be extended to investment treaty arbitration. So my simple argument is that more clarity and guidelines are needed from the Indian Supreme Court on this point. With that, I conclude my presentation. I'll be happy to answer questions and hear your comments.
Thank you, Dr. Harishankar, for that presentation. You would have noticed that a few words used in the Indian Arbitration Act, both in the definition sections and elsewhere, the key words are very important. That a dispute which is considered as commercial under the laws in force in country. Those are the key words which have to be really interpreted and so on. And there is actually no exclusion that a BIT or a multilateral treaty, investment treaty, is not excluded from the purview of being considered as a commercial dispute, if at all it involves. And as you know today, the Permanent Court of Arbitration holding a large number of arbitrations under the bilateral treaties and other international treaties. All the commercial players are very much in the game. In fact, that is one reason why the PCA has of late, after some debate and discussion, of which I had some privilege to be part of, have expanded their jurisdiction and have started setting up of regional offices of the PC only in recognition of the fact that the multilateral investment treaties and bilateral investment treaties, etc., though it is between the two government entities, would involve essentially commercial disputes. And the commercial parties who are involved in such disputes are allowed to be part and parcel of that. Though officially the litigants would be the two states who are parties to the treaties. So there is now in recognition and we have come up along. So thank you so much for that presentation. Now I'll call upon Ms. Ronjin Ray.
Dr. Sarvanan will be presenting next.
It's internal arrangement.
Yes.
Okay.
Sorry.
So, okay, then I think Dr. Sarvanan, you can please start. Where is he?
Yeah, sure. So, Dr. Hari, can you remove the screen? I want to share this. Thank you.
Sorry,
let's stop now. Thank you.
I hope my screen is visible.
Yes.
Yeah. Thank you. Thank you so much. I'm extremely delighted to be part of this panel, and I extend my warm gratitude to NLS as well as ISIL for the opportunity. The topic for my presentation is the role of amicus curiae in participation in the investor-state dispute settlement. So I looked at, so there are disputing parties, mostly party to the dispute settlement. But what is the role of non-disputant? So of late, there are a lot of cases related to environment, cases related to human rights, cases related to labor laws and the protection of environment, and many other cases started coming before the International Investment Dispute Settlement Body as well as the WTO. So as a student of international economic law, I looked at their issues from the perspective of the role of amicus curiae within the ISDS and WTO system. So what are the issues and what are the challenges, and how WTO jurisprudence as well as how ISDS jurisprudence have dealt with this issue in detail. So we'll discuss through this my paper. So when I looked at the definition of amicus curiae, I do not find any legal definition, but I could only find the definition from the Black's Law Dictionary. So the amicus curiae has been defined a person who is not a party to a lawsuit, but the non-disputant party files a petition before the court because that person has a strong interest in that particular subject matter. So why I have chosen that in international trade and international investment law, there is a lot of reason. That these are two different fields of international law, has some basic commonalities. Also, if you see the list of disputes, of late we can find a lot of dispute before these two bodies. But significantly, it has got rise. It has increased from the subject matter of protection of environment, health, human rights, and labor standard. Also, they have received a lot of requests from the non-disputant parties, including before the WTO as well as the Investment Treaty Arbitral. And the list, the amicus curiae has requested for various requests. The list has expanding. They're requesting amicus curiae briefs, and they want to get into access to the documents, and they want to be access to the court hearings, as well as they want to get a public participation and various other things. But how the dispute settlement body and investment jurisprudence have dealt that issue, so we'll discuss that, and how the investment instruments have dealt that, and how WTO dispute body has dealt with that we'll go and discuss it more in more detail. So when you talk about the WTO jurisprudence, even before WTO, before the GATT regime, there were a lot of requests made before the GATT, but none of the GATT has accepted the amicus curiae briefs, but they were very particular that only disputant party can present their arguments and present submission. But after WTO dispute settlement body, like even one of the first cases before the WTO dispute settlement body, US Gasoline 1996, EC Hormones, two NGOs submitted their briefs, support their claims with respect to protection of environment. But unfortunately, both the cases, their briefs were rejected. And the US RIM case in 1990, that was one of the very celebrated cases as far as the amicus curiae brief is concerned. because that was one of the first case where WTO dispute body, especially appellate body, has accepted the non-disputant party claims. So to support the US has imposed a restriction where the turtle, they have to, all the turtles, the shrimping vessel has to have TET vessels. All right. To support the US claim, so there are 3 NGOs, including the Center for Maritime Environment, Center for International Environmental Law, and World Wildlife Fund submitted the briefs to support the US claim. But interestingly, the panel has rejected the amicus brief submitted by these 3 NGOs. Reason was Article 13.2 in contrario. It doesn't actually, Article 13.2 has, it only talks about the submissions from the disputing parties. If we accept the non-disputant party submission, it will be incompatible with the WTO dispute body. So they did not accept this. But interestingly, when it went to appellate body has accepted the briefs from 3 parties, 3 NGOs, and they stated that though there is an Article 13.4, but still it is a discretion of the panel either to accept or not to accept, but appellate body has accepted their briefs. So that was one of the great breaking point. So that was one of the very, very first case before the WTO body where WTO dispute settlement body accepted this non-disputant party submission, and which had set a strong precedent before the future cases. Some of the cases I'm going to highlight it because that has a very strong foundation for the investment jurisprudence as well. So again, another celebrated case, EC asbestos case, where 5 briefs were submitted by NGOs, including 2 briefs were submitted by the respondent party, that is the European Commission. But interestingly, panel has rejected all the 5 briefs and only accepted the European community's briefs. So in 2009, November 2009, when it went on appeal before the appellate body has adopted a kind of additional procedure. That procedure is most important. The reason, because this brief procedure, like who can submit amicus brief and what basis they can submit the brief, those 3 principles has been subsequently adopted by UNCITRAL, ICSID arbitration rules, including the UNCITRAL Transparency Convention. So under Article 17.9, any person, non-disputant party can submit the briefs only if they should have certain desirable reason, and they should actually also state what basis and how their submission will contribute to resolving the dispute in the particular matter. And they also has to describe their name and whether they have received any financial status from the either of the parties, and is there any relationship between the non-disputant party and the disputant party. They have to specifically state in the application itself. But despite of all the encouragement, so in the asbestos case, before the appellate body, 17 NGOs submitted their brief, but the outcome is very disappointing because in all the cases, all the 17 NGOs brief has been rejected by the appellate body. So there are many other cases also. For interestingly, EC Sardines case, it was the first time when non-disputant country, Morocco, has submitted a brief to support the European Commission's response. So it was accepted by appellate body. Okay, so now the role set up motion by whatever the jurisprudence adopted by appellate body has played a very important role in the role of amicus curiae brief in investment law jurisprudence. So now, as I told you, there is a close connection between the trade and investment, because here also we can find the public and private divide, which we can also see in one of the very famous case where in Fuji Spectrum case, Supreme Court has cancelled 122 spectrum licenses given to various telecom licenses on the interest of public interest doctrine. But agreed by the decision of Supreme Court, there are various telecom companies who had, I'm talking about foreign telecom companies who had a joint venture like Telenor, Axiata, Astro Asia. They have filed a case against India host, that's India, before the different investment tribunal under the different BITs. So that we can see the difference, the divide between the public and private, which is very much evident in the Indian investment cases as well as the general investment treaty cases. So even before the investment tribunal, we can see the amicus curiae has the long list, starting from the submission of amicus brief, standing as a party, access to the case documents, and hearings, and make oral submission. But if you see the trend, early days, the tribunals were very much against this amicus curiae brief, But subsequently, they started accepting after the Glamis and then Methanix case in the investment right. And when they started accepting, they need to accommodate in the respective amendments. So there are a lot of amendments have been brought across all the other international investment instruments, including exit arbitration rule, ancestral arbitration, also NAFTA agreement. All right. So, but if you see the diversification of the amicus before the investment tribunal, it ranges from the NGOs and also in some cases, even home country, like for example, in Eureka case, in AES case, in Electrobel case, the home country, which is European Union, also submitted a brief to supporting the respondent's claim. All right. In some cases, the EC international communities like the World Health Organization also submitted a brief with respect to health concern. And in Glamis case, even private individuals also submitted a brief. So what I'm trying to tell you, the diversification of the non-disputant party before the investment tribunal varies from individuals to the home court, home state, or to the international communities. All right. So after the Methanix case, there are all the instruments like being NAFTA. NAFTA has been underwent a serious amendment during 2001, 2002, specifically Chapter 1. Chapter 1 of NAFTA discusses the investment aspect. So Chapter 11, specifically Article 1128 was amended, and they have accepted the
мероприятия. Давайте на связь будем, но ориентируемся пока таким образом.
I'm sorry.
Спасибо большое.
Okay, so Article 1128 as incorporated, and Article 1128 explicitly give a permission for the non-disputant party to submit a brief, and non-disputant party can submit a brief only for the purpose of interpretation of the NAFTA. That is the requirement under the NAFTA agreement. When it comes to exit arbitration rule, in fact, exit center also started accepting non-disputant party submission after the Suez and Vivendi cases. So Rule 37, Rule 32, and Rule 48 has been amended to accommodate the non-disputant party submissions before the exit tribunal. And all the other ad hoc arbitration are administered under the ancestral rule. Ancestral arbitration rules also underwent various changes. In fact, there are a lot of protests, lot of requests to us that were to increase the transparency, because confidentiality is one of the very cardinal principle of arbitration. So there are a lot of improvements have been made to increase the transparency before the investment ISDS mechanism. So ancestral rule of transparency has been brought in 2013, and the Mauritius Convention on Transparency, which is again United Nations Convention on Transparency in treaty-based investor-state arbitration, also has been brought in the year 2014. But again, under the ancestral rules, any non-disputing party can submit the brief by applying the three principles which has been adopted by the WTO or EC Sardine case. So they can submit the brief if they have if they have an interest in the matter, and they have to add value to the existing dispute, and the argument should not be repetitive, and they should clearly state that if they receive any kind of financial support from the disputant party for submitting the brief and all. All right. So I have thoroughly analyzed various investment treaty arbitral cases. It's a part of my paper. So I want to highlight a couple of the cases for the presentation. So when you talk about NAFTA's practice and admission of amicus curiae brief, so initially the Methanix case in 2001, this was not the first case where NAFTA has accepted the amicus brief. But the request ranges from the submission and also to take part in the court proceeding, review the memorial. But most of the cases, 99% of the cases, the tribunals rejected all other claims except only accepting the amicus curiae, giving a status of amicus curiae briefs in the investment cases.
Dr. Sabalan, please,
Yes.
thank you so much for your presentation. It is indeed a great work you have done. Please say whatever you want to say in conclusion. I would certainly request ISIL to circulate your paper, which seems to be very interesting.
Cool.
And you have brought in a very important issue, that is the role of the amicus in such proceedings. We will have an opportunity to study your paper in detail, but please conclude what you want to say. Yeah.
So what I want to tell, like, in fact, the amicus brief has become a very significant presence in the international dispute, specifically investment in ISGS and dispute settlement body. Several amendments have been made before the lot of international instruments, including ICSID and unsettled arbitration rule and various other arbitration rules. But this was a great attempt. But when you see the outcome is very, very disappointing, because most of the time, these briefs are only giving a status for amicus brief, but the role of the transparency, how to bring a balance between the public legitimacy and the transparency, confidentiality. That's a big question which has not been addressed so far in the practice. So success of transparency can be achieved only if we start accepting the amicus brief, not only just to simply sake of accepting the brief, but if they give them access to the attorney hearings and present their legal arguments. Thank you.
Thank you, Dr. Saravanan, for your wonderful presentation. And now I call upon Ms. Ranjin Ray.
Thank you, everybody. I'd like to thank the Indian Society of International Law for allowing me to present this abstract paper of mine, working paper of mine that I'm working on. I would also like to thank my colleagues. I would also like to thank my colleagues who presented right after, and thank you so much to the chairs, Mr. Ganguly, Professor Hegde. So in terms of why this topic also belongs on the panel on arbitration, I will be talking about EU's efforts of compliance of the WTO panel reports without an existing appellate body in place. And I call their efforts of ensuring compliance, whether that is them acting as a guardian angel or an oppressive demon, is what I bring into question, and I would love any views, thoughts, and comments on this topic. So just in terms of setting stage and some numbers, why is the presentation not being shown? But is it not shown there? I'm sorry, just a minute. I would like the presentation to be shown on the screen. Okay, great. Okay, so as we are all aware, the US has been blocking the appointment of appellate body members, by virtue of which the appellate body is no longer functioning since December 2019, as it lost its quorum of a minimum of 3 members. Thereafter, what has been happening? Now, when there is no existing appellate body, what is happening with the WTO dispute settlement as we have in place currently? So whenever a WTO dispute is now filed, and the process of WTO dispute settlement begins with consultations panels, after the panel process, the option of going to the appellate body is no longer remaining because the appellate body is not in place. So what is happening to panel reports at the moment? There are 3 approaches that are being adopted. The first approach is the panel report gets adopted. The member state that is inconsistent with WTO obligations has sought to adopt the panel report and get its measure consistent with its WTO obligations. So since December 2019, only 13 panel reports have been adopted. And these are some numbers that are relevant for us, particularly when we think about what it was the case earlier, where if we see the number of requests of consultations that were being filed prior to 2019 was excessive. And that number has significantly declined thereafter, with the appellate body not being in function. So since December 2019, 13 panel reports have been adopted. 25 panel reports have been appealed into the void. What that essentially means is, since there is no appellate body in place, the violating member seeks to file a notice of appeal and appeals the panel report, in effect not adopting the panel report, and so continues to be in violation of WTO law. And this essentially leads to the ineffective enforcement mechanism of the WTO, and the dispute settle mechanism of the WTO was known to be the crown jewel of the system. And without this functioning appellate body, now we cannot have, on many occasions, you cannot have a panel report be adopted by virtue of it being appealed into the void. The third thing that has approach that has come about, and that is really the reason as to why this topic belongs in this panel, is there is a procedure available under the dispute settlement understanding called Article 25, which allows for WTO members to resort to arbitration, which is what a lot of WTO members have sought to do when now, since there is no appellate body in place, some member states, when there has been a panel report that they still have issues of law concerning, they have sought to utilize the Article 25 mechanism to still ensure certain issues are reviewed and thereafter go about adopting the panel report as modified by this arbitration award that would become about. But the issue that is the other aspect that has come about through this Article 25 mechanism is that the European Union, along with some other developed countries, has sought to propose an alternate mechanism known as the multi-party interim arbitration mechanism. The multi-party interim arbitration mechanism is an ad hoc temporary mechanism that the EU and now currently 37 other member states are a part of. The MPIA, as we call it, allows for these few member states that have agreed to this procedure, allows for them to, after a panel report is issued, instead of appealing it into the void, utilizing the Article 25 mechanism. Now, the EU has utilized this Article 25 leeway that is provided under the DSU to create essentially an ad hoc appellate body in some sense, almost, and trying to mimic the structure of the appellate body, more so even incorporating a lot of the concerns that the US had with respect to the appellate body, trying to incorporate some procedural requirements like page numbers in terms of submissions, etc. So now the MPIA now exists almost as like a overlapping fragmented system under the WTO dispute settlement system. So those are the three approaches that are there. And so the WTO dispute settlement system, which we thought would just collapse post the appellate body being not functioning, continues to operate in a fragmented form with an MPIA which is accessible for only a few WTO members, and remaining WTO members seek to adopt panel reports as is, and the rest of the parties seek to appeal it into the void, and which can be a concern. So now what has gone about thereafter? Now EU, in order to ensure that more countries join their efforts of enforcing WTO panel reports, have gone about and adopted a measure, a domestic measure, which has transnational impacts. It's essentially a unilateral measure. It's called the EU Enforcement Regulation. The EU Enforcement Regulation essentially allows the EU to suspend concessions against any WTO member that is not party of the MPIA and who does not adopt a panel report and chooses to appeal the panel report into the void. Now, this is very similar to any unilateral measure. Essentially, it is essentially what the EU enforcement regulation allows is allowing for suspension of concessions that is not sanctioned by the WTO DSU, which is a very clear violation of WTO law, without a doubt. And in fact, there have been other such measures in the past that have been challenged under the WTO, like the US Section 301 mechanism that has been challenged under the WTO. And even there, it was found that such measures would be considered inconsistent with the DSU. So similarly, the EU enforcement regulation is very blatantly inconsistent with the DSU, then how is the EU seeking to justify the measure? So the EU's argument is that it seeks to justify the measure under general international law because the WTO member that is not complying with the panel report is essentially violating international law. The EU is well within its power to apply a countermeasure, which is EU's argument. But that in itself is not a very succinct, a foolproof argument, because that itself has many loopholes. Because at the end of the day, the WTO is a lex specialis regime. It has a very clear dispute settlement framework incorporated. So there are several concerns with respect to, I will take 2 more minutes of your time. Thank you so much. In terms of the EU enforcement regulation, it is blatantly inconsistent with WTO law. It is also known to be inconsistent with general international law. Now, why do we care about this as much? Currently, the EU has not effectively has not sought to enforce or has not sought to apply a measure that leads to suspension of concessions against countries, but currently it has a procedure in place with respect to Indonesia. In the case Indonesia raw materials, where Indonesia applied some export restrictions with respect to nickel, Indonesia lost the case. And then thereafter sought to appeal the panel report into the void. So Indonesia is not complying with its WTO obligations, and the EU has started its process of trying to assess the amount of suspension of concessions that is required against Indonesia. So in 7 June 2023, they started this public consultations, and EU is yet to apply any, EU is yet to suspend concessions against against Indonesia, but it is a process that it has started and we can expect for it to happen. Why is this of concern to us? The same thing can happen to India, because India has lost against the EU in the ICT dispute fairly recently and has grave implications in terms of the amount of concessions that could be suspended under this dispute. So just to conclude, what can India do in case of, the EU threatens with respect to suspending concessions through the enforcement regulation? They can comply and ensure that they remove the WTO inconsistent measure. They can seek to negotiate with the EU, which they seem to be doing. They can also challenge the EU measure suspending the concessions before the WTO, which might be difficult. And lastly, they can respond with a countermeasure. Thank you so much for your time.
Thank you for your presentation. It was really indeed a very, very interesting topic, and I am speaking for myself entirely. I'm provoked to make just only one observation.
Yes.
Why do you take all this circuitous route of going to start an arbitration in some home country after you have got an award from the panel in the absence of an appellate body? Naturally, the panel award becomes the final. And why do you have to do all this? Why not straight away go to the WTO? You have an executive committee who are supposed to adopt it.
But they're not adopted.
If they don't, it's a political decision.
That is true, 100%.
So,
it is a political
exactly.
decision.
So that's a function of that body, and since the laws of that organization WTO that operates in its own field, it's very difficult to get out of those subject matters and bring in somewhere else. You would be bringing in so much of conflict of jurisdiction. But it will be a wonderful subject for lawyers and professors. Thank you so much.
Thank you so much.
If you have a brief, I'll be interested in taking it up. Okay, right. Now our next speaker is Arnav Sharma. Arnav Sharma. Yeah, please.
So my apologies. I again request that please stick to the timeline.
Yes.
We will be grateful. And we want the audience to participate through question and answers later.
So, thank you, sir, for the kind reminder, and thanks a lot to ISIL for this platform. A very good afternoon to all of you, respected panel and the chairs. So I had actually created a very detailed presentation on what I was supposed to talk about, because there was a lot of context setting, but since there is paucity of time, I would rather divide my, so that's my bad, but I would rather divide my presentation into 3 parts, which is the background or the context, the challenge, and the response. This is not my presentation, this is Ranjini's. So the working title of my paper is called Trade and Sustainability Chapters in Free Trade Agreements and Dispute Settlement, Navigating Challenges from an Indian Perspective. Now, why do I talk about this issue? A little early in the year, we signed an FTA with EFTA countries. That FTA contains India's first trade and sustainability chapter. We are also in advanced negotiations with certain Western countries in this regard. It includes the UK and the EU. What I focus on specifically today is the EU, considering I'm following a systematic channel of EU bashing here. So before I start with that, what are trade and sustainability chapters? We are in the era of deep trade agreements. WTO is pretty much non-functional on the dispute settlement side. There are a lot of issues that have led to a political deadlock in the WTO administratively and institutionally. So we have an increased proliferation of free trade agreements. These free trade agreements have also started venturing into domains such as trade and sustainability. They are not restricted to liberalizing trade, to removing tariffs. They're also moving in the direction of new arenas. What trade and sustainability chapter specifically covers is a lot of referencing with labor and environmental obligations. It has a lot of interlinkage with what a country or a grouping has been doing multilaterally, regionally, and its sort of articulation into a trade agreement chapter at a more granular level than you usually imagine at multilateral forums. So trade and sustainability is not particularly alien as a topic. It has seen around 6 WTO disputes, and this is according to the WTO itself. Most of it has sort of restricted itself within the domain of general exceptions. We have around 3 cases in the WTO era. We have 3 unadopted panel reports in the GATT era. The more popular ones in the WTO era are US shrimp, EC asbestos, and US gasoline. Now, all of these involved environmental/health measures which were undertaken in contravention of GATT obligations. And these sort of measures were justified under that framework. What FTA frameworks try to do is sort of move away from them, sort of try to bring in a lot of multilateral environmental obligations that they've taken, recognize that countries can undertake domestic measures within that framework, and these measures need to be protected provided they follow certain frameworks. When we look at trade and sustainability chapters, it's been around a decade or 2 since we've had them. There are 2 primary approaches. One is led by the US, the other is led by the EU. So a lot of secondary literature refers to the US approach as a sanctions-based approach. So what you have rather is consultations on an issue, you move towards dispute settlement through a panel, and then you have to either respond to whatever recommendations that panel report makes. If not responded to in a particular manner or as recommended by the panel, you face consequences in terms of trade in terms of suspension of concessions and other elements. Now, what the EU does in this context is slightly different. They have a more consultative and cooperative mechanism. They rely on extensive consultations and institutional mechanisms coupled with a panel. Again, EU's approach when it comes to their own trade and sustainability chapters has been evolutionary, has been dynamic. It has been subject to a lot of internal stakeholder consultations, and there has been a general move to push from a more cooperative and recommendatory approach towards a more binding and sanctions based approach. It has not succeeded entirely, but that has led to some movement towards a more stringent framework. As I stated, India's FTA practice is interesting. We never had a trade and sustainability chapter in an FTA before. EFTA happens, and then we have a trade and sustainability chapter, but it's very different. In fact, a lot of Western scholarship also refers to it as a low ambition chapter for its lack of a panel process. Before I go into further details, what do trade and sustainability chapters under the EU framework do? They try to ensure that certain environmental standards and agreements are upheld, so there is no treaty regression. You can move towards a direction which is more stringent, but you don't fall back. You also ensure that national and local labor laws and environmental norms are effectively enforced. So it sort of interferes with certain internal frameworks that you have. Of course, it also looks at sustainability within trade of natural resources and other resources. It also looks at combating illegal trade when it comes to biodiversity and wildlife. It also looks at sustainability practices across the value chains and corporate social responsibility elements. Now, the nature of obligations here, they try to preserve policy autonomy while trying to prevent regression. They try to also effectively refer towards maintaining transparency while this is happening. It also calls for a lot of third-party and civil society participation. In fact, it has a framework, which is a domestic advisory group, which looks at the implementation of the TSD chapter within a treaty member. And it also has an innovative dispute settlement framework, which refers to extensive consultations, which then goes on to a panel of experts. And this panel of experts is sort of distinguished within its framework from the other panel. I'll just take a minute to conclude. So the Indian approach at present in this context has been to limit any dispute settlement related provisions to consultations, maintain confidentiality of reports and consultation requests, restrict third party participation. India has also tried to take in a lot of the positions that it has taken in multilateral level to its treaty framework. So it's also looking at environmental measures which are aimed at restricting trade. Particular references are CBAM and deforestation. Now, how to respond to that challenge? A lot of the transparency issues that I mentioned have already been addressed in India, although not made mandatory. What remains to be done here is some work on the panel process, and at least I argue in this working paper that India can at least adopt a softer version of a TSD chapter, which is more recommendatory in nature and not truly binding. Of course, sky is the limit in the future. We are already negotiating with a lot of advanced economies, so we might see a TSD chapter if conditions permit. Thank you.
Thank you, Arnav. May I now request Dr. Archana Sukehia to address her this gathering on her subject, environmental dispute and international arbitration.
Good afternoon, dignitaries, Ganguly sir, Professor Hegde sir, my principal ma'am, and dear participants. It is an honor to be present with you all here. My topic is environmental disputes and international arbitration, balancing interests. Recently, the quest for a forum for deciding the increasing volume of disputes concerning environmental damage has occupied much of the attention in international environmental law. Article 33 of United Nations Charter provides that the disputes ought to be settled through conciliatory means like negotiation, inquiry, mediation, conciliation, arbitration, adjudication by a judicial institution, apart from restoring to regional agencies or arrangements. Many international environmental agreements gave meaning to this article by including a dispute resolution clause in their treaty administration structure. Consequently, the international commercial arbitration is not just a litigation sitting down, rather, this is truly different form of dispute resolution, which has a rich history, a bright future, the benefit of global enforcement under 1958 New York Conventions. International commercial arbitration (ICA) is preferred method of dispute resolution for commercial entities. The main advantage are perceived to be enforceability, avoidance of specific legal system, flexibility, the ability of parties to select their own arbitrators. However, apart from these advantages, a 21st century ICA is tainted with a few shortcomings too. The procedure is perceived to be too costly and lacking the expected speed. Talking about environmental disputes, the concept of environmental protection and climate change are broad, and disputes arising in this context are in a numerous form. Such disputes range from claim against governments and major carbon emitters to investigations launched by government themselves. However, the disputes with an environmental component may arise in the context of contractual and commercial disputes that are typically resolved through commercial arbitration only. Currently, the international environmental treaties are increasingly making space for alternative dispute resolution, that is ADR methods, toward dispute settlement. The Permanent Court of Arbitration Environmental Arbitration Rules 2001 are a set of rules with few novel features about that, addressing concerns that are exclusively for environmental disputes. The rules are formed in such a manner that would make possible for any combination of parties to dispute state, NGOs, multinational corporations, and even individuals. The rules are also designated to handle multi-party disputes. Another important feature of these rules is that it addresses the cost aspect in international dispute settlement process. Member states have access to Environmental Assistance Fund also. Permanent Court of Arbitration (PCA) and the environmental rules could thus fill the place of the forum for environmental dispute with expertise. In this research paper, I have discussed few cases like Methanox Corporations and United States, Gold Reserve Incorporation versus Bolivarian, and Republic of Philippines case. From analyzing of these cases, it can be assumed that environmental and climate change disputes resolution is fragmented. Arbitration is split between investment treaties and international agreements, commercial contracts, and permanent institution or ad hoc arbitrations. Due to the complexity of the issues, which may take any form, this list may not be exhaustive. Another belief is that the regime players, whether arbitral institutions or self-regulated groups, are ready to make whatever changes to suit the future needs. Hence, it can be said that arbitrarity of environmental issue is a nascent regime that is fast gaining strength, clarity with the help of arbitration community participants. In a conclusion, I would like to say that ICA's initial success as an informal, speedy, cost-efficient trans-border dispute resolution mechanism, and it is undeniable. However, today, the procedure has largely become judicialized and therefore ill-liked by many and applauded by others. Both sides have merits in their claim to authority. I feel that the evolution of an arbitral trial was inevitable as courts were asked to approve the procedure by sanctioning the outcome of arbitral decision. Meanwhile, law firms and service providers were also occupied with taking advantage of fueling the dispute resolution demand with costly litigation feature, but yet with high quality legal services. The users wanted to win and hence wanted aggressively skillful lawyers on their side. Eventually, the scope of arbitral competence was inevitable too, and the subject matter in arbitrality doctrine became less and less prevalent. Arbitrators were considered competent to handle statutory claims and other complex matters traditionally falling outside the scope of ICA. Meanwhile, the increased quality of ICA procedure was too undeniable, making it harder to downplay its righteous entrance for complex and high-stake ICA disputes. All in all, there can be no denial of the fact that developed countries
trial techniques widen the lawyer's toolkit in this highly contentious and adversarial settings. Developed countries' law firms were highly sought after to win in arbitration at any price. More than that, there can be no denial of the fact that it has been partly been better, yet not exclusively so. So, it can be viewed by many experts as if expedited arbitration may be the only commercial realistic arbitration option for SME, that is small and medium enterprises in many instances, and despite its limit, it is certainly better to have access to imperfect justice than to not no justice at all. Thank you. Thank you.
Thank you, Dr. Ashana. That was wonderful and comprehensive presentation. May I now call upon Dr. Taruna Jakar?
Yeah.
The subject is arbitrability of IP dispute.
Yes. Yeah, I hope I'm audible. Good afternoon, everyone. Today I am going to present on behalf of two of my co-authors as well. All three of us are working together on this particular paper. The interface of intellectual property and international arbitration, and we intend to propose a universal model for resolving arbitrability of IP disputes, because this is one of, as Mr. Ganguly had already mentioned, that this is one of the most burning and debatable topic at the moment at the international level, for the reason that every state has its own take on it. Now, the idea is that when it comes to intellectual property, we have a very firm understanding of IP to be very territorial in nature. It is so basically because of the recent, in the past decade, we have seen that there has been a very wide shift from the industrial age to informational age, and intellectual property have started to become the most prominent assets of the corporations. Though these properties, which are a result of an individual's intellect, are protected at a territorial level, at a national level, but they are not just confined in their commercial dealings to these territorial peripheries, but do cross those territorial boundaries that have been divided by 200 states across the globe. So the issue is that whenever we are commercializing them, the dispute resolution mechanism also must be very robust. So by virtue of TRIPS coming into picture in 1994, we saw that the international community does want that the IPRs should be protected in a very robust manner, but a very robust dispute resolution mechanism has not been proposed as yet. And the concerned dispute resolution related to IP matters is certainly confined only and only to state courts, and it's a per se matter of litigation only as of now. The IP litigation issues basically revolve around factors of infringement, their applicable, the licensing, the assignments, as well as their authenticity, and whether they should actually be granted or not. In other words, the validity. So the issues which I am going to essentially deal with is going to be of infringement, validity, ownership, and the breach of contract. The various country perspectives that I and my co-authors have essentially explored it's a blend of common law countries as well as the civil law countries, because we would want to take a blend of all of them together, because everyone is a part of the TRIPS agreement. So Canada's position on arbitrability of IP disputes is it generally allows copyrighted aspects and copyrighted disputes to be arbitrable in nature, even if it is related to infringement of it, even if it is related to validity of the grant of the concerned copyright. But when it comes to patents, patents are something which is still a debatable issue in Canada as well, because the validity of patent is considered to be a public policy matter, not per se something which is very private to an individual who the one who's holding it, and hence the patent infringement, patent validity are something which the domestic courts essentially deal with. Europe, on the other hand, is a very unique kind of a structure, because they have certain laws related to arbitration and intellectual property at the union level, as well as the states also have their own domestic regimes. So in Europe, specifically, we have looked into France, Germany, and Switzerland. So France basically says, again, it states that certain trademark related matters, which are essentially trademark licensing matters, we can give them to arbitration, or basically they are arbitrable in nature. But when it comes to patent issues, they have the same stance as Canada. They say that patent validity and any kind of a contractual dealing in patents is a public policy matter. It's a public issue. Public interest is involved. State interest is involved. And for that reason, we are not going to make it arbitrable in nature per se. Germany says that Germany has a very, very liberal approach when it comes to arbitrability of IP. There has been the liberal approach basically says that if copyrights have any royalty issues, we will certainly make them arbitrable in nature. If there is any patent infringement concept, or if there is any issue related to patent infringement, that is also arbitrable in nature. But if patent validity comes into question, then that is not arbitrable, but rather the state courts would take care of it, because they say that patent validity is a public policy issue, but patent infringement is basically a personal issue between the concerned holder of the patent as well as the infringer. So Switzerland, on the other hand, it is even more liberal as compared to Germany, because they have said that anything and everything related to intellectual property is going to be arbitrable in our jurisdiction. UK, India borrowing most of its IP jurisdiction and IP laws from UK. UK is again very robust. It basically does not allow any form of intellectual property disputes to be arbitrable in nature, but it just simply states that trademarks and copyright, to certain extent, only to the extent that they are dealing with the licensing and the assignment of trademark and copyright, they are arbitrable, otherwise they are not. So when it comes to validity of patent, trademark and copyright, in UK they are not arbitrable, but when it comes to licensing and the assignment, which means a complete contractual dealing or commercialization of that concerned intellectual property commodity, then that is arbitrable in nature. Looking into the Indian perspective, in India, we have already had decided in 2 landmark judgments since 2010, and again we reaffirmed this in 2020. I'll just extend it for 1 minute. They reaffirmed it in 2020, stating that anything which is basically a right in rem, which includes the validity of intellectual property, that is not going to be arbitrable. But whenever we are dealing with any intellectual property in a commercial matter, that is through by virtue of entering into contracts, that is again licensing or the assignments, then that is something which is arbitrable in nature. So rights in personam, which are basically created through contractual relationship between 2 entities, then that is absolutely arbitrable in India as well, but otherwise it is not. So the questions of the whole issue that we dealt with and we are still exploring in our paper is that, first of all, public policy. It's basically a very subjective term. It's not even defined in terms of arbitration. It's not even defined in terms of intellectual property. A public policy term is just vaguely used by various jurisdictions to state that we are not going to make IP disputes arbitrable in nature. Whereas making it arbitrable is going to be very, very effective, because arbitration would provide more neutrality in cross-border transactions, in cross-border dealing of intellectual properties. It is going to provide a more neutral forum, more timely dispute resolution, and it would also enable the reduction of conflict of various decisions related to any intellectual property if the same intellectual property has been brought into question in various different country courts. So that is from my end. So we intend to propose a model in which we are saying that WIPO should come up with certain parameters in which those parameters would mention that what is going to be arbitrable and what is not going to be arbitrable. So we say that whenever, taking some inspiration from Germany, that if it is related to infringement, because this is something which is between two individuals and two entities, it can be arbitrable, but when it is about validity, it can certainly be dealt with by the states. So features such as this can essentially be encouraged and modeled by WIPO. Thank you.
Thank you so much, Dr. Taruna Jakar. May I now request Madam Anvi Kaur Sethi. Anvi Kaur Sethi. She's going to speak on a very interesting subject of online dispute resolution settlement agreements in India and their enforceability.
Good afternoon, everybody. So this is my session's outline. I'll be discussing conceptual framework, international instruments, and legal framework in India, and then issues which we are facing right now, and then I'll be proposing solutions. So ODR, what is it? Is it only EADR or it is beyond that? Ancestral Technical Notes on ODR 2016, para number 2 defines online dispute resolution as mechanism for resolving disputes through use of electronic communications and other ICT tools. Then EPEC model procedural framework, it defines ODR, but unfortunately till today we do not have a comprehensive definition for ODR globally as well as from Indian perspective. So presently in my presentation, I will be dealing with the settlement agreements arising out of negotiation, settlement agreements arising out of conciliation and oblique mediation, then consent awards. Consent awards means particularly when during the arbitral proceedings, when the parties, they arrive at settlement and on the basis of the terms of settlement, the arbitral award is passed. Then automated negotiation, settlement agreements, it's very new concept for me at least, and why it is so, I'll come to this point in a while. So it is international framework. This slide shows us the international framework presently which we have related to ODR. So New York Convention, Ancestral Model on ICA, 1985 revised in 2006, then Ancestral Model on International Commercial Arbitration and ISA, that is International Settlement Agreements 2018, then we have Singapore Convention, and then Ancestral Technical Notes on ODR 2016. So first 4 instruments, they are dealing with online dispute resolution implicitly. Per se, since we do not have a direct, we do not have the ancestral technical notes on ODR, they are not complete in the framework. That is why we have to refer to these 4 instruments. So I have drawn a comparative, it's not a comparative, but this chart simply projects that forms and contents in New York Convention, it is jurisdiction specific, forms and contents of award. And Ancestral Model on ICA 31-33, form and contents of arbitral award. 33 talks about the correction of arbitral award, and then Article 30 specifically talks about settlement award. Then Article 16 para 2 of Model on International Commercial Mediation and Convention, Article 2 para 2, these 2 provisions, they have specified the requirements for settlement agreements, so arising out of mediation. And unfortunately, uncitral technical notes on ODR 2016 is silent when it comes to ODR outcomes. So it covers the process of ODR, how it is going to, how it should be implemented, but it does not covers the ODR, the fate of ODR outcomes. So similarly, requirements for enforcement, these provisions, they deal with requirements for enforcement of outcomes, and then grounds for challenge. Article 5 New York Convention, Article 34 uncitral model, Article 19, and then Article 5. And again, the grounds have not been, since we do not have a mechanism for challenging or enforcing the ODR outcomes in uncitral technical notes, so we do not have the grounds for challenge also. So ultimately we have to come back to these four instruments, or specifically New York Convention and Singapore Convention when it comes to international settlement agreements, and uncitral model law and uncitral model on both uncitral models. They can be referred by the nations for developing their respective laws. Then this is a brief overview of the legal framework governing ODR outcomes in India, not explicitly but implicitly. So this is again a diagram. I mean, this chart shows that even though we do not have an explicit ODR framework, legal and or regulatory framework, but the existing legal framework covers ODR. So forms and contents of settlement agreement, again, it is covered under Part 1 as well as under Part 3 of the Arbitration and Conciliation Act. Section 30, which is based on Article number 30 of uncitral model, again, it talks about settlement award. When the parties, they arrive at a settlement during the arbitration procedure, then on the arbitrator will pass an award on the basis of the terms of award, and it will have same status as that of an arbitral award. And similarly, section number 73, which part 3, which talks about conciliation, again, it has, the award will be passed under 73. The settlement term agreement will be equivalent to arbitral award under section number 30. Now we have Mediation Act, and section number 19 talks about, it lays down the format, the contents of mediation settlement agreements, and subsection 5 of section 19 specifies that whatever has been written in section number 19 subsection 1 till 4 will apply to online mediation settlement agreements also. Now there is a drawback. Drawback is that we took around 2.5 years or 3 years to make this law, 2 years. But still we did not cover electronically generated MSA. We are talking about artificial intelligence, but we have failed to cover the automated negotiation settlements also, or automated mediation settlement agreements. Now procedure for enforcement 34, 35, 36, and again the decree of the court, the execution procedure mentioned in CPC is followed. 27 of Mediation Act talks about the enforcement of mediation settlement agreements, but again the drawback is on enforcement of, it is silent on enforcement of automated decisions. Application where it is to 34 subsection 1, we are talking about application for enforcement of the settlement awards, and then it is 35 and 36 will be filed. And then when we talk about application for challenging the award, the settlement award, then 34 deals with the grounds on which the arbitral award can be challenged. 28 deals with 28 subsection 2 deals with the grounds on which the mediation settlement agreements can be challenged. Now when I talk about MSA, and when I talk about, this is fourth point, subsection 2 and 2A of section number 34, that is grounds on which the awards can be challenged. The enforcement can be challenged. Now when it comes to online dispute resolution, in my opinion, the awards which have been already mentioned, the grounds which have already been mentioned are not sufficient. Why? Because when we are dealing technically, technology is involved, then there are chances that breach of privacy, breach of data is likely to arise. So that kind of ground should also be included. And most importantly, section number 28 subsection 2, which entails the grounds for for challenging the validity of mediation settlement agreements, is not in consonance with Article 5 of Singapore Convention, which should have been done by the legislatures. That's my opinion. Then timeline, subsection 3 of section number 34, it gives a timeline for 3 months for filing of an application for setting aside of an arbitral award, and similarly 90 days for setting aside of mediation settlement agreements. So according to me, it should be redefined. Why? Because when we talk about ODR outcomes, 3 months time period is not required. EPEC procedural framework 2019, it gives merely 10 days for processing the award. Then in case if any correction is there, then 5 days. There are certain provisions which talk about the same. Then when we talk about application, then we the last point from this chart is on which I wish to focus is that domestic and foreign, part 1 and part 2 of Arbitration and Conciliation Act, they cover, we have a provision for domestic awards and foreign awards in arbitration, under Arbitration and Conciliation Act, but unfortunately under Mediation Act we have ruled out the enforcement of cross-border awards, cross-border mediation settlement agreements. Why? Because we have not yet ratified the Singapore Convention. I'll just 2 minutes. The issue, absence of unified regulatory framework, not only at national level but also at international level. There is a dire need for comprehensive framework for online dispute resolution. Then jurisdictional dilemmas, not only at national level but also at international level. These dilemmas, they exist. Now this slide I'll be focusing only on Indian perspective. For example, judicial dilemmas. Now I was just going through the Arbitration and Conciliation Bill which has been proposed 2024. Now section 20, seat venue, the clarification has been given, but the clarification should also be given for the ODR, from the ODR perspective, or from the digital MSAs or digital arbitral awards. Then comprehensive definition should be there. Section number 30 of Mediation Act is not AI inclusive, and there is a scope for improvement. And I just wish that the regulations which MCI is going to frame as to how the online mediation should be should work, should include it gives a comprehensive definition in the regulations. And then we do not have explicit provisions for regulating the conduct of ODR platforms and ODR service providers. Now this gives rise to another issue, that in case, for example, a private organization which is an ODR service provider, the parties approach the ODR service providers, for example, they go for mediation, they pass the arbitral award through that organization. Now, what will be the validity of the awards or settlements arrived through the private ODR service providers? And in case if the parties again they have to come back to the court, then the entire process will become redundant. So we should frame certain guidelines for ODR service providers and platforms. Role of the courts should be minimized when it comes to ODR. The recent bill, it proposes that arbitral appellate tribunal should be there, and according to me, we should refer to OECD developing effective in Latvia. This report has been this report signifies as to how we can streamline the ODR process in our country as well.
Sorry, madam, to intervene. Can you quickly finish it?
Sure, sir.
In one sentence, whatever you want to say now.
Right, sir. So, we need comprehensive ODR mechanism for enforcement. And this is the diagram.
Say that, then I use one sentence for you and for every information of the audience. That these we have taken actually. The government of India had set up a committee.
Yes, sir.
Of people of which I happen to be one of the members. Therefore, I am giving a personal knowledge to you. This may be available on the public domain. I can't say whether it is or not. We have made very strong recommendations for recognizing private forum to facilitate ODRs. Even under the existing law, it is not inconsistent. ODRs can be enforced.
Yes, sir.
And they are recognized. Only thing is you have to follow certain procedures, in the sense you must decide where are you settling, where is the seat.
Yes.
Because you are doing it online. You should decide what is the seat. You should decide the law. So there are few things which have to be done as a matter of, but then it's now in the realm of government can do something about it. You are all free to give your inputs to the government. Thank you.
Sure, sir. Thank you, sir. Thank you, everybody.
Now, I think next speaker is Mr. Akshay Sagar. No, one more. We have someone from outside India going to present something. We don't know what's the topic. Oh, this one. Okay, we'll see that first. Akshay, I will request you to finish it as quickly as you can.
Sure.
Because we have one more speaker and then the House must respond. Such important topic we have dealt with. Come on, quick.
Good afternoon, respected chairperson, panelist, and audience. I am Akshay Sagar, and my topic is the intersection of war crime sanction and commercial arbitration. So, my topic explore the complex relationship between war crimes, international sanction, and commercial arbitration, focusing on how these factors interact in today's global conflicts. As international tension rise and sanctions are imposed to address violation of international law, business operating in conflict zones face significant challenges. Commercial arbitration becomes especially important as disputes arise from war-related activities and sanctions. As the world becomes increasingly interconnected, the ramifications of geopolitical tensions, such as sanctions and diplomatic conflicts, complicate arbitration proceeding by affecting the enforceability of arbitration award and creating jurisdictional issues. This is particularly relevant in regions dependent on foreign investment where such disputes frequently occur. Arbitration institutions like SIAC provide neutral platform for resolving disputes, but geopolitical factors, particularly concerning state-owned enterprise, often shaped outcomes. Historically, commercial arbitration has served as a mechanism for resolving disputes impartially and efficiently. However, the rise of sanctions, often targeting states for entities accused of war crimes, raises questions about the enforceability of arbitration agreement and awards. For example, sanctions against Russia following the conflict with Ukraine have led to the annulment of arbitration agreement, making dispute resolution more difficult. Similarly, sanctions on the Assad regime in Syria complicate arbitration for foreign businesses operating there, raising questions about the balance between international law and fair arbitration. Through case studies, this paper examines how sanctions and conflicts impact businesses, particularly those involved in rebuilding war-torn regions. The goal is to highlight the need for more transparent and neutral arbitration framework that can effectively resolve dispute even in politically charged environments. In conclusion, as international relations evolve, the dialogue surrounding war crimes, sanctions, and commercial arbitration must adapt to ensure that the mechanism for dispute resolution remain effective and just, ultimately contributing to a more stable and lawful international order. Thank you so much.
Thank you, Akshay. It is really comprehensive and you are to the point, precise. Stick to the time. Now we have a foreign speaker, Mr. Alexander Koskin from he's from Moscow, Russia. He's going to address us online, but I really don't know the topic on which he's going to speak. He has given us his expertise in various aspects, including complex disputes involving foreign parties and international commercial arbitration. So let us hear what he wants to say. Could you please tell us what is the topic on which you're going to speak?
I would like to speak on the Indo-Russian Treaty on mutual assistance in civil and commercial matters, and especially with a special focus on arbitration, because it's strikingly surprising that such a treaty includes provision on arbitration. Am I hearable?
Please go ahead, but you have to be very comprehensive. We are running out of time. So as short as possible. Thank you.
Many thanks. Just it may be striking both for Russian and for Indian lawyers that the Treaty of 2000 includes provisions on arbitration. It is striking for the reason that Soviet Union and India have been parties to New York Convention 1958 for a very long time.
Yes.
It's very important, for instance, to mention the famous case Tractor Export v. Tarapur Company, which has been frequently reported in many collection of articles. But it may be for some reason difficult to understand why both Russia and India included provision on enforcement of arbitral awards in the Treaty of 2000. And for instance, such treaty states that the term judgment so the treaty includes, and the sole explanation to this could be found in Article 4, which refers that assistance in civil matters could be effected by means of letters rogatory, which are submitted from one central authority to another, which means basically that not only court judgments, but also arbitral awards could be forwarded by means of letter rogatory from India to Russia and Russia to India. But still then, there exists a number of hurdles in application of this treaty. Because, for instance, if you may open Article 24 of the treaty, which basically states the conditions for enforcement of judgments, it says that judgments rendered by court, by judicial authorities, and obviously in an arbitral tribunal is not such a judicial authority. So here we come to a very difficult situation while interpreting the treaty, because obviously it does refer to arbitral awards. The sole explanation to this is that to enable enforcement of arbitral awards as well as court judgments by means of letters rogatory. But still then, the text of the treaty does call for its further elaboration, so that to be clear on its scope and to be clear on how arbitral awards could be enforced by its provision. I would be very happy to hear and to learn about the Indian practice regarding the treaty, but as I may understand that it's not widely applicable, because mainly it's the New York Convention that governs the enforcement of arbitral awards, not the bilateral treaty.
Thank you, Mr. Alexander Kosin, for your intervention. We really appreciate that in such a short time you could comprehensively put across how India, Russia could resolve their problems regarding enforcement of awards, arbitration awards, and how the investment treaties executed between the two countries would be conducive to the enforcement of those awards. So thank you so much for joining us. Now I would request our my co-chairperson, Dr. Gigi Hegde, to first make his comments before I invite the audience to respond. And Dr. Hegde should not run away. Gigi Hegde, I'm looking at him because possibly I'll request you to speak after the chairperson, after the co-chair has spoken. Yes.
Thank you, Mr. Ganguly. I think it's very difficult. I believe in learning international law the traditional way. Let me clarify. That is, basic concepts. Basic concepts are basic concepts. We are dealing with a number of topics which could be categorized under international economic law, international trade law, which in today's parlance it is World Trade Organization, and then international commercial law, and then we have this international investment law. So my first observation is I'm quite thrilled to look at the issues raised by all the presenters here. And I must place on record the attempts they have made, and it is well taken. I think there is enough to ponder over the issues they have raised. My second observation is particularly in the context of international commercial arbitration, and then dispute settlement under WTO, then investment arbitration. So between international commercial arbitration and international investment arbitration, my personal view is that we have to ask the question, when did the discipline of international commercial arbitration arise? How did it go in the last few decades? The same question must be posed to international investment law as well. When these two, when was the time these two disciplines merged? And is there any time these two disciplines depart? I mean, these are most important things when we apply a particular international legal principle applicable to one discipline and then transposed to the other discipline. This is my general observation. Otherwise, I'm quite thrilled to see the issues raised by each of the presenters here, and I'm grateful on my own behalf and on behalf of the co-chair and on behalf of the audience as well. And now there are well-known international trade law experts here, so we will. I give the floor to the co-chair.
Thank you, Dr. Hegde. May I now this is all open to the floor now, but may I request first Professor Hegde, who had been teaching this subject for many, many years, and we have so much to learn from him. Would you please say something on the subject? And do you have a mic there? Can you provide, please? Yeah, we're getting you a microphone there.
Actually, I don't have much to say, but still I think it revives me. Of course, I'm teaching for last about 2 decades. Before that, let me also make a confession. I was on the working group of the Ancitral as a part of the ministry, as I was working in the ministry that time in the legal division. I attended 3 years, and actually it was on New York Convention, enforcement of arbitral awards. Particularly, the guidelines were issued that time. Guidelines as to how to interpret some of the provisions of the New York Convention, 1958 New York Convention on enforcement. There were certain issues, like, for example, one of the interesting issues, which of course, if you look into the travel proprieties of the New York Convention, I could able to first get the printed original version of the travel proprieties from the Ancitral Secretariat, because I continuously went for almost 3-4 years, thanks to the ministry. Then the first problem was about how to define an agreement or a contract should be in writing. So they wanted to define what is writing actually. So it was in 1999, 2000 and 2001. Still we are not into digital age, but we were coming into that. But actually there were a number of areas where contracts were made without writing, particularly in shipping, salvage contracts and many contracts. So that was the first hurdle they had to cross, and they came out with an entire notes on that particular issue. Maybe that would be a good idea to look at actually. See, Ancitral has actually come out with an entire set of notes
regarding as to how to interpret the provisions for implementation of the enforcement, the 1958 convention. And then secondly, some of the work also went into that time in consultation with the Ministry of Law and Justice. This takes back me to many years. You were also there that time. I consulted many senior advocates of Supreme Court that time to amend the Arbitration and Conciliation Act. There were consultations held within the Indian Law Institute with the Ministry of Law and Justice. The major problem which about the arbitration is about the number of, particularly in India actually, the number of adjournments, how to go about doing it is more procedural actually, not than substantive. And most of the, although those days, I should critique it since I am in academics, most of the people who, I don't want to name them, they wrote a book as well, that they did a lot of work. They brought out a big Arbitration Conciliation Act. What is Arbitration Conciliation Act? 95% is UNCITRAL actually. It did not adapt to the Indian conditions. So that's another problem. Although you are not involved, but there are others, I don't want to name them, but they claim that they did a great work. But actually, if you look at the English Arbitration Conciliation Act, they did more original work, because I was in consultation with many of the colleagues at that time. But unfortunately, India did not, and it happened to, same thing happened with the competition law as well. Although there were two reports which came in 2003 and 2004. I was privy to that as well, but these were my active practicing days. Then I decided I think better should get back to academics. So I'm in academics teaching. But now this recollects me a lot of these ideas, which have come up. The other point which at that time, on the amicus curiae things, we were dealing with WTO cases that time. I was also part of that case that time. We were discussing with Commerce Ministry and things like that. Amicus curiae, its word used in Article 13 is to seek information. I think the word is seek information. See here, whenever we talk about international arbitration, I think up to a point I agree with Dr. G.G. Hegde and also with Mr. Ganguly. Both have a lot of experience, particularly Mr. Ganguly in this case. One area where we need to be careful is whether it's investment enforcement of issues, arbitration issues, or this arbitration, international arbitration, whatever it is, where you have private parties are also involved. Particularly when states are involved, you need to have this idea of the state's sovereignty in making legislations and implementing them. In case if there are several cases, I'm sure we talk with a lot of enthusiasm about amicus curiae and all that, but at the same time, states have obligation. In case Supreme Court gives an order saying that tomorrow there is not going to be anything on Vedanta, it has to be closed because it's going to affect Namgiri, tribal rights, that should be respected. But in case if you take it to arbitration, that has happened. In Latin America, there are, in Mexico and in many countries, these cases have come up. But where is the sort of space for the states to come out with legislations which are very important? It has happened in Trinidad and Tobago and other countries where they had to, for example, for tourism, certain resorts were constructed and they had to really environmental application of law. So you need to also, although there are of course variables like states corruption etc. are there, they do many things, but state sovereignty needs to be maintained. So in this sense, for a long time there was no proper assessment of this, basically certain, I'm sorry to use the word, certain coterie of private lawyers around the world actually did this, in my view, of course, which I agree up to a point, in investment arbitration, and they intelligently did it, tying up the MFN clauses, etc., which came up in the first batch of arbitration. But at the same time, the problem was this MFN and things like that. So India and many other countries decided to reject it because of that. But in the second batch, they tried to remove it, but tried to do something. And now it has become a really hodgepodge. But that's a different issue. The issue is we need to maintain the balance when a state-centric issues come up, particularly when you have to enforce certain rights which are essentially for the public good. So how do you define that? That's very important, particularly in the context of international investment law, actually. Of course, Australia did it in the Philip Morris and things like that, but this is increasingly becoming difficult. I'm not saying that this is wrong, but at the same time, finally, I think the draft which came out of the Institute of International Law, that Institute Droit International, finally took it up and decided, it's one of the very respected international body of lawyers. They came out with certain sort of a restatement of the laws, which I think we should see. I would rather see that first and then assess the things rather than looking at some of the assessments made by, because this is an intersection of international relations, state sovereignty, and international law, and also the interface with domestic law. I'll stop at that. Thank you very much.
Thank you, Professor Hegde, for your enlightening the entire audience here, including us, me particularly. You are always so informative. Now, may I request Professor Jairaj to say something if you wish to input. He is an all-rounder, so it doesn't require a subject.
I would have, of course, the points that Professor Hegde made regarding the ISDS, Investor State Dispute Settlement. Just yesterday I presented a paper here. It's about the arbitrators. He almost said that coterie. And I read a lot in the last 20 days how this coterie works, how the international law firms, 10, 20 of them have emerged in the College of Arbitrators. They are the counsel, they are the arbitrators. They are the experts in giving evidence, and they go in one matter as arbitrator, in another matter as a counsel. So this question, there is a notorious word called double hatting. Now this double hatting issue that is why we suffer. But this morning somebody presented a very good paper. I don't know. I think that a government of India has created a think tank and also kind of producing lawyers, if not coterie of lawyers, at least with the third world perspective. So I think that is what should be done actually, to train capable Indian lawyers to appear for Indian cases. And in course of time, the Indian lawyers will be taken by the rest of the third world also as arbitrators, counselor, and expert witness. That's one important thing. The working group 3 of the UNCITRAL is currently working into it, from arbitration ISDS to a multilateral standing mechanism by way of a tribunal. So the role of the arbitrators will be reduced, and the movement of dispute settlement will move from this investor state to the multilateral thing. So I think,
more institutionalized rather.
No, there is a problem that there is they are trying to see two tiers. That means one mechanism is that tribunal will be created, and then the tribunal, there will be also an appellate tribunal in the same document.
Yeah.
But what they do right now, the appellate tribunal will be a tribunal, not only will see the investment disputes coming from its own tribunal, but from ICC, from ICSID, from any area of arbitration. So I think that is much wider. That reflects also the European Union's desire to have a multilateral court. So this is what just I can
Thank
say.
you.
There are things, but then I want to endorse his words, which I was sharing with him. They have done a great research, each one of them. It's a wonderful panel. I am really appreciating once again all of you so much for enlightening us.
Thank you for this. Yeah.
First, we will thank the presenters.
Yeah, you do that.
Yeah. Lastly, I thank each of the paper presenters here, and also the participants, and in particular Professor Hegde, who made a very meaningful intervention along with Shri C. Jairaj. Thank you. This session is ended, and there is an announcement. Please stay tuned.
Yeah, please.
You can.
There's some announcement for all of you.
Now I would like to request Professor C. Jairaj to facilitate Mr. A.K. Ganguly.
Oh, that's so great, Jairaj. Thank you, sir, for gracing us.
I would request sir to also facilitate Professor G.G. Hegde.
Thanks for sharing the session.
So shall I start? Okay. So welcome and good evening to the 10th International Conference on International Law, Issues and Challenges organized by the Indian Society of International Law. The session is on SARC due diligence mechanism. Our first chairperson is Shirley Scott, who is a professor of international law and international relations in the School of Humanities and Social Sciences at UNSW Canberra. She is a recognized researcher at the intersection of international law and international relations, which is especially relevant in the light of current geopolitical and environmental challenges. She is also at the forefront of international debate regarding what constructive role the UN Security Council could play in addressing the climate insecurities. She's accompanied by another our chairperson, who is Ambassador Narendra Singh. He is Secretary General of Indian Society of International Law, Professor of Law at Maharishi Law School. Further, he is a Chairman of International Law Commission, United Nations 2015 at Geneva. And we have 8 to 9 speakers here. I would request our chairperson to begin with the session. Over to you, please. Sir, ma'am, any one of you.
Well, thank you for the kind introduction. As you mentioned, we have a topic for this session. We have a panel on the SARC due diligence mechanism. And this panel will deliberate on establishing of a SARC due diligence mechanism similar to that under the CEDAW Convention, and to deal with issues relating to gender-based violation. We all know that crimes regarding gender-based violation are endemic to the subcontinent, and women lack effective redressal mechanisms when they become victims of such crimes. Frequently, the jurisdiction of such crimes are taken together with other jurisdictions like family law and property, and there is a lack of a specialized mechanism, which results in inadequate solutions being offered, and the efforts of investigation, etc., also they don't receive the due attention that they deserve. Now, under CEDAW, all the states parties have compliance obligations, reporting obligations, and the violence against women is one of the issues which needs to be taken up seriously, where we are lacking, and we hope to hear more, get more information today from our panel on the extent of the problem, the seriousness of it, and how best we can tackle it, and what mechanisms can be established to deal with this and to find solutions for it. So our first panelist, I would call on Shritha K. Vasudevan of the University of Adelaide, Australia.
So I'm going to propound the case for a SARC due diligence mechanism as an outcome of Giovanni Sartori, who was a political scientist in 1970. Right? I mean, in 1970, he propounded the ladder of abstraction. He said that the most lamentable thing about political science was that problems were not capable of conceptual traveling, and which meant that concepts evolved in the West were not, could not be carried across time and space. So, how is this relevant, to a due diligence mechanism in the SARC region? All I'm saying is something very simple. The CEDAW has the due diligence obligation, the obligation to prevent, prosecute, and punish all forms of gender-based violence. It is forthrightly enshrined in General Recommendation number 12, number 19, and number 35. And all I'm saying is that you can take it, travel down the ladder of abstraction, and come into the Indian society, come into the subcontinent, and then have an exclusive mechanism on a gender-based violence within the SARC region. So what does Sartori say, right? You have to generalize from big abstractables, have big generalizations. So when you look at the empirical universe, what is the biggest generalization that is present as far as women's rights is concerned? That is the CEDAW, right? It is the foremost international instrument on women's rights. It was evolved out of a commonality of world consent, and scholars and activists worldwide, renowned scholars and activists embrace it. They routinely come up before the CEDAW committee. State parties come up before the CEDAW committee. They present reports. And so because of this consent, it is something that is a big observable in the universe. And as one gazes at the gendered system of international affairs that is readily discernible, one is confronted with a regime of gender-based violence. And I say almost, right? We have the Belém-de Convention, we have the Inter-American Convention, we have the Istanbul Convention. So there is almost an incipient regime. It is time for a regional mechanism in the SARC region. So one way of effectuating India's obligations under the CEDAW is to effectuate its due diligence obligation in the subcontinent. So all I'm saying is, how about we have an exclusive tribunal on gender-based violence in the subcontinent? It's quite simple, right? The idea is quite simple. And as Sir was talking about it, it takes like 4 years for a simple case of domestic violence to go all the way, to be adjudicated. And in between, we're going to have a lot of problems. And one of our panelists is going to talk poignantly about the problems she's been facing. So I'm just saying that we can have an exclusive mechanism on the on gender-based violence modeled on the CEDAW committee. So the headquarters should be headquartered in New Delhi, as a fulcrum of power. India is the regional hegemon. And I'm going to talk about regime theory, that to have a stable regime in the region, you need to vest the authority, or you need to vest authority in the hegemon in the region, in the powerful hegemon in the region. Only then, is that tribunal going to be successful. And this will also demonstrate the firm and unequivocal commitment of India in complying with its CEDAW obligations. So I'm going to present a theoretical rationale. I'm going to just examine a case study in 3 countries, and then I'm going to present the rationale for a SARC due diligence mechanism. So I'm firmly of the opinion that the SARC due diligence mechanism should be at the helm of affairs in New Delhi, as I've stated. It will concentrate power in the hands of the stable hegemon in the region, India, and reinforce the legality of the mechanism. So the proliferation of many regional mechanisms on gender-based violence should provide the impetus for the government of India to launch its own SARC due diligence mechanism for the stabilization of a regime on gender-based violence in the region. And we have to note that we still don't have a single regime on gender-based violence, though it seems really counterintuitive. So how does regime theory relate to a SARC due diligence mechanism? The SARC due diligence mechanism is a way of thinking about the international society that will consciously socialize its members to conceptualize the issue area of GBV in one particular manner, that is the Cedoyan way of thinking, right? We can impose this perception on GBV on the other SAARC nations by conditioning behavior on a gendered path and creating a new intersubjective understanding. So by creating a language of gender, I mean, we are united, we are probably disunited by cultural ties, but united by the common language of gender, we can generate the movement of ideas on the basis, in the SAARC region. So what is the most problematic issue, right, in the subcontinent? It is this Hobbesian anarchy with Pakistan. So India should strive to replace the intersubjective perception of Hobbesian anarchy with that of a gendered peace. So the SAARC due diligence mechanism will create a new structure of intersubjective expectation that will hopefully surmount the endemic anarchy in the region. And I propose this idea that we hold the security relations constant, ceteris paribus, as in political science, and then we move forward, we open a separate diplomatic channel of communication with Pakistan on the basis of a gendered peace. So it will add to the status and reputation of India as a law-abiding state, right? Under Article 3 of the ICJ World International Court of Justice Charter, we are part of the community of the civilized nations of the world, and we have to live up, to that standard. So India can create a structured perception of itself cognitively in the international community by promulgating the SAARC due diligence mechanism. So when we talk about the domestic implementation of international norms, the international norm on a right against GBV can matter only when it is actively incorporated into domestic processes. So India has shown the way, right, with the enactment of the POSH Act, which references the CEDAW in its preamble. There should be a concerted effort in legislation. And we all know the government of India has promulgated policies like its Mission Shakti, the Nirbhaya Fund, the Pradhan Mantri Matru Vandana Yojana, to name a few. So I know Western feminist international relations castigates the entity of the state, but in India, the women's movement and the government of India is inherently linked, to the liberal mechanisms of the law to further the feminist cause. So rather than complete castigation of conventional IR scholars for their state-centered approach, my paper aims to evolve a state-centered, gendered approach in the South Asian context. So, talking about Sartori's ladder of abstraction. So, like I said, one of the main laments of American political science in the 1970s was that it did not consist of concepts capable of traversing empirical universes. The need of the hour was identified as generalizable universal concepts that withstood the scrutiny of time and space. And I repeatedly emphasize that because the CEDAW has been drafted with a commonality of the of world consent, it is a mechanism, that can travel across time and space. I'll quickly go over to the studies that I've done. So the first study was a study in India, and women compromised on the violence due to fear of separation or divorce. They were embarrassed to talk about the violence. The Nadal family suggested to put up with the violence, and they offered help as a last resort. So when talking about patriarchy in Pakistan, there was controlling behavior by men, and there was a religious prescription that women were chattel, they were property, and they were meant, to be subordinate to their husbands. The act of resisting is considered as going against the will of God. Religious prescription mandates the husband to be in the state of a divine relationship with the wife and hence cannot be opposed. And then coming to Bangladesh, there was a culture of hegemonic masculinity. There was a culture of forced marriage and marital rape. So I would like to conclude by saying this, that we need a SAARC due diligence mechanism to consolidate a mechanism on redressing gender-based violence in the region. So the Sartorian ladder of abstraction is an important conceptualization for linking the CEDAW to a SAARC due diligence mechanism. We all need to collectively stand together and take forward the initiative of establishing a SAARC due diligence mechanism in the region. Thanks.
Thank you, Rita. I now invite Dr. Megha, University of Delhi, and perhaps you would like to reflect on the efficacy and the feasibility of establishing a SAARC mechanism at a time when SAARC, as was pointed out by one of the commend audience in one of the panels that SARC meetings have not been held for several years. So in an atmosphere like that, can we think of a SARC mechanism, or should we think of strengthening the domestic mechanisms which we already have? Thank you.
Okay, so a very good evening to everyone. My topic is SARC due diligence mechanism and non-recognition of rape within marriage in India, a critical question for a comprehensive approach for gender-based violence against women. International law recognizes a state's obligation to adhere to a standard of due diligence when addressing the issue of gender-based violence against women, and for this purpose, the standard comprises 4 equally important obligations: prevention, investigation, prosecution, and compensation. When we are talking about prevention, some articles like Article 1 and Article 5A, they both are important, and general recommendations like GR 19 and GR 35, they are also important because like when I talk about GR 35, it is more important because it is directly talking about criminalizing marital rape. And then there is this idea of investigation and prosecution and compensation, and what this paper argues that without having that idea of prevention of marital rape, we cannot talk about proper investigation, prosecution, and compensation. Now if you look at due diligence mechanism that has been adopted by CEDAW, then we will find that Article 1 to 16 incorporated within Part 1 to 4 have adopted a comprehensive approach towards gender-based violence against women. Violence and freedom in all aspects of social, political, economic, cultural, and personal have been well explained, and proper mechanism has also been dealt with the involvement of state and non-state parties. No distinction has been constituted in terms of women within marriage, women out of marriage or without marriage, women who are sex workers, and women who are mothers. Violence and freedom have not been measured on the continuum of different identities and violence defined by hegemonic masculine frameworks and interpretations. On the same bedrock, the paper proposes the due diligence framework for SARC member states based on its ontological grounds. SARC aims to promote economic growth, social progress, and cultural development in South Asia, dealing with different issues like agriculture, rural development, education, security aspect, environmental issues, and others. And here I would also like to appreciate SARC for launching Gender Info Base SGIB in 2008 as one of the key goals of the MOU between SARC and UNIFEM, and is being seeded with information and data on following issues like violence against women, especially focusing on trafficking, health issues like HIV and AIDS, and feminization of poverty. With SGIB, SARC has recognized the gender-based specificities of vulnerabilities experienced by women. Here, the paper strongly argues that there is a need to have a due diligence mechanism for gender-based violence against women initiated by SARC because due to patriarchal culture in all its member states, gender hierarchical structures prominently define, determine, naturalize, and make women's subjugation apolitical. It's very important to mention here that all member states of SARC are committed to gender equality within their respective jurisdiction, which is enshrined in their constitutions and laws. Moreover, due to their contextual and relational ontologies, it would be easier to frame and communicate due diligence mechanism for gender-based violence against women. However, the paper states that the biggest hurdle in the path of these SARC member states' potential to promulgate this due diligence mechanism is their own approach to looking at violence against women on the continuum of identities and sexual violence, and to categorize and differentiate women on the basis of their social roles. The paper insists that a substantive SARC due diligence mechanism for the prevention of gender-based violence against women needs to have a comprehensively inclusive, gender-sensitive approach where equality should not be conceived exclusively between men and women, but between women and women also. Justice should not be denied to women because of their adjectives, quote unquote, being married, unmarried, sex worker, mothers, when it is a matter of their bodily integrity, which should be considered considered as a foundation of all freedoms for women. In this light, the paper takes rape within marriage as a case for comprehension because, except in Nepal, rape within marriage has not been recognized as a criminal offense in any of SAARC member states. And keeping in mind the ongoing debates on the issue of rape within marriage, the paper exclusively takes the case of India with two-pronged interests. Number one, the paper argues that being one of the strong democratic states committed to gender equality and justice, India has the potential to play a central role in bringing due diligence mechanism for gender-based violence against women. And in that context, to have a comprehensive approach, there is a need to recognize rape within marriage as criminal offense, because acceptance of rape within marriage constitutes the basis for rape culture in public sphere. Second, by criminalizing rape within marriage, India can set an example for other SAARC countries and can initiate the idea that marriage is Indian culture is legitimized on the basis of love and respect rather than rape. And with this, India can portray its role as Vishv Guru in practice. Section 375 of the Indian Penal Code, which I think that it's very important to talk about, which categorizes rape as an offense in the country, exempts rape by a man of his own wife from the offense. Even the Supreme Court of India affirmed that marital rape is not a criminal act if the victim is above the age of 18 years. The non-recognition of marital rape as a wrong renders the women of India devoid of any mechanism by which they can obtain redress for an otherwise internationally recognized human rights violation. The lack of recognition and redress could even have adverse physical and psychological implications. Over 2 decades after the 1983 amendment, the Indian legal system drafted another Criminal Law Amendment Act 2013, which we all know took place after Nirbhaya case. It clarified 7 criteria that define rape as per Section 375 of the Indian Penal Code, which provides a clear understanding of consent. Consent means an unequivocal voluntary agreement when the women, by words, gesture, or any form of verbal or non-verbal communication, communicates a willingness to participate in the specific sexual act, provided that a woman who does not physically resist to the act of penetration shall not, by the reason only of the fact, be regarded as consenting to sexual activity. Again, this definition of consent does not exist for married women. Regarding their husbands, verbal and non-verbal gestures, communication, and physical resistance do not activate when it comes to married women. Even this refined definition of rape has expanded the exception by including sexual acts by the husband apart from sexual intercourse. The legal position on rape so far reveals that the legal definition of the offense of rape is more concerned with the regulation of sexuality rather than the protection of bodily integrity of the woman. Moreover, the law works on the distinction between virgin and non-virgin. Only virgins have the right to get legal protection from wrong perpetrator, and non-virgins such as wives do not have the right to claim protection by the law if the perpetrator is the right person, that is the husband. So the husband's sexual rights over their wives are kept above the law and the state as well. Though I have done an intensive work on that by taking 1300 women's interview, but I would not like to go for that. But what I have come about is that how the legal and socio-sexual framework is working on two dominant discourses of heterosexuality that actually provide a cultural foundation on which heterosexual relations in India are organized and by which masculinity is normalized within marriage. First is male sexual drive discourse, which holds that the drive or need to have sex is uncontrollable for men, and this is overwhelming drive which is considered to be natural, and it has been observed in many rape cases where the court has given decision like where the natural instincts of men has been taken as normal. Thus a man can go to a great length to satisfy this need, which is justifiable within marriage because it is considered normal to play their sexual drive on their wives even in violent ways. Second, that is have-hold discourse. It has played an important role in shaping women's sexuality to men within marriage. Women's sexuality to men within marriage. Women's sexuality is considered asexual and must be viewed within the parameters of monogamous heterosexual relationship for producing children. Some also consider a woman's sexuality as dangerous and always in need of control. A masculine legal heterosexual matrix makes it very difficult for women to step outside this discourse. When a woman is not considered sexual or attractive, she is often labeled as ball breaking, a cock teaser, frigid, a cold bitch, or uptight. If a woman woman doesn't show her interest in sexual acts with her partner. She herself enters a discursive space riddled with pejorative and potentially punitive consequences, which leads to the divorce also. Since the law does not provide a definition of consensual sex, rape trials tend to carry traditional sexual norms forward. Often the defendant tries to present rape as normal sex because the latter is far removed from mutually negotiated, mutually satisfactory sex between equals. In reality, the legal view of normal sex encompasses a masculine interpretation of women, accusing to sexual use by men. Mutual negotiation is not a test of normality. Just 2 minutes. I would also like to talk about, much awaited Domestic Violence Act, and it is always argued that Domestic Violence Act is incorporating marital rape, but it's not reality, because Section 3 is actually talking about sexual abuse, and there is a difference between sexual abuse and rape. For example, a man can be sexually abused, but he cannot be raped. So we do have a different understanding. So in contrast to the state and judicial paradigm, which does not incorporate and even emphasize the absence of language of sexual danger for wives within marriage, the paper comes with the experiences of women who are suffering from rape by their husband. As I have told you that I have taken 1,300 women's interview, and we are able to explore with those interviews, yes, women are suffering with marital rape, and this is beyond our thinking that what kind of sufferings they are having. The understanding that paper is coming up is that in order to depart from the patriarchal underpinnings of law and society, there is a need to work on language, because rights and languages are interconnected. Due diligence mechanism would be having that language. Criminalizing marital rape would be having that language. The language of Indian rape law: sexual intercourse or sexual acts by a man with his own wife is not rape, provides the husband the right to rape his wife. It is a legal language that develops because of which the husband conceptualizes himself as the owner of his wife's sexuality, which further legitimizes the rapist husband behavior and is accepted and emphasized. In most of the interview of the victims, in most of the interviews of the victims, it is found that when wives restrict their husband from having sex, they reject it by insisting that it is their right to have sex, and define the wife's duty to be available for sex all the time. Phrases like "I am your husband" and "I have right to sex with you" and "you don't have right to refuse" and "it's your duty" illustrates the prominence of masculine rights and duties in the minds of men who rape their wives. It is very much clear that husbands rape their wives due to that sense of legal privilege, which is re-emphasized by the language of rights and duties prescribing husband and their wife's sexual roles and identities. So the debate so far, there are many debates which are going on. For example, Gujarat High Court in 2018, they also accepted this idea of the importance of criminalizing rape within marriage. In 2021, Kerala High Court also recognized marital rape, and in 2022 there was a split verdict on the criminalization of marital rape, and you all know that the month of November is going to be crucial for that purpose. So the debate so far demonstrates actually the democratic character of Indian state, which could be institutionalized on an international platform by criminalizing marital rape, as it would pave the way for India to initiate a comprehensive approach to gender-based violence against women, and would definitely promulgate due diligence mechanism for SAP. Thank you so much for the patience.
Well, I thank Dr. Megha for highlighting this very important issue of marital rape. As you mentioned, this issue is currently before the Supreme Court of India. And however, this is not the first time this issue has been raised. It has come up for discussion whenever India presents its reports before the UN Human Rights Committees. And those committees also have recommended that India should adopt a law outlawing this marital rape. Justice Verma Committee also in 2013, they had recommended adopting a law on marital rape. And I think we would do well to emulate what the British courts have done. Even without enacting new laws, they have interpreted the laws to outlaw marital rape. So now we come to our next panelist, Mr. Dinesh Tripathi.
Thank you so much, Ambassador Narinder Singh. And first of all, I would like to thanks Sritha that she has taken timely initiative. That this is a high time that SARC nation must show a political will, political courage, and muster their political will to have some kind of a mechanism at the regional level to address this issue, because the violence against women is the worst kind of violation of rights of women. Women have also equal right, and women have right to meaningful participation in the national affairs, in the social affairs. So because of the violence which is perpetrated against the women, so they are not allowed, they are discouraged to participate in the national process, social process. So violence is a big hindrance. And now look at in South Asia, there is a massive violation of women's rights. Women are facing discrimination. Women are facing massive violation and violence also at the societal level, as well as at the domestic violence also taking place. They are also subject to political violence. So because of violence, their agency of women has been undermined. Their right has been undermined, and their right to have equal participation, and they have also a full dignity, full right to full citizenship. So because of violence, and their right to dignity has been violated. So there is a normative framework convention. It's called CEDAW. So CEDAW, it outlaw violence, and under the CEDAW, I think most of the South Asian nations, they ratified it with some reservation. There are some nations, they have also some reservation as well. But I think that all the South Asian nations who are not ratified it, they must ratify it without reservation, and they should implement, have all the legislative measures they must adopt, because under the CEDAW, the member state, the who became the state party of the convention, they have they are under international obligation. They are under the treaty obligation to implement full implementation and effective implementation of the CEDAW convention. So under that convention, they have obligation to take legislative action. CEDAW said that, and they have an obligation to take administrative action and all other action to full implementation and effective implementation of the convention. So if there is a violence is taking place against the women, it means that it's a serious violation of the CEDAW convention. And since rights of the women need to be protected under all circumstances, and there shall be no excuse. Even the war is also not excuse that the rights of the women has been violated or they are facing discrimination. So one thing is that if any laws, any policy, and is not good for women, it is also not good for the nation. So so all the laws, it has to be a gender friendly. It has to be women friendly. If the law is not women friendly, it means that it is also not good for man. And there is no zero sum game. There are some kind of mindset that if we ensure the rights of women, if you provide the full-fledged rights of women, so even the right of the man will be violated. It's not like that. There is no zero sum game. We can create a win-win situation, and if the rights of women are protected in a full-fledged manner, then there will be a civilized society, equitable society, and even the rights of man will be also protected. So like as Ambassador Narinder Singh, he said that okay, the SARC is not moving forward, but I would say that SARC is almost dead. But at the same time, I also say that SARC is dead, but long live SARC. We have to we have to revive the SARC under any circumstances, because look at this age of regionalism. Look at the Europe; they are making progress. Look at the ASEAN; they are also making progress. But we are blocked into the hostility. There is a lot of animosity within the SARC region, and so how you can create culture of trust? And because we are suffering from deficit of trust. So how you can bridge the gap, and how you can work together for the better future? Because you have a common future and we have a common problem, and our problem can be tackled in a collective manner. There are so many problems you cannot tackle only by the nation state level. You need some regional effort, because this is the age of regionalism. So there are trade blocks are coming up all over the world. So South Asia is a rich, there is a rich human resource, there is a rich natural resource. But why we are lagging in poverty? Now, why became the poverty belt of the world? Because there is a heavy militarization, there is a mutual deficit of trust, and there is no cooperation, there is no trade among the South Asia region. So how you can enhance the trade, investment, and peoples to people relation, which is very important. If track one diplomacy fail, we also apply a multi-track diplomacy, people to people diplomacy. So that is very essential, and this is a high time that SARC nations, they must show the political will to move toward more regional cooperation, and at the same time not only in the terms of trade and investment or in all those things, but in terms of human rights also. Look at, there is in morning session I also mentioned that there is a success story of European Court of Human Rights. There is a success story of Inter-American Court of Human Rights. But look at, in the SARC region, we don't have any mechanism. Even the Arab nations, they have some kind of mechanism, although it's not very functional, but theoretically they have some mechanism. So, regarding the violence against women, so what's the wrong if you can have some kind of regional mechanism, due diligence mechanism? Of course, what I believe that the regional mechanism cannot replace the domestic mechanism. Of course, we need a regional mechanism. We need an international protection of human rights. We need an international protection of women's rights. But at the same time, we also need a robust mechanism at the domestic level. If domestic level if you don't have a robust mechanism, then the regional or international mechanism doesn't work. So first we need to, because the fundamental and primary duty of the particular nation, particular state, to protect and promote human rights. International mechanism or regional mechanism, it play only a supplementary role. And if it cannot replace the domestic one, but what you need at this point is that we need additional safeguard. We need additional safeguard. Like look at the Europe. It's not like that any European citizen can file a case in European Court of Human Rights. It's not like that. First, we have to adjust all the local remedies. Local remedy need to be adjusted. Only you can go to the regional court. Only you can approach regional mechanism. The same case is also regarding Inter-American Court of Human Rights. First, we have to adjust all the local remedy. Look at the CEDA. There is a treaty body, so it also look after. But in order to have a communication, because look at ICCPR, it has a optional protocol. So in order to utilize that mechanism, first we have to adjust all the local remedy, and the justice has to be denied. Only that case you can go to the file individual communication in the Human Rights Commission. So it's like that. In the regional mechanism, you have to apply the same mechanism, because it's not like that in Nepal right is violated, Bangladesh the rights of the women is violated, and they are rushing to the regional tribunal. It's not like that. First, we have to adjust all the local remedies. It is a basic principle of human rights. Exhaustion of local remedy. Without exhaustion of local remedy, you cannot recourse regional or international mechanism. So I think that this is a high time. Now you have to show some political will, some courage. First, we make the SARC a functional reality, because it has no alternative to have a regional cooperation, regional interaction. It's very important at this juncture. So look at women are facing severe. I'll take severe crisis. Now there is some discussion about marital rape. So I'm proud that we are in Nepal. We are able to under our law, our criminal code. Now you have a provision for marital rape. There is up to 5 years imprisonment, and there are several cases are they are facing persecution in the court of law. So marriage should not taken as a license for rape, because it is also women have their own they have sovereignty over their body. We are not allowed to encroach their body without her consent. So my body, my right, So the marriage should not taken as a license. So at least Nepal has, enacted that kind of legislation. Even the court are giving verdict under that. And one more thing is that rape has been also used as a weapon of warfare. And International Tribunal on Bosnia-Herzegovina, in its verdict, it said that rape is a torture. So the tribunal said that, why it said that rape is a torture? Because the torture has a universal jurisdiction. If in a particular state, if there is an unwillingness or unable, lack of capacity on the part of the particular state to punish the perpetrator, then universal jurisdiction apply in case of torture. So since rape is also considered as a torture, so universal jurisdiction has to be applied. So if universal jurisdiction is applied, why there is no cooperation among the South Asian nation? Thank you so much for inviting me.
Thank you, Mr. Tripathi, for telling us about the amendments and changes made in Nepal's law regarding marital rape. I think that's a very important development we should take need of, and also highlighting the need for reviving SARC rather than just accepting its demise. Now, our next speaker is Dr. Bhavna Rao, but she's not present here, and Shrita will speak on her behalf.
Okay, so Dr. Bhavna Rao is a legal academic and expert, and she was until quite recently at UPES in Dehradun. So she's given me a response paper to my paper on the SARC due diligence tribunal. And she's propounded the argument of a golden balance, the argument that India is low on indicators, which calls for a leadership role, versus it being seen not as competent to run the initiative. So the question is the fact that India is very low on its indicators, gender-based indicators, is that a reason to deny India the leadership capacity versus it being a regional hegemon in the region? So another point that she raised was that a uniform civil code will actually help the SARC tribunal. So it will help in problems facing the UCC, if we have a SARC due diligence mechanism for legislations coming out in the near future. So if the government comes out with the UCC, it will facilitate discussion and dialogue over the UCC. So unless we have some form of due diligence mechanism on GBV, we cannot meaningfully discuss the Uniform Civil Code, right? I mean, these questions are interrelated, that of the Hindu personal laws, that of gender-based violence in Hindu society. And so, and the same is, I only speak for the Hindu religion, so the same might be true for the other religions as well. So the other question was the enforcement power of the tribunal, right? So will it should have the binding power of the member states. So in WTO disputes, nations are not adhering to the tribunal's orders. So there requires a high level of diplomacy and enforcement through the member states. So a main question that we have to think about, the devil's advocate, is will Pakistan adhere to any of the rules of the tribunal? And I think Mr. Dinesh Tripathi sir was quite right. Like, we have to exhaust regional mechanisms and then approach the interregional mechanism for the success of the tribunal. So a question that was raised by the government of India in our discussions was, why are we proposing the SARC due diligence initiative as opposed to the BeamStec initiative? And then Bhavna says that with Thailand, we don't have a common cultural connection. It would be difficult to establish, a tribunal with a country as far away as Thailand. So all of us are Commonwealth countries. We are English-speaking countries, and our codes are more or less similar. The criminal codes are more or less similar. And so there will be since Thailand is not an English-speaking state, there will be a communication gap. So, we can have a SARC initiative, we can have a BeamStec initiative. So if Thailand wants to join, we can as well join. So we need to develop some deep strategies. So Bangladesh currently is facing problems. So grassroots are difficult to examine, and Indian civil society is not very strong. So if the tribunal can the tribunal has to reach to the lower level, and we have to improve our grassroots organization. And the states do not use English. The BeamStec states is what she meant. So we have a Commonwealth connection. So we have a cultural contiguity. So another point that she made in favor of this mechanism was there is a robust legal mechanism at the grassroots level. So the Gram Nyayalaya Act or Legal Aid Act can be used to support the argument that we need a seat at the tribunal. So it is only India that has a Gram Nyayalaya Act, and then we can rope it in for the SARC due diligence tribunal. And she has told me to explore more on implementation challenges and potential political and cultural issues. And she's commended me on it being a very strong proposal and highly original, and it's a valuable contribution. Thank you, Bhavna. So we conclude by saying that India should be the seat of the SARC initiative, because it is indeed the regional hegemon. Thanks.
Thank you. And now is it Dr. Kokila? Is she speaking online? No, she's not here. Then Dr. Sapna.
Yeah, Sapna's online.
Sapna is online. Yes, we'll have Dr. Sapna online.
Yes, I'm here.
Speaking from the University of Kent, the United Kingdom.
Yes, thank you, sir. Good evening, everyone, and thank you, Shweta, for allowing me this opportunity to respond to your paper. I'm glad that you asked me this. So what Shweta has asked me as part of my engagement is to reflect on her paper, drawing from my research experience on the localization of human rights, as well as working on regional cooperation. Well, my work is more on international cooperation, so Shweta has asked me to engage with the regional cooperation aspect of it. So what I will be doing in the next 10 minutes or so is to reflect on the mandate and process of the proposed SARC due diligence mechanism that Shweta has done so in her paper. But before I do that, I would like to also contest this question of identifying India as the ideal seat of the forum for the SARC due diligence mechanism. Because Shweta, when I read through your paper, I saw that you start off with an optimism and you give quite convincing arguments as to what are the benefits that India can gain by leading the pioneering role as the main actor for providing the foreign space for the due diligence institution. But what was unclear to me, and it seems so for you as well in the latter part of your paper, you do engage with certain research that looks at the continuing prevalence of violence against women in India. For example, you quote Napri Kaur and Roger Beard's work on the bride deaths and the bride burning and the continuance of the bride deaths in many rural parts of India, as well as Dirabendhu Mundal and Pinto Paul's work on the cultural aspects of a continuation of domestic violence in many of the economically marginalized sections of the society. So that part of the social and the cultural and the political capital of India as a seat for the forum was less convincing for me. And I think that's something that would need a bit more fleshing out. Now, coming to my very brief points on the mandate and the process of the due diligence institution. First, looking at the mandate of the due diligence institution, what the paper proposes is a forum where the different SAARC countries can come together and also provide a space for redressal mechanisms for women of the SAARC region to report on gender-based violence. What was unclear there again was the mandate, whether the due diligence body was going to be a monitoring body or whether it was going to be a regulatory enforcement body within the region. What I mean by a monitoring body is if we are following the CEDAW model of monitoring mechanism, a due diligence institution that would deal with monitoring mechanism need to ask the member states to provide annual reports so that the main due diligence institution can observe, compare, and rank societies as to where they stand with regard to the realities of tackling gender-based violence within their local context. But it wasn't quite clear within the conception in the paper. So that is, again, a clarity that if at all this project is going to take is going to come to realization, that is something that we would need to see a bit more engagement with. Like if it is a monitoring mechanism, how would this institution monitor the different realities of violence against women in these societies, which are quite socially, culturally, and politically different from each other? Because if you look at Sally Inglemerry's work on the functioning of the CEDAW committee and how the CEDAW committee observes and listens to the different annual reports from the countries, we can see that Mary draws in on like the instruments such as indicators, which allows the committee members to help the member states to report their local realities in specific frameworks. So then are we saying that for this particular due diligence SAARC model, we would be thinking about such comparing units through which we can observe the observe the reality of violence against women in the different SAARC region countries. The other issue that I wanted to raise was the question regarding the process that we would need to consider when we have a supranational institution such as the SAARC. And Dr. Megha's intervention is quite relevant here as well. So Shrita has conceptualized that due diligence institution can be set up by settling on an international settling on meanings of international norms against gender-based violence, but with embracing the historical and the national realities. But if we have to localize international norms, then there are many questions that come up with that. The first question is, especially with regards to how do we settle or get consensus on the idea of what kind of deviations will be considered as violence against women? While it might be possible to get a consensus on the grave acts of deviation of violence against women, it might not be quite straightforward for the minor degrees of violence. Why I say so is because from my own research on domestic violence and the localization of CEDAW within the context of post-conflict Timor-Leste, what I observed especially in rural areas of Timor-Leste was that when it came to minor deviations or minor aggressions between husband and wife, within a rural area, it was much likely that the women and as well as the local community were quite resistant towards recognizing that as an act which have criminal implications. Now, there are the reasons why they resist against it have got quite cultural, traditional, religious, economic reasonings to it. The cultural and the traditional reasonings go back to the idea of not allowing private issues to be aired in public and having state institutions engage with these matters which are quite private. The economic aspect or the economic rationale for not engaging or criminalizing these sort of minor aggressions is because women, especially in rural areas, rely on their husbands for economic sustenance because they do not go out and work. And the example of marital rape is going on the grave side of violence against women. So while we might be able to get a bit more consensus in the region on this particular issue, then again, there are questions as to what happens once we agree on identifying a common problem within the region. What are the ways through which we would address that problem? Again, what I can observe from the paper as well as from the other speakers is this move towards a criminalization of all forms of violence against women, which is what the CEDAW also lay out. But when we come to the local realities of many communities and societies, not all forms of violence against women and girls, or even boys and men, might not be welcome to be, like, not all aggressions would be considered to be of a criminal threshold, or communities might push back against the criminalization of such deviant acts. So how do we reconcile with these sort of tensions, especially when we are talking about societies which have quite distinct social and cultural realities at different spatial levels within their societies, like India, Pakistan, Bangladesh, for example. So those were my two questions. But I'm probably raising more pessimism in my interventions. But one of the ways through which I think that one can move forward, if at all one conceptualizes such a supranational body for the region, is the involvement of actors, not just lawyers, but also actors beyond the legal field, such as anthropologists, sociologists, who can help in understanding why violence happens in different societies within the SAARC region. What are the ways through which what are the effective ways through which such violence can be addressed within those regions? And how can we go about doing that? Is criminalization the best way to do it? Is the question that the people who are conceptualizing this idea need to think about. Or are there other soft social, cultural measures that are rooted within the local histories of these societies that we can bring together and still use that to recognize women's rights within these communities? Okay, with that, I conclude. And thank you again. And good luck, Shrita, on this very important project.
Well, thank you, Dr. Sapna, for your views. And Ms. Anjali Srivastava is available? Or?
I think she's available online. Can you just check?
Yes. Hello.
Yes. Hello. Yes, I give the floor to Anjali.
Am I audible? I'm audible, right? Hello?
Sir, she's asking if she's on.
Yes, we can see you.
Okay. So before starting, I would just give my introduction. I'm Anjali Srivastava. I recently got divorced at the age of 42 after being in a horrible marriage for last 17 years. And after my divorce in 2021, for last 3 years, I'm working as a project manager in Bangalore. So I'll be sharing my experiences with the Indian society police, and judicial system as I face them as a single parent and a single woman. So I would like to start my beginning, I would say, is from a middle class family. And that part of society from where I come, we are taught to be very nice girls when we grow up. And we are taught not to raise voice. No matter what, don't speak up. And this factor gets embedded in our DNA so much that even if we get beaten up, assaulted, abused, molested, anything happens, even if our bones get broken, we learn to keep quiet. I got married in 2004, and this was with everyone's consent. So I'm emphasizing here because it's important in Indian society whether you ran and you married or everyone's consent. So yeah, I got married with everyone's consent, but soon I realized that my mother-in-law was tremendously jealous of me and she hated me so badly because I married her only child. And this made my life worse than hell. And I spent next 17 years in the longest, darkest, as the darkest years of my life. In these last few years, I have faced immense mental, physical, sexual trauma, and which is beyond words. But I would just summarize my thing still. As a married woman, it is only acceptable if you return dead from your in-laws' house. With this mentality, even I come from this family with this mentality, so even my parents didn't support me. And when I got pregnant, I was left on the road, literally, by my in-laws, and nobody bothered to check on me. Even my parents, they closed their doors on me, and my in-laws too. I survived majority of my pregnancy living on roadsides, temples, and railway stations. I was hungry in those days when women are literally, taken care of so much. I was depressed and there was nobody by my side. Still, I didn't even think of going for police help or legal help because I was told your family matters should not go out. Nobody should know. So I just did what any other woman in my situation would have done from my background. I just kept crying and I kept requesting my husband to do something. This happened years after years, and nothing changed basically. My husband never wanted to be bothered basically, and nothing changed even after I gave birth to my child. When my child was born and he was 15 days old, my in-laws, they took possession of my son, and I was not allowed to see him for maybe a month or so. Now, any woman who has experienced motherhood would understand what I am talking here. I was feeling so helpless that I literally gathered all my strength and I went to women crime cell that time and I pleaded them. The response I got was, hey, don't make big things, don't spoil your home, adjust, go home, don't make a big fuss out of it. And this is not that I didn't adjust, I tried hardest, but didn't help anything. So eventually I called a PCR, I went to a PCR van which was standing just 1 kilometer away from my house, from my in-laws' house. I told them that this is the case, I am going to get my son, please see if whatever happens, you'll be responsible. I'm going there, I want my child. They said, okay, if anything happens, you dial 100. I thought, okay. I I went there. Somehow, I just knocking at the door. I just sat there for hours and hours. Eventually, I got my child somehow. I had zero money that time, zero support from anyone, but I decided to live separately and take care of my child. I found a job, but I soon realized how hard everything is without a man by your side. Renting a house, where's your husband? Getting admission for your child in school, what's the father's name? Where's father? We want to interview father as well. Aadhaar card, father. Voter card, father. All the school documents, father is needed. Every place, there's no place where I can go and somebody can understand that, okay, I'm a single parent and father is not there. It's so embarrassing to tell that father doesn't even care. In this society, which is so judgmental, that even if as a single woman I'm putting a light lip color on my lip, they will call me names, they will assassinate my character, and they will declare that I'm just left by my husband because something that I would have done. This is the society I'm living in. Fast forward to 2015, an NGO, which is a well-renowned one, they filed a domestic violence case and maintenance and divorce cases on my behalf. I was very hopeful that something will move. But when I went and saw the reality of courts here, it was all for nothing. I saw there were judges who were sitting there, and there was a assistant to the judge. I don't know. I don't have that legal terminologies, but there was a person who used to give files to the judges. He used to take money directly from everyone, and the judges used to, ignore that something like that is even happening in the court. There were some male lawyers who wanted to explain the meaning of marriage consummation to me. Like, what does it mean? It was so humiliating at every step. I waited for years to get any result from the court. I was told sometimes that your case is going to be fast tracked or something, but it was only a fancy word that I heard. Nothing happened. Finally, when COVID hit in 2020 and courts stopped, everything stopped. Even my work stopped. I had no money. I was very desperate. I again reached out to the women crime cell. This time I knew the legal things somewhat. I bought my papers, everything, all the documentation. I told this is the thing. They said, no, doesn't matter. You go to your husband's house, and if anything happens, dial 100. Since I've been listening to this dial 100 since very long, I actually dialed 100 that day. But to my surprise, the police came. They had a discussion with my in-laws in separate. They came out and threatened me, and later I came to know that they filed a case against me, and they threw my stuff out on the road once more at the midnight. That was the worst feeling. I don't know if I'm able to tell what I felt, but yeah. Now, recently, I will tell you, last year in 2023, I wanted to get the passport created for my son, and I knew that the laws permit a single parent to obtain the document for a minor without the husband's name or mother's name, like single parents can file it. But still, I was made to sit and wait, and then even though I explained, I showed all the papers, everything, they said, no, you have to fill the form, otherwise it will be very problematic. So this stigma that is there in the society that doesn't even listen to the laws that are already passed, it just reminds you at every step that you're nothing without a man. I'm not an expert in law or something, but from my standpoint, I can tell you where it hurts the most, and I have a few suggestions that I have penned down. If possible, I would like all of you to please just give them a thought. My first suggestion is, like, when we are in school, please create awareness about our basic human rights, which nobody talks about at all. Nobody tells us that just somebody was talking about marital rape. I didn't know what was happening with me was marital rape. I also would want to suggest that any people who are working with such delicate area like women crime cell or special police or something, they should have some proper psychological assessment to understand whether these people have empathy or not, even to understand what a woman has gone through and why she has come to you. That's it from my end. Thank you so much.
Well, thank you, Anjali. I think it's very sad hearing to hear the extent, the troubles you have gone through and the personal suffering you have had to endure. And yeah. So, as you highlighted that in our families, girls are taught to keep quiet and to suffer in silence. And as long as this attitude continues among families, I think we cannot find solutions to the problem of domestic violence. In questions of marital rape also, I think the women come under family pressures not to complain, not to take up the matter. And if a person with your education, with your background had to suffer so much, we can only imagine the plight of those who are less fortunate. So now I give the floor to Dr. Kiran Grewal.
Okay, thank you. It's a bit hard to come straight after such a moving story, and I'll try and keep my comments brief so that we have time for Professor Shirley as well. So I think actually some of the things I want to say follow on quite nicely from what Sapna was talking about. So, I mean, I come at this from the point of view of someone who's spent the last 20 years working at the level of international law in relation to women's rights. And one of my biggest frustrations is the seeming standoff that we constantly see reproduced between gender, sexuality, rights on one side, and culture on the other. And it seems this sort of impasse that we've never quite been able to get through. And so for me, when Shrita approached me about this idea of something regional, I thought that this was an exciting thought experiment. I think Sapna's identified some really important questions about the practicalities of what that would actually look like. But I'm going to focus more on, I think those are really important questions that we need to address. I'm going to focus more on why I think it might be useful to think at the regional level when it comes to women's rights, what I see some of the challenges being, what I think are potentially positive conditions currently that might promote this, and then a couple of recommendations I would have as we think about what this might look like institutionally. So, I mean, I think the first thing, and this really goes to what many of the people who've spoken already have talked about, is the importance of actually getting to the root cause of violations. And this has been a trend within the human rights field over the last 10 to 15 years that we've really moved towards saying, you know, we did the sort of standard setting, we did the kind of the ideals, and now we need, you know, and then we did the kind of legal implementation, and now we need to think really about what are the social, economic, political, cultural dimensions that create the possibility for violations. And that can't happen at an abstract level. That has to be rooted in local contexts, as Sapna was talking about, and in local cultural, economic, social, political settings. The other thing that I think is really important is, again, as somebody who comes from an Indian background, has lived my life in the West, has worked within sort of international institutions, I feel very strongly about the importance of us articulating an anti-imperial human rights and an anti-imperial feminism. I'm sick and tired of women's rights being used as a way of shoring up a global political order that puts some countries as supposedly more civilized, enlightened, and therefore entitled to intervene in others. I mean, we only have to look at the example of the very justification for the war in Afghanistan to see how we can mobilize this language of women's rights to justify military intervention. What have we created for the women of Afghanistan? I think we only need to look at what's happening in Afghanistan now to have an answer to that. So I think it's very important that we find a way to hold on to some sort of anti-imperial message when we're talking about women's rights. I also think that's important for recognizing the very important contributions that have been made by women's rights activists across the global South to theoretically understanding the violations that women experience and to theoretically understanding what women's rights might look like. The contribution they've made politically to promoting particular causes and practically to actually developing strategies for addressing the violations that women experience. So I think, one of the big criticisms that we have seen over and over again of the global feminist movement is the tendency to see feminism as a white women's project emerging from New York or Geneva and, London, and that this is then passed on to all of the oppressed women of the rest of the world. And, certainly growing up as an Indian woman living in the West, being told, oh, it's so great that, you got lucky that you got feminism. My family's Punjabi. Everyone was terrified of my grandmother and my great-grandmother. Feminism wasn't something that I needed white women to teach me. It came from my own cultural heritage as well. And so that's where I also think that we are at a moment in time where we can really shift our understanding away from a kind of universalist idea of rights towards what some decolonial scholars are calling a pluriversal idea of rights. And in that, it's to say that culture is not determinative of our lives. It's not fixed and always the same. It's also not irrelevant. We are products of the culture that we come from. The way I experience the world is a product of the cultures that I have been brought up in, both, migrant cultures, home cultures, all of these things inform the way I see the world. And that's true of all of us. And at the same time, we also need to recognize that culture is not automatically a barrier to rights. And that's an important shift away from setting up this idea, and Sally Engel-Mary, who Sapna mentioned, talks about this in relation to the CEDAW committee, that unfortunately in international law, we've seen quite often that culture, often marked as cultures that are non-Western, are seen as obstacles to be overcome to introduce rights. So how do we escape from that? Well, one of the ways we do that is by escaping what the Indian feminist Uma Narayan calls death by culture. And what she talks about there is the ways in which once we identify a problem as cultural, then no other explanation is necessary. It's the culture. So what she says is what gets lost in that is that all acts that are named cultural also have political dimensions, have economic dimensions, have social dimensions. There are actors in this. There are agents. When Anjali is talking about what she experienced, her mother-in-law is an agent in this. Her husband is an agent. These are not just figures of a culture. And so actually by unpacking the claims to culture and identifying who are the people involved and what are their political, economic, social interests, we actually complicate the idea of what culture is. That can't be done, again, from far away. That has to be done within the context. And it has to be about recognizing plural ideas of what the culture is. What Punjabi culture is not just what a patriarch in a village says it is. It's also not what I say it is. It's a combination of many different factors. And we need to keep that space open for those conflicting ideas of culture to be discussed and explored. So what are the challenges that I see? Well, I think one of the challenges that we see, of course, is that it's not just societal attitudes, it's also institutional attitudes. So there's a wonderful article by a Turkish scholar called Dicle Koyacalı. It took me a long time to learn her name. But she did a study of how Turkish judges and lawyers treated cases which involved honor killings, which are predominantly within the family, obviously the victim is usually a female and the perpetrator usually a male. And she contrasted that with the way that the same judges and the same lawyers treated blood feuds, which is another gendered practice in Turkey, usually across families where the victim is predominantly a male. And what she found was the very same judges and lawyers, when they were talking about honor killings, they'd say, it's this tradition problem, how to change people. It's always been that way. When it came to blood feuds, they would say, this is a barbaric practice. We up the sentence for this. If there's a suggestion of a blood feud, we have to crack down on this. So this is where changing institutional attitudes of acceptance of certain things becomes important as well. The other question that I would have would be, and this is where I'm not convinced that any proposal put forward should assert any one country in the region's dominance in it. I think for it to be a regional mechanism, it can't be a mechanism whereby one country is seen as leading on it. I think it will undermine the buy-in of all the other countries, and I think it will end up being used in a way that women are often used as promoting particular national projects, political projects, rather than actually centering the rights of women. And so what do I think are the positive conditions? Well, one of the things that really surprised me was at the BRICS conference summit just last week, there was a statement about Afghanistan and the importance of respecting women and girls' right to education. Now, that to me seems like a positive step, that actually BRICS nations are seeing themselves as having something to say on a global stage about the issue of women's rights. And I think it is heard differently when it comes from BRICS countries than when it's coming from New York. So I think that is positive. I think that there is also a very strong regional network of women's rights organizations that have been active since at least the 70s, if not earlier, that can really be mobilized and would be very supportive of an initiative like this. And they have done a lot of that work of bringing together what interests are. What are the issues affecting Pakistani women, Bangladeshi women, Sri Lankan women, Indian women? So I think if we draw on those strong regional networks, I think that's a real positive. The final thing, and I also just wanted to make a little plug for, I'm currently living in Sri Lanka. Sri Lanka is the country that I spend most of my time in terms of research. One of the really positive outcomes of the recent presidential elections was we saw a massive increase in women's participation. There were rallies of thousands of women coming out to vote. And for the first time in recent years in Sri Lankan politics, women's issues, things like period poverty, things like domestic violence, things like working conditions for women in garment factories, have actually made it onto the agenda where major political parties feel they need to talk about this. So I think this is a moment where there is hope. The recommendations, just to finish up very quickly, is I think it would be really important to get full regional buy-in. And so this has to be something that is seen as a regional initiative and not something that is driven, even if India is the regional hegemon, I don't think it can be seen as an Indian initiative. I think it will undermine it. I think this is a time to think regionally. I think that civil society has to be a big part of this because they have that experience of working regionally and bringing the issues together. And I think I'm questioning whether or not it needs to limit its scope to thinking only about violence against women, because what we have learned through the women's movement is that actually the women's rights are a continuum. And if we ensure things like economic participation, education, political participation, that the violence issue is more easily addressed. So I would encourage that we think more broadly than just violence.
Well, thank you, Dr. Kiran Grewal, for that presentation and for highlighting some very important issues and cooperation and the need to change the thinking in society and especially the attitude towards women. Now, we come to a very important part of our session, that is the keynote address by Professor Shirley Scott. She is a professor at the University of New South Wales in Canberra, and the topic on which she will speak is the 4 stages in geopolitical evolution of the multilateral treaty since World War II. And I think this reference to World War II is very significant because this is when the United Nations was established in 1945. And when the UN was established, around 750 million people around the world were still living under colonial domination, including India, which was one of the founding members of the United Nations in 1945. So gradually, these countries which were under colonial rule attained independence. They joined the United Nations, and then they had an opportunity to participate in the international treaty making, in the international lawmaking, which until then was the exclusive domain of the colonial powers. So we see how Professor Shirley Scott will tell us about whether, after all these years, the developing countries, in particular the newly independent countries, have really achieved the objective of playing an effective role in international treaty making. Thank you.
Well, good afternoon, everyone. It's a real privilege to be here for this conference. Thank you, Ambassador Singh, both for your kind words of introduction and also for the opportunity to be here. I leapt at the opportunity because I've been here twice before. Some of you may remember that the Indian Society hosted a conference of the Asian Society of International Law, and I attended that. And before that, I came to Delhi on behalf of the Asian Society to discuss the program. So I've got very fond memories of that whole experience. And as I say, I'm just delighted to be back. There is a little bit of a change of pace, I guess, or different type of topic here. So I might say just a couple of words of introduction to set the scene of how this paper fits into my research. So as you've heard, the core of my research is for us to understand the political operation of international law. I mean, up to a point, we all know and are all conscious of the fact all the time that international law is operating in a political context. But a lot of my work has been about trying to explain exactly how the two relate and also to theorise how it operates. So some of you may know I have a textbook that seeks to set that out for students, and that has been a lot of my sort of professional journey, has been integrating that into my teaching and learning from my students, and I'm currently working on the 4th edition of that. And so I was particularly pleased also to be here in Delhi so that I could get some sense of an Indian perspective that I could incorporate, also infuse into the next edition. But I'm also working on a monograph on my theory of international law as ideology. This I developed actually when I was doing my PhD, or I started, and I published it soon after in the European Journal of International Law. And really it's been a considerable part of my professional journey as well, because I created the theory really at a sort of framework level. And then during a lot of my career, what I've done is I've filled in the middle, if you know what I mean, a bit like I just had the branches of the tree, and now I've been putting all the leaves on and make it a much thicker theory and looking at more aspects of, a whole lot of different aspects of the political operation of international law. So today I'm just going to try out one little section of ideas that will be in that book, and it's related to the evolution of the multilateral treaty since World War II. So what's become clearer as I've worked on this theory is that its sort of period of relevance is that of US predominance, which I date in international law from 1918 actually, but it was a gradual climb up and then more obvious after 1945. And so I divide the period into 1918 to 1945, then the 1945 to the 1970s and decolonisation, then the 70s to the end of the Cold War, and then a sort of long post-Cold War decade to 2001 or /3, and then 2003 till about 2022. So it's been fascinating as I look at different characteristics and aspects of the operation of international law to see how actually, as there have been these geopolitical shifts, so that's reflected in what's happening in international law. And one of the things I'm doing in this book, in the section on multilateral treaties, is I find that when I apply my theory, I come up with one particular type of treaty that's characteristic of each of these subdivisions, if you like, of time. So particularly that 1945 to the 70s, so that post-World War II period, then the period after decolonisation and to the end of the Cold War, what I'm referring to as the long post-Cold War decade, and then what's happened this century. It's not that every treaty, and I'm talking about multilateral treaties that aim for global participation, it's not that every treaty concluded in each period necessarily fits this categorisation, and there is some overlap between types. But I have found it really interesting to see how these shifts have taken place. So let me explain what I'm talking about when I'm talking about categorising multilateral treaties. We categorise them all the time, most often by subject matter. So we talk about human rights treaties, trade treaties, and so on. I'm actually categorising them in terms of the relationship of the treaty text to the existing set of power relations in that issue area. I'll say that once more. I know it's late in the afternoon, but I'm categorising treaties in terms of the relationship of the treaty text to the existing set of power relations in that issue area. To give you a sense of where I'm heading, because I'm going to just quickly give you an overview of these types of treaties. From 1945 to the 70s, so that first period after World War II, we saw some really significant status quo treaties. Then from 1970s on, after decolonisation, treaties that I refer to as revisionist treaties, or certainly attempts at revisionist treaties. After the post-Cold War, we have what I regard as overstretched treaties, and I'll explain what I mean by it. And then this century, we're getting the phenomenon of destabilising treaties. So let me take you on that journey. First of all, how do I do the analysis to identify these different types of treaties? So here, try and take it in, because the rest will build on this, and I'll just try and give you a flavour so you don't have to take it all in. But first of all, I start off with this unit of analysis, a heuristic unit of analysis of international cooperation. And I say the key elements are, first of all, a political issue to be addressed in that process of cooperation. Secondly, the solution, how that issue is going to be addressed. And the third key element is the foundation ideology, as my term, obviously. And by that I mean the principles that provide the logical premise or reason as to why that's the best solution for addressing the issue. Typically, during the US era in international law, once we got an issue, ideology, solution nexus agreed, implicitly, because obviously that language wasn't necessarily being used, it was instantiated into a multilateral treaty, though not all the elements to the same extent. So the issue is sometimes alluded to in the title, but not always. The solution, how we're going to deal with that issue, is typically in one or two of the early substantive provisions of the treaty. And the foundation ideology, those principles that logically underpin why that's the best solution, are alluded to in the preamble. So let me give you an example, and I think it's perhaps one of the sort of clearest examples, and that's the NPT. The issue is who is going to manage the nuclear threat and how. The foundation ideology, those principles on which the solution was premised, was non-proliferation. The further horizontal spread of nuclear weapons would increase security dangers. And the solution, as you probably know by Articles 1 and 2, was in essence that those with nuclear weapons wouldn't share them with non-nuclear weapon states, and that non-nuclear weapon states would not acquire nuclear weapons. There was a really tight logical nexus with this, because if you apply the principle of non-proliferation to the issue of who's going to control nuclear weapons, then you can see how you can end up with that as a solution. Being such a tight logical nexus means then that there's a very robust structure, and in this case, the solution, that of that two-tiered structure in the NPT, defined a power structure that actually reinforced the existing distribution of power in relation to nuclear weapons. We had the states with nuclear weapons and those without. And by having that solution that nuclear weapon states wouldn't share them and non-nuclear weapon states wouldn't acquire them, in essence, then you can see that the treaty reinforced what was already the status quo in the issue area. The UN Charter is another example of a status quo treaty that reflected the existing distribution of power and, of course, is often critiqued now for having done so. GATT was, although the analysis is a little bit more complicated to do, and I've done the same sort of analysis with a whole suite of treaties. Of course, I should perhaps, being here in India, make mention of India and the NPT, that the treaty did not even leave open the possibility that an additional state would acquire nuclear weapons and be a legitimate nuclear weapon state for the purpose of the NPT. So again, you can see how the intention was to make it very much a status quo treaty. And these status quo treaties also tended to prioritise order over justice. So we can see how it's not equitable to have that solution, but actually, as I say, it did reinforce the status quo. According to the theory, if the foundation ideology comes to be seen as simply a mere ideology, a sort of political idea, then as opposed to a truth in some way, then that would undermine that system of power relations. So that's that first period of the multilateral treaty where we got these really important, in terms of the international legal order, foundational treaties. But after decolonisation in the 1970s, we had a different set of sort of normative propositions and some of them actual treaty proposals. This was the time when we had the attempt at the new international economic order, for example. The 1982 Law of the Sea Convention contained certain revisionist elements. But I would say that the quintessential example of a revisionist treaty was the UNFCCC dealing with climate change. And let me explain what I mean using the same terms just briefly. The issue being addressed by the UNFCCC and the regime that was built on that was essentially who was going to take responsibility and how for the issue of mitigation, bearing in mind that that issue is in essence an economic issue. The principle of common but differentiated responsibilities, as originally incorporated into the UNFCCC, stipulated that developed countries should take the lead in mitigating climate change. And this was operationalised via the Kyoto Protocol that placed obligations on economically advanced and not on developing states. But the solution meant that the cost to developed countries would continue to grow as the economies of major developing economies grew. And as we know, those developed economies led by the United States were not keen on that situation. So it was an attempt at a revisionist treaty, but actually it was one that in practice was then rejected by some in the North. But if you compare that with the NPT, both the NPT and the UNFCCC had differentiated solutions, one that would serve to reinforce the existing distribution of power, and the second one that sought to revise it. So let's now move on to the post-Cold War decade. And here we have a period where there's the phenomenon of what I'm referring to as overstretched treaties. And by that I mean that they went beyond, the text of the treaty went beyond what the major powers of the day would accept. Often the United States, well, we'd already have a sort of foretaste of that, but also other states as well, major powers. For example, the Ottawa Landmines Convention banned landmines, and this appeared to be a new era in which civil society could further develop international law, even when the United States was not keen on it. Mind you, it wasn't only the United States, it was Russia and China and so on. But it was seen as quite a euphoric moment for many in civil society because they said, oh, here we go, we're creating international law. But if the major powers don't necessarily agree with those provisions, it can serve to, well, first of all, civil society thought it could be used to critique those states' policies and bring them sort of into line, which might be true up to a point, but it also doesn't necessarily help international law if it's seen as not supported by the most powerful. I'd say the quintessential example, however, of these overstretched treaties at that time was the Rome Statute of the International Criminal Court. Courts tend to be established on the basis of the foundation ideology of a rule of law, that law should treat all states the same. But arguably, and this may be controversial, I don't know, but arguably the Rome Statute went too far towards a rule of law or / a strong court, or one without the mechanisms built into the design to respect the fact that international law ultimately operates in a political context. Compare, for example, the PCIJ and the ICJ. These emerged from the ideal of a politically neutral court, but as they were actually created, they also provided for the reality of power politics through such provisions as the system of judges ad hoc, of optional compulsory jurisdiction, of judgments to be legally binding, but in actual fact the enforcement mechanism to be a political body. It struck something of a compromise, but the International Criminal Court could exercise jurisdiction over alleged perpetrators of crimes on the territory of a state party, irrespective of the nationality of the accused. And the Security Council didn't remain the gatekeeper for cases coming to the court, as the US had hoped. Ironically, this meant that the operation of the court risked illuminating exactly what can weaken a regime, that is, that the foundation ideology is not really true. And in this case, that law, the politics of law is becoming more evident through how the court is functioning and different scenarios it's having to deal with, and risk doing harm to international law at a systemic level. These are just a flavour, a snapshot of them. So I'll go on to the last stage and the last type of treaty I've identified when I applied this framework, and that is the ones of this century. And this century I see what the phenomenon of destabilising on subversive multilateral treaties and normative propositions. So here I'm referring to normative initiatives such as responsibility to protect, or whole new treaty propositions such as China and Russia's proposed treaty on the non-weaponization of outer space that have the logical potential to undermine those status quo treaties of the immediate post-World War II period. R2P was often presented as redressing outdated notions of sovereignty, but an analysis through this framework that I've done and published illuminated that the threat it posed to the prohibition of first use of force in the UN Charter. What I'm taking as the sort of quintessential example of these destabilising treaties is the 2017 Treaty on the Prohibition of Nuclear Weapons, which entered into force in 2021. India isn't a party and neither is Australia. This is founded on the ideology of the elimination of nuclear weapons. And the principle here is that the most complete form of disarmament, elimination, is understood to be the only way to protect, or is the only way to protect against the far-reaching risks posed by the continued existence of nuclear weapons. According to the ideology of elimination, the risks include those to traditional security, to human survival, the environment, socio-economic development, the global economy, food security, and to the health of current and future generations, and in particular women and girls. It's quite a long ideology. Defined in this way, it excludes the possibility of non-proliferation being useful. Right? The only thing that's useful is complete elimination. The solution is contained in Articles 1 and 4 to prohibit the development, production, stockpiling, transfer and use of nuclear weapons and other nuclear explosive devices, and to provide for a verified, time-bound and irreversible process by which nuclear weapon states would eliminate their nuclear weapons programs would, if agreed to by the nuclear weapon states, supersede their obligations under the NPT due to Article 18 of the treaty. It can be easy for international lawyers, particularly within the P5 countries to dismiss the significance of this treaty on the basis that nuclear weapon states aren't likely to join. But it still has considerable potential to undermine acceptance of the ideology of non-proliferation. The ideology of elimination is being promoted domestically and internationally The ideology of elimination is being promoted domestically in certain countries in what could be seen as a process of subversion. In other words, getting civil society on board, and we can all think it would be great to have a world without nuclear weapons. And so getting civil society on board with this ideal of that underpins the treaty, and therefore, from their point of view, hopefully putting pressure on the government. The TPNW defines a flatter power structure than the NPT because it's about all stakes being equal because you've eliminated nuclear weapons. But as I say, it may never actually happen in that if the P5 don't join. So the risk is less that the TPNW will actually replace the NPT as one of the core status quo treaties, but rather that it will have a destabilising impact. Supporters have presented the TPNW as compatible with the NPT. So the multilateral treaty landscape becomes ever more complex. So there's a need for us to be able to undertake these analyses to see actually what impact the newly proposed treaties will have on existing treaties. It may be that it's a good idea to supersede treaties, but most of the literature on regime interaction looks at the legal interaction of treaty regimes rather than what they'll mean for existing political structures. I hope that wasn't too heavy for this time of the afternoon. We're actually seeing, I think, quite a number of these destabilising treaties. I haven't done the analysis of all of them, but it's possible that several of the treaties that are actually being stabilised would, when undertaken in this framework, actually be understood as having the potential to actually undermine a lot of the rules-based international order. Thank you, and I'll leave it there.
Well, thank you, Professor Shirley Scott, and my apologies for stopping your flow at a time when we were really enjoying the presentation, but we were told that we have to vacate the room because there's another program which is scheduled to be held here. But thank you very much for your wonderful analysis, and maybe we can have just one quick question. Jaraj, would you like to ask something? Now we are being actually pushed out of the room. We have been
Sir,
threatened that the
now
lights
I
will
would
be
like
turned
to
off.
invite Professor Jairaj to facilitate the chairpersons for this event.
So I thank all the panelists for their presentations and their views, and I would just like to reiterate my view that the Indian law does not allow marital rape. That is my interpretation. And we can discuss it maybe separately if you want. And also I thank Professor Shirley Scott.
Professor Shirley Scott.
Indian Society of International Law, and we are very pleased to have you here, madam. Thanks for visiting the society.
My pleasure.